did the state complete the redactions on those two exhibits? Okay. Are you all ready?
Yes, Your Honor.
Okay. All right, let's bring in the jury. Thank you. All right, welcome back, members of the jury. Everyone may be seated. Good morning to you all. All right, so to remind you all where we were, the state of Florida concluded their case yesterday. We stayed a little bit after to work, and so now I turn to the defense. Mr. Dreiser, do you choose to open a case?
Yes, Your Honor. Good morning.
Good morning.
The defense would call Petra Obitzberger.
Okay. Outside, all the way?
I was
one of
told
the
that she's
rooms.
in the side room.
Okay. Good morning. If you please raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, right over here, make sure that you watch your step. Here's the slight incline. All right. Mr. Dreiser, you may proceed.
Good morning.
Morning.
Would you please introduce yourself to the jury?
I'm Petra Obritzberger.
Okay. And would you tell them where you work?
I work at the Discovery School in Jacksonville Beach.
Okay. And when did you start at the Discovery School?
I started on July 1st in 2021.
Okay. Who was the first couple to introduce themselves to you at the Discovery School?
It was Shanna and Mario.
So you did have an opportunity to meet them?
Yes.
And that was at the Discovery School?
Yes.
Fair to say that the Bridegan children were enrolled from the time that you started until the fall of 2022 when they moved to Washington State?
Yes.
Okay. And while you were there, did you learn that their father was murdered?
Yes.
Okay. And who let you know that?
I can't remember who let me know that. I don't recall that.
Okay. But somehow you were
that he was murdered. Shanna let us know of the passing.
Okay.
But
Miss Gardner.
yes, Miss Gardner. but we were not informed that he was murdered.
And before you were informed of the fact that Mr. Bridegan had passed, and all the media and all the things that happened at the school, did you know that they were getting divorced?
Shanna shared with the school, with teachers and myself personally before the murder, that Mario was moving out.
Okay. And is that something that the Discovery School encourages parents to share so that you guys, will you tell me, is that something they encourage parents
Yes.
to share?
Yes, any change in the family, any change in the home is encouraged to share, yes.
And can you just say why that would be something you would want to know?
To understand, the children's situation, and if anything changes in their behavior, we are aware of it, and we really, really want a parent partnership. And that's why we want parents to let us know if there is a change in the home.
And when you were informed of this information, did they tell you that they were separating right away, or were they delaying the separation process?
So before the murder, Shanna said that they are separating and Mario is moving out during spring break. But after the murder, Shanna let us know that because the children have just lost their father, that is delayed and is not going to happen until the summer.
Okay. And what were your observations of Mr. Fernandez and Miss Gardner from the time that you could observe them while you were at the Discovery School and they were parents at the Discovery School?
They were caring parents. They were friendly. They lived right next to the school. When they came over for Carline, it was greeting, again, friendliness, appropriate parent communication.
Do you ever think there was anything unusual about them?
No,
Okay. And did you ever get an opportunity to meet Jared Bridegan?
I did not.
I have no further questions.
All right, thank you. Cross-examination.
Good morning, Ms. Orbitsberger.
Good morning.
So the Discovery School, that is directly behind Mr. Fernandez and Ms. Gardner's home, correct?
Correct.
And in the Discovery School, your property takes up that whole corner of 15th and Shetter Avenue, correct?
Correct.
Behind the school, is there a gravel parking lot?
Yes, towards the retirement home.
Okay. I want to ask you about, you mentioned that you were advised by Ms. Gardner that Jared Bridegan had passed, but she did not tell you he had been murdered.
Correct. We received an email the night of, from Thursday to Friday, that let us know that the children's father had passed and they wouldn't come to school.
Okay, and she used the word passed. She didn't
Correct.
mention that it was a
Correct.
criminal investigation.
It was passed, yes.
And I'm sure that a lot of people at the school were talking about the case. At some point, did the media release a photograph of a vehicle of interest that you're aware of?
I can't recall that.
You mentioned that you were advised that Mr. Fernandez and Ms. Gardner would be separating. Are you aware that they are still legally married today?
No, but I hadn't looked into that either.
Thank you. Your Honor, I have no further questions for the witness.
All right, thank you. Any follow-up?
On a Wednesday night at 7 o'clock, any particular Wednesday night,
Okay.
not necessarily the night of the homicide, if something suspicious was going on, do people report information to the school if they think that something is suspicious or the children could be in danger or anything?
Often,
That happens often?
parents are, they care for their children. So every time they see suspicious activity, they have reported it to the school, they have reported it to police. I'm not saying always.
Does the community seem to care about the safety of the children of the Discovery School?
Absolutely.
Do you believe that the Jacks Beach community, especially the folks living around the Discovery School, care about the Discovery School?
Absolutely.
Okay, so my last question is, do you have any recollection of anybody reporting any suspicious activity or trucks parked at the Discovery School the evening of the homicide?
No, nobody reported anything.
No further questions, Your Honor.
Anything further for this witness? Okay, may she be excused?
Yes.
All right, thank you so much.
Thank you.
Call your next witness.
Lauren Meredith.
Lauren Meredith, please. All right, good morning. If you could walk all the way forward, please. All right, please raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, when you get near the witness stand, just watch your step. There's a slight incline, all right? Make yourself comfortable, pull yourself up to the microphone. Okay. You may proceed.
Good morning.
Good morning.
Would you please introduce yourself to the jury?
I'm Lauren Meredith.
And back in the years of prior to 2022 and 2022, where did you work?
I was a teacher at the Discovery School.
Okay, and what was your position at the time?
I was a lower elementary lead teacher,
Okay, and who were your students in 2022?
A, B, and LB.
Okay. Can you just tell the jury very briefly a little bit about the Montessori school, or excuse me, about the Discovery School?
The Discovery School has toddler through 8th grade. We're a small independent private school towards Jack's Beach.
Okay. And in 2021, 2022, you were LB and AB's teacher, or at least a co-teacher?
Yes.
Okay, were you familiar with the children?
Yes, very, very much so.
And at some point while the children were enrolled, did you ever get an opportunity to meet Jared Bridegan?
I did.
Okay, and how would you characterize your interactions with Mr. Bridegan?
It was open house, which is typically intended to be a very exciting time. So it was a little bit surprising, my interaction with him. He was a little bit almost condescending. I didn't have a lot of context for the situation at the time, so I was surprised.
Okay. Did he appear to love that the children were enrolled at that school?
He didn't. He asked what was so special about the Discovery School. It just kind of came off as a negative undertone.
Okay. Did you have any interactions with Kirsten Bridegan?
I did.
Okay. And pleasant interactions?
Always.
At some point in time, excuse me, may I have a moment, Your Honor? Sorry about that. Prior to the homicide of Jared Bridegan, were you informed that Ms. Gardner and Mr. Fernandez were separating?
Yes, they had come back from a Hawaii trip and let us know that they were planning to separate.
Okay, and is that something that's unusual that parents would tell you that?
No.
Okay, would you expect and want to know that information?
Yes, it impacts the children and their well-being, how they experience school.
Okay. After the homicide, do you believe that because of the media attention, LB and AB were affected?
Yes, because of the proximity to their home, they really couldn't escape it.
What measures did the school have to take to protect the children?
We blocked certain search terms on the computers. We made sure that the students knew that we were available to them. We brought in a grief counselor. Eventually, we ended up putting up fences around the outside to protect against media and unwanted attention.
And was there interactions with Kirsten Bridegan? Did she contact you, or did you have to contact her, excuse me, regarding some information that you became aware of? Can you tell the jury about that?
Yeah, there was a Justice for Jared Instagram page. It was pretty vocal about wanting to make sure that Jared wasn't forgotten and that the case didn't go cold. And at times there could be some pretty inflammatory comments on there. At one point I saw
Without telling us what was on there, because that would be hearsay.
Okay.
You felt that there were inflammatory comments? Mm-hmm. Okay, and did you want...
She's saying, Could you clarify, yes or no?
Were there inflammatory comments on there?
Yes.
Okay, and did that cause you to reach out to Ms. Bridegan?
Yes.
Okay, and did you want her to tone it down for the children?
I asked her to remove a post, and she did.
Do you believe that the children were happy at the Discovery School prior to the homicide?
They were very happy.
Any reason to believe that they would be disenrolled in that school?
No.
Would Mr. Fernandez participate in activities for the children? And we'll tell the jury how Mr. Fernandez would participate at the school with the children.
He was present for most events. He also came to pick up the children. He was there for parent-teacher conferences, things like that.
Okay. And prior to knowing that Miss Gardner and Mr. Fernandez were going to be divorcing, did you learn that they were in couples counseling?
Yes.
Can you describe Miss Gardner and the children on their last day of school when you learned that they were disenrolling and moving to Washington State?
They were sobbing. They were really sad to leave. They had made a lot of friends, and this was their home community, so they were sad.
Did Mr. Fernandez and Miss Gardner have a memorial service for Jared Bridegan?
They did.
Did you attend that?
I did. It was mostly put on by the children, and so it was really a show of community for them, an opportunity for them to say goodbye to their father.
Okay. Did you feel it was a nice service?
It was. The children read letters to their dad. We went out and released flowers into the ocean, came back, had kind of a little interaction where kids played together, and it was just very pleasant.
Okay. I have no further questions. Thank you.
Ross? Thank you.
Is it fair to say, Ms. Meredith, that what you just shared with us is your opinion?
Yes?
Is it fair to say that your opinion is not necessarily based on all the facts?
Yes?
Were you aware of the fact that Mr. Bridegan lived a significant distance from your school?
At the time of open house, no, I wasn't. All we had been made aware of was that they had been divorced and that they didn't really get along.
And Ms. Gardner made you aware of that?
Yes?
Ms. Gardner told you that they had child custody issues, correct?
Yes?
And that they were significant, correct?
Yes?
You weren't aware of any discussions in this family about the fact that the school was private/expensive, correct?
Correct.
And that Mr. Bridegan was living 40 miles away, correct? In many cases, you would like for the child to be close to both parents. Is that fair?
Of course. Yes, they can be more involved.
The opinion that you had that said that he was like condescending, he might have just had a real difficult drive on I-95 for the hour it would take to come up to see his children at their school.
For sure. As we got more context, it made sense more.
When you learn those additional facts.
Oh, yes.
Okay. And Mrs. Bridegan was always a pleasure.
Yes, she was right next to the school. She often brought cookies over for the teachers. She was very actively involved.
That's Mrs. Gardner.
Oh, I'm sorry. But yes, Miss Bridegan was also very pleasant. We only really exchanged words in car line, and it was always very pleasant.
It didn't take very long for Mr. Fernandez to have no part in these children's lives, correct?
Correct.
It was basically right after the murder, he was gone. Fair?
Yeah, as soon as they started to separate, he no longer did anything with the children.
Anything.
Anything.
And it wasn't long after that Shanna Gardner pulled her children out of school and moved them to Washington.
Yes.
The night, February 16th, you saw a post.
Yes.
And within that post, who did you see?
Shanna Gardner and AB doing gymnastics at home.
And is it like an Instagram type deal?
Like a Facebook story, so would be up for 24 hours. They had several posts about, they did that all the time. They were working on new skills. AB would come in and show her new skills. She was very proud of her gymnastics.
So this would have been shortly after they were dropped off from their date night with their father.
Yes,
And did you see Mario Fernandez in that video?
I did not.
That's all the questions I have, Your Honor.
Mr. Dreiser?
Do I understand that you would see posts like that with Ms. Gardner and her daughter doing gymnastics often?
Yes,
Did you ever see Mr. Fernandez in those videos?
I did not.
No further questions.
Anything further for this witness from either side?
No, Your Honor.
All right, thank you very much. You're excused.
Defense rests, Your Honor.
All right, let me see the lawyers at sidebar, just without the court reporter. He needs a microphone.
Hold this, please. James, can you do it? My hands
All right, please raise your right hand, Mr. Fernandez.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, good morning.
Good morning, Your Honor.
All right, so your attorneys this morning called two witnesses to the witness, no. There's two. Yes, two witnesses to the witness stand. And at sidebar, they informed me that you did not wish to testify. Is that true?
Correct, Your Honor.
Okay, so this conversation between me and you, I am, like I said at the very beginning of these proceedings, I'm going to check in with you at critical stages to make sure, because even though your attorneys announced rest, that does not mean that the case cannot be reopened. The case can continue and certain things can happen. Do you understand that?
Yes, Your Honor.
All right. So before I confirm, at least in my mind, that you are deciding not to testify freely and voluntarily, I'm going to explain some things to you. At any point in time, generally speaking, it's rude to interrupt a judge, but I want you to interrupt me, okay? If you don't understand something that I say, or if you need time to talk to your lawyers, I will give you whatever time that you need to make sure that you are 100% understanding and in agreement. Do you understand that?
Yes, Your Honor.
Okay. So that's the foundation of our conversation with one another. So you can stop me, you can interrupt me, you can ask questions of me, or you can even ask questions of your attorney. You understand all of that?
Yes, Your Honor.
All right. So I'm going to start with the foundation of this entire proceeding, which is the state of Florida has brought these charges against you, and you are presumed innocent of those charges. Do you understand that?
Yes, Your Honor.
And there is only one party in this entire proceeding that has a burden of proof, and that is the state of Florida. Do you understand that?
Yes, Your Honor.
Now, your attorneys have indicated to me that you want to remain silent, which is 100% your right. Do you understand that?
Yes, Your Honor.
But in a criminal trial, you have choices. And the choice that has been made, even though you did, that is your attorneys call witnesses to the witness stand, that doesn't shift some type of burden to you. Do you understand that?
Yes, Your Honor.
So it's still on the state of Florida. But your testimony is something that you can choose to offer. That decision is yours. It's not your lawyer's. It's no one's except for yours. I can't pierce it. No one can pierce that right to remain silent. So your choice either to remain silent or to testify is fully yours. Do you understand that?
Yes, Your Honor.
Have you talked to your lawyers about whether you wanted to testify in this trial or not?
I have.
Okay. So those conversations, they're private, they're protected, but it's important that I explain to you whatever those conversations may be, and I don't need to know what they are, and I never would ask, which is you understand your decision-making in that process. That is, you can talk about it. They can tell you about their trial experience, which that is what you hired them for. They are very experienced lawyers. You understand that?
Yes, Your Honor.
So they can give you their advice, they can give you their guidance, they can answer all of your questions, but what they can't do is make the decision for you. Do you understand that?
Yes, Your Honor.
Do you know why that is?
Because ultimately it's up to me.
It is up to you. Why is it up to you?
I'm giving them my, I don't know how to explain it, but they're the ones that are more or less doing this for me for what I don't understand.
Right. So those are the questions, that's the consultation, but why is it solely up to you? It's because it's your life,
Yes, Your Honor.
okay? That's it. It's your life, it's your trial, and so that is, I think when I put it like that, it puts everything into focus. Does that make sense? Because they can't make those decisions because it's not their life. It's not their trial. They're working for you, but they aren't you. Do you understand that?
Yes, Your Honor.
All right. So I asked you if you had the time. Do you need more time to talk to them about your decision?
No, Your Honor.
Okay. So they've told me that you don't want to testify. Let me go on the flip side of that, which is if you testified, sometimes the decision to offer information to a jury to weigh just like any other witness, that is the instruction I would give if you were called to the witness stand. So did you look at the jury instructions at all?
Yes, Your Honor.
Okay, so there's one of the instructions called weighing the evidence. There are 5 factors given for any witness. Did they have the opportunity to see and know the things about which they testified? Were they honest and straightforward in answering the attorney's questions? Does their testimony agree with the other testimony and other evidence in the case? And then there are other factors in there, like do they have some interest in how the case should be decided? And one of the optional ones that happens if you testify is that I would tell the jury to treat you just like any other witnesses. Witnesses don't have burdens of proof. Witnesses, their credibility is weighed just like any other witness and any other evidence. They would weigh your testimony. Do you understand that? Without placing a burden on you. So in that, by not testifying, you're giving up the right to have the jury consider what information you would choose to give, and it doesn't have to be a formal defense. I know your lawyers filed some notice of alibi, but it doesn't have to be a formal defense. It could just be any information. Have you weighed that too?
Yes, Your Honor.
Okay. So, other witnesses, I think none of them have, except for that one proffer guy, the Mr. Ponder, who was in the jail. Do you remember him?
Yes, Your Honor.
Okay. Do you remember that Mr. Mizrahi was starting to ask him questions about his record? Do you remember that?
Yes, Your Honor.
So that is also a factor that I do not believe exists for him. Is that true? Okay, so he doesn't have any impeachables. That's what we would call that. Remember, Mr. Mizrahi was like, oh, you got like however many felony convictions. You remember that? And your lawyer was talking about his convictions. Do you remember all that?
Yes, Your Honor.
Okay, that doesn't exist for you. So that could be a possible negative for not testifying. You would agree with me, right?
Yes, Your Honor.
But that doesn't exist for you. You understand that?
Yes, Your Honor.
Have you weighed that?
Yes, Your Honor.
Okay. So what are the foundational things I've just gone over with you? Which is you're presumed innocent, right?
Correct, Your Honor.
Do you have a burden of proof?
I don't, Your Honor.
Who makes the decision about whether you testify or not?
I do.
Have you made it?
Yes, Your Honor.
What is it?
I don't need to get on the chair, Your Honor.
Okay. So what does that mean?
I don't need to testify. I don't need to prove anything. Ultimately, the jury doesn't get to ask me questions, so.
I want to know what you want. Do you want to testify or not? Yes or no?
No, Your Honor.
Okay. Has anyone threatened you to get you to make this decision?
No, Your Honor.
Promised you anything?
No, Your Honor.
And you understand this whole process?
Yes, Your Honor.
And this is your decision and yours alone?
Yes, Your Honor.
All right. Thank you for answering my questions. I'll find that his waiver or his right to he wants to maintain his right to remain silent. The court finds that that's both freely, knowingly, and voluntarily entered. And so a couple more questions. The witnesses that your attorneys have presented, are you in agreement with them resting the case and not calling any further witnesses?
Yes, Your Honor. I'm in agreement.
Okay. Anything else from Mr. Dreiser at all?
I just want to clarify that when you asked him, do you remember Mr. Ponder, you were asking him from when he testified in court, not from the jail, correct?
What? Yeah, in court, when Mr. Mizrahi was asking him the questions.
I just want to make sure that's what you were asking. That's-
Yeah, no, like when he was asking him about
Sure.
his felony convictions
Understood.
in the jail. Like, not in the jail, but he was asking him about his convictions. You understand that, not whether you're associated with that person or not, whether you saw him come take the witness stand and have to answer questions about his criminal record. That's unlike any other witness that has ever testified in this case. I don't think anyone's been impeached with felony convictions except for maybe Mr. Biggerstaff, right? I think he has one.
He had one felony conviction.
Okay, so there are two, Mr. Biggerstaff and Mr. Ponder, Mr. Ponder stuck out in my mind because he had more, but.
A lot more.
All right, Mr. Dreiser. So that's what I'm trying to say. Do you understand, like, that was unusual in this particular case? All right. Thank you for clarifying. Anything else? All right. Thank you, Mr. Fernandez. All right, so where do we go from here?
Charge conference, Your Honor.
Charge conference, and if the state believes they could close this morning, I believe the defense and Mr. Mizrahi could close this afternoon. If that's not the case, we could just do the charge conference, take a lunch, Ms. Stifler can close, and we'll come back tomorrow. It's the court's preference, and the state's, collaboratively, whatever everyone wants to do.
Did y'all get the instructions? I need to know how long you think the conference would take.
15 minutes.
Are they pretty close?
I think so. I think
Yes.
we're in agreement with most.
I think so.
I got it.
All right, so I'm not going to bring the jury back out. I'm going to let the jury know that so if we start at 10,
I have to go back to the office and get my laptop and some things set up.
all right, so can somebody stay with me so we can go over these instructions? You can go back and do what you need to do.
Yes, Your Honor.
Okay.
Your Honor, at this time, the defense would renew all previously made objections, filed motions, as well as our motions for judgment of acquittal, and will rely on all previous arguments.
All right, thank you. I keep interrupting you from doing that, Mr. Hill. I'm sorry. All right. Does the state want to be heard any further?
No, Your Honor.
All right, the court will maintain its ruling on its denial of the defense motion for judgment of acquittal. All right, so we are going to go off the record so that I can have a conversation with the attorneys I'm going to join the Zoom. Mr. Holman, if you would, it's 9:40, so if you would let the jurors know that I'm going to bring them back out at 10 a.m., okay? Court's in recess. I'm going to work with the lawyers over the recess on the instructions. So all I do is I need to join Zoom. Okay. We have been working off the record with the instructions so that we can have a succinct charging conference. And I'm going to go through the instructions that we have gone line by line to make sure that the record is clear where there is agreement and where there are objections. So for the record, I have all defense counsel present. Mr. Fernandez-Saldana is present. All assistant state attorneys are present. And this court is referring now to the title page. Any objection to that?
No, Your Honor.
None from the defense.
And I'm going to go through introduction of final instructions and statement of charges. Any objection to either one of those instructions?
No, Your Honor.
No, Your Honor.
First degree murder. Any objection to this instruction?
No, Your Honor.
Lesser included crimes. Here, the defense was willing to waive the lesser included. Is that correct?
That is correct. And we did have consultation with Mr. Fernandez and explained to him our position. He was in agreement, but we understand at the request of the state that they're included.
All right. Did the state want the lessers?
Yes, Your Honor.
All right. I'll give the two necessary included lessers requested by the state, which are second degree murder and manslaughter. Moving to second degree murder. Any objection to this instruction?
No, Your Honor.
No, Your Honor.
And for the record, we did discuss the alternate language related to the word imminently dangerous act. And so we've all decided that that other language doesn't apply to this case. Are we all in agreement with that?
Yes, Your Honor.
Okay. Manslaughter, we discussed this instruction and agreed on the procurement instruction, agreeing that manslaughter by act does not apply in this case.
Agreed.
Agreed.
Okay, so we've taken out that reference, and so we agreed with this instruction.
Agreed.
Yes, Your Honor.
All right. Count 2, criminal solicitation. Any objection to this instruction?
No, Your Honor.
No, Your Honor.
All right, so we spent a significant amount of time on principles. Mr. Hill, so the first half of this instruction, which is all the standard, you did agree with that, is that correct?
That is correct, Your Honor.
Now, when we get to the second portion, did you have an objection in this one?
The only objection I had was deviating from what is listed as a standard instruction in the current rule book by including manslaughter.
All right, so what you're referencing, this court put a sentence at the request of the state. The following instructions applied to count 1 of the indictment, and the second paragraph, which refers to the lesser included crimes of second degree murder. Over the defense objection, I'll overrule it. I will include the crime of manslaughter. This court finds that it is a correct statement of the law. It is a lesser included offense of the charged crime. The standard for giving an instruction is there some evidence and is a correct statement of the law. It is not admittedly in the list of crimes that were bracketed out. However, the court will cite that in a normal homicide, and I say quote unquote normal, that language would be given along with second degree murder, that there is no need for the state to prove that the defendant intended to cause death. So this court finds that even though it's manslaughter by procurement, the state, Mr. Mizrahi, you argued that it's the procurement of the act, not the result.
Correct.
All right, so I will overrule the defense objection and give the instruction as written. Date of crimes, venue.
No objection.
No objection.
I'm going to roll through a couple of them, okay, because I don't think, plea of not guilty, reasonable doubt,
No objection.
weighing the evidence. We agreed on these, correct?
We did.
All right, so both pages of that. defendant not testifying will be given. The only change was that in the second paragraph, I took out did and just put did not by agreement with the defense. Is that correct?
Correct.
All right, rules for deliberation, notes, cautionary instruction, verdict. Any objection to those instructions?
No, Your Honor.
No, Your Honor.
Now, Mr. Hill, the verdict forms, make your big debut with your request.
Yes, Your Honor. We consistently always request to move defendant, we, the jury, find the defendant not guilty to the top of the list.
Okay. All right, so I did comply with the defense request to move not guilty to the first page, even though it leaves the signature line on the second page. However, I will deny the defense request to put not guilty first. The court finds that while the defendant is presumed innocent of the charges, to do that would then conflict with the verdict instruction, which has the jury find the defendant guilty of the highest crime and then work down from there if they are not satisfied with the evidence. So for those reasons, the court will deny the request. Second verdict form, any objection to that?
No, Your Honor.
No, Your Honor.
Now I'm going to roll through a couple of them, single defendant, multiple counts, and submitting the case to jury. Any objection to those instructions?
No, Your Honor.
No, Your Honor.
All right, that will conclude the charge conference. I will finalize the instructions with a couple formatting things that I saw. I'm going to stop my share. Counsel can have leave to set the courtroom up for closing argument. I'm not sure where did Mr. Holman go? Okay. Let me know when you're ready for closing. I just want to get Thank you.
I changed my mind. I'm just going to go straight into closings if that's okay with the court.
Sounds great.
Thank you.
Then what I'm going to do is, AJ, I hate to be a pain. There won't be any need for a Zoom. Can you switch it back over? Is that too much of a, are you okay? Is it okay like this? I'm leaving, yeah. Let me know when you're ready. Okay. Let's bring in the jury. Thank you. All right, welcome back, members of the jury. Everyone may be seated. All right. Members of the jury, both the state and the defense have now rested their case, and the attorneys will be presenting their final arguments to you. Before they do, I need to let you know that you need to remember that what the attorneys say is not evidence or your instruction on the law. However, you should listen closely to their arguments because they're intended to aid you in understanding this case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. I turn the case over to the state of Florida. Ms. Stifler.
May it please the court?
Yes.
Counsel?
Yes, ma'am.
Jared Bridegan never saw it coming. He was unarmed, unaware, exposed, vulnerable. He had no time to prepare for death. And he couldn't have known on that cold asphalt in February of 2022 that the architects of his murder had been making preparations for his death for months. You have been attentive jurors over the past week and a half. Your job has been to listen to the evidence, and your job will be to render a verdict. The state of Florida's job is to present you with evidence and prove the charges we've indicted this defendant on beyond a reasonable doubt. The defense attorney's jobs are to test the evidence and defend their client. You are here to discover the truth. That is what justice is. The truth of what happened to Jared Bridegan on February 16th, 2022, and who is responsible. This is a court of law and reason, as I said last week, not anger or emotion or prejudice or sympathy or bias. What happened to Jared Bridegan in front of his daughter is awful. But your emotions must not rule your verdict. It must be based on the law and the evidence. And your role is to answer two questions. Was a crime committed? And did this defendant, Mario Fernandez, commit that crime? The law allows you to make reasonable inferences from the evidence. You have heard a lot of witnesses. You have seen a lot of exhibits. And I'm going to go through some of the law the judge will instruct you on and the evidence that you have been presented and show you how we have proven our case that this defendant is criminally responsible for the planning and the preparation of the death of Jared Bridegan. One of the instructions the judge will give you that I want to keep in your mind while we go through the evidence is the law on reasonable doubt. Reasonable doubt is not a mere possible doubt, a mere speculative doubt, a hypothetical doubt, a forced doubt. It's not a guess, conjecture, and the law does not require proof beyond all doubt. I tell this to you because during the course of this trial, through cross-examination, the defense opening, and what I anticipate they will argue, is that you will be asked to speculate, you'll be asked to imagine, you'll be asked to conjure and guess as to alternate explanations for the evidence presented by the state. And if you are back there in that deliberation room saying to yourself, maybe, what if, possibly, you are straying from the law that the judge is going to instruct you on. Reasonable doubt means that it is based upon reasoning and common sense after a careful and impartial consideration of all of the evidence. The most important thing I will talk to you about today is how the evidence relates to each other, how the evidence should be viewed in its totality, and how the evidence in its totality is overwhelming against this defendant. Was a crime committed? You're going to be instructed on two crimes, murder in the first degree and solicitation. And I don't think, you've already heard, that there's any dispute that Jared Bridegan was killed in a premeditated first-degree murder. He's dead. It was a criminal act, and it was premeditated, meaning that there was a conscious decision that Jared die. You know that based on how he met his end, the manner in which he died, and the fact that Henry Tenen fired 4 10-millimeter bullets at him, 2 of them striking and killing him. The law doesn't require a fixed period of time to form this intent, but you know, based on the evidence, that those plans, that preparation, and that intent was formed long before February 16th. Premeditation. 4 gunshots in a row, execution style. There is no doubt that Henry Tenon pulled that trigger. The defense has conceded it. The state has proved it. You saw it yourself on that video. There is no doubt that Henry Tenon shot Jared Bridegan. But in this case, not just one person is guilty, because this crime is not a crime that is committed by one person. I said at the beginning of the trial that this is real life. There's been a lot of talk throughout this trial and at jury selection about the presence of media, about podcasts, about true crime, about TV shows. And I talked to you about the manner in which Jared Bridegan died in my opening statement to remind you that a man, a real man, was wiped off the face of the earth on a dark road, on a dark street, on a February night for no reason, or no good reason, no justifiable or legitimate reason. Lying on the pavement, dying, while his 2-year-old daughter is panting in her car seat, wondering if the police are going to help her daddy, ice cream still sticky on her mouth. One thing, though, that I will say podcasts and TV shows and books and movies get right about crime is this idea, common sense idea, even absent the instructions the judge will give you, which she will instruct you that you can and should use your common sense. This idea of means, motive, and opportunity. Not elements, something that you all know intuitively as human beings and as jurors, and something that you intuitively can see in this case when you look at the totality and look at the big picture. Consciousness of guilt. And here's the thing. Henry Tenon had none of those things. He didn't know Jared Bridegan. He's a convicted felon who's basically homeless, squatting on people's couches with an overdrawn bank account and no access to firearms, who doesn't go to Jacksonville Beach other than the times where he is hunting Jared Bridegan. Henry Tenon didn't have motive or means or opportunity, absent one person. We started this case with the ultimate question: who did? Who had these things? And standing here a week and some days later, the answer should be clear to you and proven to you beyond a reasonable doubt. This defendant, Mario Fernandez, and his wife, Shanna Gardner. I want to talk a little bit about the idea of criminal solicitation. But one thing I want to talk about before we get there is that the defense made some arguments or statements to you in their opening statement and fleshed those out through cross-examination. And there were 3 things they said that I agree with, that you should keep in your mind as you view the evidence. The defense in opening said, and in jury selection said, just because you know a wrongdoer doesn't make you a wrongdoer. That's true. They said that the defendant, Mario Fernandez in this case, didn't really have a motive, that the divorce wasn't that bad, that there really weren't child custody issues, and therefore it's inconceivable that he would commit this crime. I agree with the idea that if you don't have a strong motive, it does not make sense that you would commit this crime. Which lends you to, as we get down, what I mentioned earlier, that Henry Tenon had no motive. It makes no sense that he, on his own, independently and alone, would commit this crime. And lastly, the defense argued through cross-examination, and you recall those many, many poll camera clips, that distancing yourself from somebody looks guilty, and not distancing yourself from somebody doesn't look guilty. And I agree with that concept, consciousness of guilt. But in this case, Mario Fernandez did distance himself from Henry Tenon and John Biggerstaff and 5239 Potomac Avenue when he realized the police were closing in on him, when they arrested Henry Tennant on August 18th of 2022. Up until then, he didn't think they would ever get caught. This plan was designed specifically so that it would never tie back to Mario Fernandez. Using a random tenant without a lease, without lawful residence at that residence anymore, with checks, with subject lines that wouldn't draw too much attention out of a business account. Until it didn't. Until they figured it out. Until, by a stroke of luck, an act of God, good detective work, boots on the ground, never giving up, going everywhere, trying everything, talking to everybody, finding that tire at Potomac Avenue. And then in August 2022, that's when this defendant began to distance himself. And you all saw the evidence, and I'll discuss that. So 3 things I agree with. Mere association with a guilty party doesn't prove guilt. But close association with several guilty parties, that's harder to explain. Motive, even though it's not required, can tell you who committed a crime. And consciousness of guilt, hiding evidence, destroying evidence, is evidence of guilt itself. First-degree murder, the law is very simple on that, and it's not going to be in dispute that Jared Bridegan was killed with an intent to kill him. Criminal solicitation is the other charge that Mario Fernandez has been indicted on, and that requires that he solicited Henry Tennant, meaning he commanded, encouraged, hired, or requested him to commit this first-degree murder. There are 2 distinct crimes under the law, murder in the first degree and solicitation. Your verdict is separate on both. But a large majority of the evidence we presented applies equally to both. The solicitation is the ask. You earnestly ask someone to commit murder or to engage in specific conduct. You don't ever have to lift a finger to help. It is the ask, a genuine, earnest ask. It doesn't require that the act be completed. Somebody can ask somebody to kill someone for them, and it never happened, and they never do anything about it. And if you believe they asked that person beyond a reasonable doubt, even though it didn't happen, and even though they didn't lift a finger, they can still be found guilty under the law. Solicitation is the ask. Principle to murder is the completion of the act. The ask and the act. Here, both happened in this case. He is guilty of both because he asked, and he is guilty of both because it happened. And he helped, and he incited, and he encouraged, and he hired, and he solicited. 2 of the other things we have to prove are the dates of the crimes. I'll get into that. I have a timeline to show you. The murder, February 16th, 2022. There's no dispute there. Everybody is in agreement. Jared was shot and died on scene there on Sanctuary on February 16th. Criminal solicitation, the state has charged a range from November of 2021 to the act, the completion of the act on February 16th, 2022. We also have to prove venue. That means that we have to prove this occurred in Duval County, which you all know, multiple people testified this was in Duval County, just north of that St. Johns County line in Jacksonville Beach, Florida. And the reason I bring all this up is because I want you to be clear on what the law requires and what it doesn't, which is the state has to prove, was a crime committed, did the defendant commit it, date, and venue, where it happened. So you've got the who, the what, the when, and the where. The law doesn't require us to prove the why. The law doesn't require motive. But in this case, the why proves the who. So I'm going to get into how it is that the evidence has shown that this defendant participated in the murder of Jared Bridegan. The principal's instruction. This is something the judge is going to give you. And this is something Mr. Mizrahi talked about in jury selection with that example of the bank robbery, where you have the getaway driver, you've got the bag man, you've got the guy holding the gun while they're sweeping the money into the bag, and you have, like in Ocean's 11, the guy with the blueprints of the bank and how to get in, off in Cabo enjoying himself. They are all equally culpable under the law. They may not be punished the same, but they are all equally culpable under the law because they are principals. So the state in this case doesn't have to prove that Mario Fernandez was at the crime scene, that Mario Fernandez pulled the trigger, that Mario Fernandez was in the proximity of it. We just have to prove that in this time frame, he intended that Jared die and that he did something or said something that was intended to and did incite, cause, encourage, assist, or advise Henry Tenon. And all of you must render a unanimous verdict when you're considering first-degree murder and whether he incited, caused, encouraged, assisted, or advised Tenon. You all have to be unanimous that he is guilty as a principal for doing one of those things. You all don't have to be unanimous as to which of these things you personally believe it falls under. You can believe he paid Henry Tenon to do this. You can believe he encouraged him by showing him what Mr. Bridegan's vehicle looked like. You can believe that he drove the truck that night. You can believe he gave Henry Tenon the gun. It doesn't matter which fact you believe beyond a reasonable doubt this falls under, as long as all of you believe he did something or said something that is one of these things. That makes him guilty under the law, and you can return a verdict of guilty under the law. He doesn't have to be present when the crime is committed. He doesn't have to know under the law how every detail of the crime will be committed. If he had that intent and did or said something to do one of those things, assist, encourage, incite, then he must be treated as if he was standing there holding that 10 millimeter, pulling that trigger 4 times until Jared Bridegan died face down on that pavement. The law is written in this manner for this exact scenario. A murder for hire, a way to distance yourself, an outsourcing of your dirty work so that you are never traced back to it. That is why we have this law, because the law contemplates that there are situations like this, and the law understands that someone should not be able to get off completely scot-free and never be held accountable because they outsource a murder to somebody else. Again, I said the judge is going to instruct you that you're allowed to use your common sense, and you should. You brought it with you here today. You're not going to leave it here in this jury box when you go back in those deliberation room. So look at the evidence, understanding it in a reasonable manner, looking at it with common sense, and deciding what it means. And to do that, the law gives you guidance. The judge will instruct you on how to weigh the evidence. The testimony of witnesses is evidence. The exhibits before you are evidence. It is not the question asked by the attorney to the witness, but the answer that they receive that is the evidence. When you look at witness testimony, you look at, do they know what they're talking about? Did they see and hear and know what they are describing? Are they accurate in their memory? Do they have a bias or an interest in how the case should be decided? That is important because if somebody is tailoring their testimony because of an interest, you need to consider that as to whether you believe they're credible, reliable, and truthful. Have they been promised anything for their testimony? And does their testimony agree with the other testimony and evidence in the case? You listen to a witness and their testimony doesn't agree with other evidence, and they have an interest, personal or otherwise, in making sure that their interest is protected or the defendant's interest is protected. You get to decide how much weight you give their testimony. You can give it some, you can give it none. So I want to go through, I know there was a lot of very dense testimony, a lot of technological, digital evidence, a lot of surveillance, phones, cell site. You all got quite the education this week in the plethora of evidence available to modern law enforcement. I want to go through and explain from beginning to end how it all connects, how it all adds up. And I think it makes the most sense to start chronologically. From 2018, when Mario Fernandez married Shanna Gardner, up until the murder in 2022, there were years of animosity between Ms. Gardner and Mr. Fernandez and Mr. Bridegan and his new wife. You know that. You know that from the testimony of Taylor Kudis, who told you Mr. Fernandez complained to her about a high conflict custody issue. You know it from the testimony of John Biggerstaff that the defendant said the child custody dispute was putting a strain on his marriage with Ms. Gardner. You know it from the court filings. There was some cross-examination with Detective Johns about the court filings and how they weren't that petty, they weren't that acrimonious, but you can look at them. These people are litigating everything. Who should pay for half of an oxygen tank for their kid? It was not a pleasant and happy and copacetic situation. And you don't have to take my word for it, and you don't have to take their word that it wasn't. You can listen to the defendant's own words in his recorded interview.
The primary goal, because it wasn't amicable and because of how they're being with the kids, we were more or less fighting for the kids to have a chance and for Shanna to have majority decision making. And if she could have more timeshare on her, and if it was like 60-40 or whatever, if we could bend it just enough, it'd be great because the kids would be better off.
Right.
You know, and if we could push them into the corner of all the interaction with the kids, we all need to be together.
Yeah.
So they could just suck it. And I don't care if they're suffering because they're uncomfortable. I'd much rather it all be right there in one. So if they say something dumb, I can immediately. I'm confrontational. I don't care about that. So I could be like, no, hell no, dude, we're not doing that.
Right.
And I can shut him down, and the kids can see, hey, like, not this. We can do it this way, and we'll all be here. So there's no, oh well, they said no. I that shit was just so annoying to me.
The defendant himself said there was custody issues. They wanted majority decision making. They wanted more custody, even 60-40. He is at an interview with police 13 days after Jared Bridegan has been shot and killed, and he is going on and on and on disparaging Jared Bridegan. He calls him a keyboard warrior. He says that they can suck it. He's talking about a dead man to police in a murder investigation. It is clear there was no love lost between them, and it is clear from his words, not their argument, that they were seeking more custody. And you heard that too from Mr. Fernandez's own friend, Carlos Fong, said. It was incessant. Shannon was always talking about she wanted more custody, she wanted more custody, she wanted more custody. The witnesses they called, the teacher, Ms. Meredith, said she was aware that they wanted more custody. He acknowledges years of conflict.
What could we tell them? And I told her, I was like, we tell them what we know, which is our interactions with Jared, how Kirsten is being a total bitch right now, and how this has been. For me, this has only been for 4 years. Mm-hmm. For Shannon, it's been like 7-8 years. And then before the divorce, it was everything that she dealt with him.
Right.
Years of animosity suddenly
So like
solved.
certain things are happening where it's like, oh, well, we're going to do this. And it's we don't have to do that anymore. Mm-hmm. Like, we don't have to do that anymore because there's no split.
He was talking about how the kids' new normal with Jared gone is asking about the things their dad used to require or their dad used to want. And his statements are, we don't have to do that anymore. He's gone 13 days after. And listen, I am not here. I'm not a family law attorney. My client is not Jared Bridegan or Kirsten Bridegan. My client is the people of the state of Florida in a murder. I don't care if Jared Bridegan was the most petty, obnoxious, keyboard warrior jerk during a divorce and custody battle. That's not before you. It doesn't matter if they were completely right about this situation or completely wrong. What matters is how they fixed it. They fixed it by executing a man when they had other alternatives available to them. That's why we're here. Don't get caught up in the pettiness and the drama, who's right, who's wrong, who's good, who's bad, who's nice, who's not. What matters is, did this defendant take matters into his own hands to solve this problem? To tell them to suck it, to have more custody. They don't have to do this anymore. There's no split anymore. So there's years of animosity. We know that from the defendant and the rest of the evidence, and that all corresponds and agrees by witnesses that have an interest in protecting Mr. Fernandez said it themselves. His friend Carlos Fong, the witnesses called by the defense, the kid's teacher, his former fling/friend, Ms. Kudus. So you can consider, and his own words, you can consider those statements and that evidence of this animosity reliable, because it came from multiple witnesses, including the defendant, who have no reason to help the state of Florida. And it came from Mrs. Bridegan as well. Kirsten Bridegan admitted it was bad, and there were pettiness on both sides. So we're moving now to November 21st to December 21st. We know from Mr. Fernandez's, again, own statements and the testimony of the detectives that Henry Tenon was living at 5239 Potomac at this point. We also know that the defendants had made statements about how Mr. Tenon was constantly behind on his rent. He could barely scrape the money together.
Right away, like, you know, just you can pay like week by week kind of deal, but you got to make it up. And then I want to say it was either September or October time frame, like it's so fucking long ago now, that he flat out told me, he's like, I can't fucking afford it anymore. He just couldn't.
So he just left, yeah.
Yeah, and well, the thing was, I told him, I was like, well, how about, you know, what can you afford? And like the dude was like scrapping up like 300. And then I told him, I was like, I could, if this is where you're at, I can give you till December, and after December, like that's it. And the thing was, like, I had a new tenant come in January.
So we know that, according to Mr. Fernandez on that wire call with his friend, that Henry Tenon was evicted in December. And we know that Henry Tenon had no money and couldn't pay his rent. And yet, Henry Tenon was still living at Potomac for some period of time after this eviction in 2022. And a man who couldn't even afford his rent and was behind in his rent is receiving large sums of money for Henry Tenon, large sums of money, like several months' salary from this defendant. And we know that Henry Tenon and Mario Fernandez had significant contact on January 4th, 2022. We know that from the phone records. They were in contact. He's getting evicted. Why are they communicating so much in January and February and March when he's no longer a tenant? It's because they are discussing January 5th. This is where the solicitation comes in. You have evidence beginning from the defendant, again, own words. He's evicting this man, he can't pay any money. And then magically in January, Henry Tenon is driving around Jacksonville Beach, the same route of the homicide, on a date night when Jared Bridegan would be in Jacksonville Beach. You would have to know about date night. And you have to know that Jared would be there. And you have to know where to look for Jared. They met up. The only texts left on Henry Tenon's phone happened to be from this date, which is lucky for us. January 4th, 2022, from Mario Fernandez to Henry Tenon. Heading your way. Okay, I'm here, brother. The timing of everything. Individually, I want to be very clear. Individually, the defense can take any one of these points, any one of these exhibits, any one statement from a witness in a vacuum on its own, excised from the rest of the evidence. And of course, there's always going to be an innocent explanation for every one little thing. And I'm not saying the fact that Mario Fernandez went and met up with Henry Tenon on January 4th makes him guilty. What I'm saying is, it is interesting and suspicious and evidence in the totality of everything of his guilt that he meets up with him the day before Henry Tenon goes to Marsh Inlet, where Mario Fernandez lives, to Shetter Avenue in Pablo Hamlet, where he waited that night for Jared to commit that murder, and down Fairway, the same route that homicide truck took that night, the same route where there are no cameras, the same route where you can look for somewhere to sit and wait for somebody, like Cradle Creek, a nature preserve with a parking lot and no cameras, and a view of 15th from Marsh Inlet where you could see someone's headlights and car easily. That's what you have to consider, not in its individuality, but in its totality. So on January 5th, we're in the time frame of the date range for the solicitation. How would Henry Tenen know about date night? That is something I want you to really think about, and I want you to really use your common sense, because there was a cross-examination question by Mr. Dreiser, I believe, of Detective Johns, that date night is litigated in all these filings in the St. Johns County Family Law Clerk of Courts. And you can ask yourselves if you think it's reasonable that Henry Tenen is logging on to the St. Johns County Clerk of Courts family law case, pulling up individual filings on time sharing and parenting plans, and reading the details, and then plotting a map of where he should be. You decide if that's reasonable. I would submit to you it's not reasonable, it's ridiculous. Henry Tenen knew about date night on January 5th in this location and this route because Yes. was reading filings and then plotting on a map and devising this plan is not reasonable. It's ridiculous. And it causes you, or asks you, to conjure, it asks you to rely on conjecture and speculation and imagination, and that is not what the law requires of you, and it's actually what the law forbids you from doing. Somebody had to tell Henry Tenen about date night in these locations and these routes right next to Mr. Fernandez's house. And your common sense and the totality of the evidence leads you to the conclusion, beyond a reasonable doubt, that that person was Mario Fernandez. But it's not just Mr. Fernandez's connection to Henry Tenon. He also is connected to John Biggerstaff. John Biggerstaff, who happens to own a Glock 10mm firearm that can't tell us where it is, can't produce it, can't find it, despite the fact that he is a self-proclaimed gun enthusiast, former JSO reserve officer, 20-year Navy veteran with 20 firearms. I don't know where any of them went. My son kept them in his car for a few months. My son, the police officer, just kept 20 guns in his car for a few months without checking on them ever. We took them to someone's house. I never saw them again. I didn't think about selling them, even though they're valuable, even though guns have value, even though his son could have legally sold them. His son, a police officer, and him, a former police officer, are just so careless with a killing machine, a lethal weapon, when they are trained and know better. Knowing a wrongdoer doesn't make you a wrongdoer. Knowing two wrongdoers is a little harder to explain. And there's no dispute that Mr. Fernandez, the defendant, and Mr. Biggerstaff had a very, very strange relationship, as you all heard come out during cross-examination and defense opening. But that connection to that firearm is what makes, in the totality of this, the defendant's guilt that much stronger. Because here you are, you're getting more and more and more and more pieces of evidence that individually, again, can be explained away, but together becomes much, much harder to come up with an innocent explanation or to look at these in a reasonable way that doesn't suggest overwhelming evidence of his guilt. On January 25th, we know, because of technology, that Mr. Biggerstaff and Mr. Fernandez were together at Mr. Biggerstaff's home. Mr. Biggerstaff testified that Mr. Fernandez came over and he just can't remember what they talked about. 2 weeks before the homicide, he can't remember what they talked about, and he can't remember Googling Glock 10mm firearms, 10mm Glock pistol, 10mm Glock pistol, pin on hidden gun case, after Mr. Fernandez left his residence. Mr. Biggerstaff, remember earlier when I talked about the weighing the evidence and the memory and the interest and the bias? You can decide how credible you think Mr. Biggerstaff is in giving this helpful testimony to his buddy that he couldn't remember ever discussing a 10mm with him, just a coincidence that he was Googling it. But on defense cross-exam, Mr. Biggerstaff could recall with excruciating detail every single minute of his slip and fall, from the fact that it was a 4-foot sign next to the breakfast sandwiches. He could recall every other Google search he did. Yeah, I remember Googling flour tortillas, and I remember Googling yachts in the south of France, and I remember Googling military bases. 10mm? Oh, don't remember that. I do remember Googling a 9mm, because I know that's not the firearm used in this homicide. But this one, don't remember, don't know her. These gun cases and hidden furniture, that's from my drugs. Even though, and he remembers that, even though it says pin on hidden gun case in these searches. So that, we're talking close in time. We're talking weeks before the homicide. This defendant is going to Henry Tenon's home, who's evicted, no longer a tenant. The day after they meet up in person, Henry Tenon is driving past Mr. Fernandez's house, driving past Pablo Hamlet on a Wednesday night date night. Week before the homicide, 2 weeks before the homicide, Mr. Fernandez is going to Mr. Biggerstaff's house where he's Googling how to hide a 10mm in furniture and Googling 10mm firearms, searches that he can't recall, just like he can't recall where that gun is. In totality, there is no other reasonable inference than these people are planning this murder. They're planning to use a 10mm, that's what was used. They're planning when it would happen and where it would happen. That's why Henry Tenon drove that route. They're planning who was going to be killed, and the only person with a connection to Jared Bridegan between those three, Biggerstaff, Tenon, and Fernandez, again, this defendant. The connection, the spoke in the wheel that turns that plan to its eventual execution and completion. Then we get here to January 29th. I have here the, quote, dry run. That is what Mr. Dreiser asked Detective Johns or Lindsay Butler. Is this what you would call this, a dry run? It's a pretty good name for it because it is sort of a dress rehearsal for committing a homicide. This is what you might call scouting the scene, scouting the victim, casing the joint, whatever you want to call it. This is what happens. Henry Tennant's two devices, his phone number ending in 7612, his other phone with henrytennant53@gmail.com, go from his house where he's squatting at Potomac Avenue, because at this point we know Jeremy Ordway has moved in. You remember the lease defense put into evidence was dated January 27th. So Henry Tennant is evicted at this point, and there's a new tenant. And yet Mr. Fernandez arrives, or is possibly co-located, if you want to use expert testimony jargon, at Potomac Avenue right before Henry Tennant drives all the way to St. Johns County. We know he's in that blue two-tone truck, and we know Mr. Fernandez is coming to Potomac, and Mr. Tennant is leaving and then coming back while they're co-located again in that same truck. Mr. Fernandez, as you saw from the poll cam footage that the defense put in, would go to Potomac in his Tundra, park on the street, and Henry Tennant and Jeremy Ordway's cars would be parked right there in that driveway. Although in August of 2022, the truck's broken down, so Henry Tennant's driving that Crown Vic. But you know, from their evidence that they said is great evidence of habit and history and usage of this residence, you know Henry Tennant parked in that driveway when he was there, and you know Mario Fernandez parked on that roadway when he was there, and you know Henry Tennant was in this truck before the murder, and you know that truck was released to the media, and you know that this defendant didn't say anything about his tenant owning a blue two-toned Ford F-150 when he talked to police on April 1st, 2022. That's what's important about this. Multiple things about this day. Maybe individually, your tenant owning a truck that you might not know about, not bad. Going to the house when your tenant's in that truck, a little worse. Going to the house when your tenant's in that truck who then goes down to AB's gymnastics studio and the street where the victim lives, really bad, really hard to explain, really doesn't make sense unless you are in that truck with that tenant, telling him where to go, telling him who to look for so that he knows exactly who he's supposed to execute on February 16th. The biggest thing about this, too, is this is the defendant's own words that let you know he's the one that told Henry Tennant about this. Because I don't think, and you can check me, you can go through every filing you want, and you can go back in your mind over the testimony, that anywhere in that parenting plan or in that date night was it stated the location and the habit of Jared Bridegan to go to this gymnastics studio and go back to his house. So that is where Henry Tennant went, past this gymnastics studio, and then to the street where the victim lived. And if you look at the time on those maps, you can see that he's traveling like he's on a highway, and you can see that the distance between those data points, the time between those data points, is not enough time that he's stopping somewhere. He's not going to a medical appointment or a business. He's not going out to dinner. He drives straight there, drives around, and then drives up to the crime scene. How would he know to look for Jared at the studio and then at his house? How would he know?
Abigail has told us, like, that he just drops her off and then leaves, goes home, then comes back, even though they live, like, 5 minutes away.
The defendant himself told police it made him angry. It annoyed him. He complained about it. He's trying to make Jared look like a bad dad. Listen, he drops AB off at her gymnastics, and he doesn't even stay. He doesn't even stay to watch her. He drops her off, he lives 5 minutes down the road, and then he goes to his house. Well, what does Henry Tennant do this day? Goes by the gymnastics studio, and then goes by Jared's house. That is not a coincidence. That is not an accident. He was searching, he was looking, he was hunting. And he was told by this defendant about that habit of Jared Bridegan, because there's no other way he could have known. Then, after leaving Potomac, where he no longer legally resides, going by the gymnastics studio, going down the victim's street, he goes up to the crime scene, the eventual crime scene where Jared would be killed. And while he's doing this, the defendant's phone is in the vicinity, in these bands at Potomac. That's what those bands mean. It can be within 1 to 2 bands. He is at the Potomac residence, but what is interesting about this is all his phone is recording what we talked about. These timing advance means that your phone's communicating with the tower and it's taking measurements without you doing anything actively. There's no cellular usage. And cellular usage, meaning what tower you're using, is different. Remember, timing advance is a network-initiated activity. T-Mobile is pinging your phone, so to speak, and sending back information about how far you are away without you doing anything, as long as it's on or not in airplane mode. You, if you are using your phone or texting or calling or doing anything, create data on cell towers. And Mr. Fernandez's phone is not creating any data. It's not interacting with the cellular towers. It's not making calls. It's not sending text messages. And on its own, a period of time when your phone is not being used isn't suspicious. It isn't evidence of guilt. But the totality of your phone staying in one area and not being actively used by the phone holder, by the defendant, while Henry Tenen is driving down to an area only Mr. Fernandez would have known to tell him about, that is evidence of guilt. That only has one reasonable conclusion, is that Mario Fernandez got in that truck with Henry Tenen and went down to show him Jared Bridegan's vehicle in St. Johns County, and then up to show him the eventual homicide scene. And we know that because as soon as Henry Tenen arrives back at Potomac Avenue, Mario Fernandez's phone leaves 3 minutes later. That timing, he arrives, they overlap for 2 minutes. That's plenty of time to hop in someone's car. Henry Tenen's truck, in that truck, does this whole route, comes back. 3 to 4 minutes later, Mario Fernandez leaves. That can't be a coincidence. That is evidence of what they were doing. That is evidence of this plan. That is evidence of the preparation. We're moving along. February 15th, this is an important date because this is the day before the homicide. And it is important because the defendant, again, has contact with 2 of wrongdoers, as defense would phrase it, in the same day. It is significant. It is of evidentiary significance that Henry Tenen, the shooter, and Mario Fernandez are together the night before the murder. You saw a map. I don't have it here, but you can look at it. They are together at Potomac. Their devices are co-located for over 27 minutes, about 27 minutes. And we know Henry Tenen at this time is driving that truck. So there's 27 minutes, Mario Fernandez at Potomac with Henry Tenen. And then Mario Fernandez leaves Potomac, and that night he goes to the home of John Biggerstaff, the person who owns an unrecoverable, unfindable Glock 10mm firearm. And you heard some very unpleasant testimony about what Mr. Fernandez was doing there that night, but it is of evidentiary significance that he is having contact with 2 people with connections to that scene. The truck from Henry Tenen, the gun associated with a similar gun that Mr. Biggerstaff owned that he can't produce. This defendant has contact with both of them the night before Jared Bridegan is killed. That is significant. Individually, contact with one, contact the other can be explained away. Together, there's only one reasonable conclusion. They are perfecting this plan. February 16th, of course, Tenen murders Jared Bridegan. That's Henry Tenen. This is the part where I want to remind you of that instruction from the judge that she'll give you about principles. It is not necessary that we prove Mario Fernandez was present when the crime was committed. All we have to prove is that he encouraged, incited, assisted him, whether by explaining date night, by telling him who Jared was, by showing him the car, by giving him the gun. You can find him guilty based on that and that alone. You don't have to believe beyond a reasonable doubt he was there. But we know there were 2 people at the homicide scene that night. Henry Tenen on foot and somebody driving that truck. Who would Henry Tenen bring to commit a murder? He had to go commit a murder with someone. Who would he trust? Who would he bring? You don't bring a witness to a murder, you bring a co-defendant. Do you know why? Mutually assured destruction. You got to trust that that person and you are going to keep your mouths shut. And how can you do that? You can only do that if that person is equally guilty, equally culpable, and wants the same objective you do. And nobody wanted Jared Bridegan dead. Nobody that the evidence uncovered or the investigation uncovered more than this defendant and his wife. So if you're Henry Tenen and you're going to kill Jared Bridegan and you need help with it, you bring someone who wanted Jared Bridegan dead, who wanted to see it happen, who wanted to see it successful, and who wouldn't rat you out later. Mutually assured destruction. Henry Tenen had very few close associates. You heard from his phone records, he had a girlfriend, Peanut. He had Jeremy Ordway, his roommate, and he had Mr. Fernandez, who he's in frequent contact with during this time frame. And you saw in Mario Fernandez's phone that Henry Tenen, although his contact was deleted, that Mario Fernandez had a contact, Jerry at Potomac, Jeremy Ordway. And you will see that the phone number for Jeremy Ordway in the defendant's phone matches a phone number that was calling Henry Tenen's phone that night. The phone here by this green tower. While Tenen, who's on foot at this pink tower, these dots. We know he's there from the surveillance. We know he's there from the cell site with that phone linked to Henry Tenen 53. His phone for 7612 is using this green tower. And Jerry Ordway is calling this green tower phone during the homicide. And we know the truck, the person driving the truck, is separated from the person on foot. So if Jerry Ordway is calling this phone, that means it ain't Jerry Ordway. And if you eliminate Jerry Ordway from the list of associates of Henry Tenen, the people that he's close with, you're left with one person, the person with the motive, the person you bring to a crime, the person who wants you to commit that crime and is going to help you succeed in your endeavor. If you're Henry Tenen, you don't bring a witness, you bring Mario Fernandez to complete the mission he wanted you to complete. You bring your co-defendant. And we'll never know where Mario Fernandez really was that night because his phone stops communicating with the cell tower. And not just stops communicating with the cell tower, it stops recording those timing advance recorded data points. Even though there's a number of them before the murder, and even though there's a number of them after the murder, there just happens to be none of them. Starting at 7:10, when they end here on the slide, through 8:20. And there is no incoming, outgoing, text calls, etc. Agent Blythe testified even if you are on Wi-Fi at your house, your phone will still interact with the cellular tower and still record data in those records and still record those timing advance. And he said it's much more likely, it makes more sense based on the totality of everything that the phone was off or in airplane mode, rather than it just happened to have connection issues on the timing advance and just happened to not be using his phone at the same time. And another thing that happened to happen here is that the last timing advance data point recorded is at 7:10:28 p.m. And when you go back and watch that surveillance video of the homicide truck leaving Pablo Hamlet before Jared Bridegan's killed, it pulls out at 7:12 p.m. So his phone, if it goes into airplane mode, as I'm arguing it does, or is turned off, is a minute and a half before that truck pulls out. And do you know where Mario Fernandez's residence is in relation to that truck parked at Pablo Hamlet? Over a fence, over a gravel parking lot. A minute and a half. In its totality, there is no other reasonable inference or explanation that he was getting in that truck to drive it, to take Tenen down, to complete the mission that he wanted. The mission that he wanted accomplished. No data. Mr. Dreiser brought out in cross-examination with Agent Blythe that there are other data points we didn't make a slide for, and I really wish we would have made a slide for. gap, if you want to call it, between 9/11 and 10:02, because that also coincides with that truck coming back to Pablo Hamlet, turning into that gravel lot, and then disappearing from sight. So if there's a gap there, it also happens to be during a time frame when that truck can't be seen. I'm sorry, when Mr. Tenen is coming back to that truck. So the gap at 8 p.m., Mr. Fernandez's phone turns back on at 8:20. We know that truck pulls into Pablo Hamlet at 8 and then pulls immediately into that gravel lot. And then this time frame, 9/11 to 10 p.m., we know that is when, based on the surveillance, Henry Tenen is trying to get back to that truck, trying to meet back up with the person in the truck, to get his keys, to get his phone, whatever he's doing. And that time gap here happens to be when Tenen and that person are successfully meeting up, because Tenen got his keys back. We know that because he ended up at Potomac at the end of the night. And here is a view of the back of Mr. Fernandez's home. This is the lot for, the front lot for the Discovery School, and the headmistress testified today that there is also that lot, as Detective John said, near the retirement community and at the back of the school. So over this fence, through this lot, around the back, into that back gravel lot is a reasonable inference you can make from the available evidence. February 17th, who does Mr. Fernandez spend his whole day with? John Biggerstaff. And John Biggerstaff said to Mr. Dreiser on cross-exam that Mario Fernandez didn't tell him about this murder, even though we know Detective Burrell and Detective Lamont made that notification late that night. Mr. Biggerstaff said, I think he told me a couple days or a week later, after I'd seen it on the news, he said, the kid's dad died. But this whole day where he's driving around setting up chairs and tables for a wedding, according to his testimony, Mr. Biggerstaff's, doesn't say a peep about this humongous event in his stepkid's life, his wife's life, his life, doesn't mention it. And you can decide based on your analysis and weighing of how credible Mr. Biggerstaff is, if you believe that they didn't talk about it. If they were talking about it, ask yourself, what do you think they were saying? What do you think they were talking about? February 28th is a very interesting day as well in the timeline here. This is the day that the defendant, you saw in those bank records, transfers $50,000 from his flagship account to First Choice Home Rentals. $50,000 that should have gone to the Shanna Gardner Irrevocable Trust Fund, because he's getting disbursements from Shelley and Sterling Gardner, $75,000 in December 2021. He's the trustee of the trust. I would posit to guess, and you can use your common sense, that in-laws aren't giving their son-in-law a $75,000 present for Christmas of just because. You can assume as the trustee that that money was earmarked for the kids or for Shanna or for the trust. It's in his personal account, and on February 28th, he moves it to First Choice Home Rentals. February 28th is the same day he talks to the Jacksonville Beach Police and schedules an interview with them the following day. Remember, February 28th, March 1st. February 28th is the day before March 1st. So the transfer of the money is February 28th. February 28th, he speaks to detectives to arrange his interview. And February 28th into March 1st, he deletes 5,342 artifacts from his Google Cloud Drive. Now, individually, people who go meet with the police might delete things from their phone, maybe. Collectively, and in its totality, Mario Fernandez going to speak to the police about the murder of Jared Bridegan that occurred 2.5 miles south of his house on a date night deletes 5,300 items. And then March 1st, he's interviewed. March 2nd through 6th, there's this, again, on its own, fine, it doesn't prove guilt. Maybe you can explain it away. It's when you view it in this timeline that it becomes significant. He takes an unplanned trip. How do we know it's unplanned? Because he's Googling, mapping Pittsburgh on February 28th. That same day he's deleting, moving money, and arranging his interview. He goes to North Carolina. He also Google Maps North Carolina. He goes to visit a man named Victor Quiras that he has never met in person, who knows him by his video game handle who he's only spoken with via headset, and he stays on his couch. Then he drives to Pittsburgh, calls and gets a hotel for 2 nights, buys toiletry items, and then whilst talking on the phone, when you look at those phone records, to Shanna Gardner, Shanna Gardner's sisters, and Shanna Gardner's dad, Sterling Gardner, turns around and drives straight back without staying that second night in Pittsburgh, without staying another night back to Jacksonville. After his interview, while AB and LB are set to go have their interview with police. And again, taking a road trip on its own is not evidence of guilt. But when you combine it with the bookend of all those deletions and the moving of the money and his interview and this investigation, it becomes more significant, and you can make a reasonable inference from this. March 9th, the truck photos are released to the media. March 10th, Henry Tenen and Mario Fernandez have a phone call of 1,638 seconds, which is about 27 minutes, the day after that picture of Henry Tenen's truck is released to the media. A 27-minute phone call with his evicted, squatting tenant, the day after the truck is released to the media. Again, having a call with your landlord, or ex-landlord rather, on its own, not significant. But this number being much higher than any of their previous calls or any of their subsequent calls on that date is something that you can rely on in rendering your verdict. I included in the evidence with Detective Ostertag, who did the phones and the Google downloads, and the analyst, Lindsay Butler, some of the defendant's emails from 5239 Potomac. And I did that because there's a stark contrast between Mr. Fernandez's emails, calendar invites, invoices with Bueller Air Conditioning, and the complete lack of any documentation for these checks written to Henry Tenen for work. You will see those emails. You will also see that following the installation of a new air conditioning unit at Potomac, the defendant prepays, he buys a service package. And the service package is supposed to run from September 2022 to September 2023. He's doing this work on Potomac, and the reason that's significant or becomes significant is later, after Henry Tenen is arrested, and within 2 weeks, the defendant is calling home buying, flipping construction companies and short selling that house that he had a contract going the entire year to follow. This shows you that at least in March of 2022, before the police caught on to Henry Tenen, Mario Fernandez had no intention of selling that Potomac house. He was putting money into it. He was putting work into it. He was getting service plans. He had a lease with Jerry Ordway through December, at least. So that I'll talk about a little bit in conjunction with it later in the timeline. Then we get March 28th. We get the 2 checks that are dated. On March 29th, one of those checks is deposited. And on April 4th, the other check's deposited. And what Detective Johns was telling you, these are what he was talking about. When he's talking about check stubs, this is a bit from a business book. So you would have a book, this would be on the side, and then the checks would be to the right or to the left where you can see the perforation where they're torn out. You can see 27, 28, 29, they're not torn. The perforation is still intact. And it's possible, on its own that doesn't mean much, it's possible, like Mr. Dreiser said in cross-exam, that you could rip one out, and then rip the last one out with all 3 stubs attached and give them out that way. That's possible. But you have to look at it again in the totality. So these checks, Henry Tenen, $2,000 for landscaping and clearing. Unlike the checks Mr. Mizrahi showed you with Detective Johns for J.B. Coxwell, which is a corporation, actually sponsored the Jags, to Bueller Air Conditioning, which is a corporation with an email address and invoices, to Tri-H Construction, which is a corporation. He doesn't write what address on the subject line, landscaping and clearing, don't know where, I'm presuming Potomac. Keeping up with the roof, $3,000, keeping up with the roof. Not roofing, not replacing a roof, but keeping up with it. Repairing a shingle here or there, $3,000. And then of course the Kickstarter for $5,000. The Kickstarter, the business plan, the composition notebook from 2022, that also came with a bunch of his pay stubs and his payday loans and his child support wage garnishment paperwork. And there's been no evidence in any of their phones or any of their Google Drives or any of the investigation that there was an actual Kickstarter. July 18th, that tire is located at Potomac. Without that tire, we may have never solved this. Henry Tenen would have just been another name on a phone record. They never would have looked into him, gotten his phone, gotten his DNA, gotten his cell site. That tire is what solved the death of Jared Bridegan. I said in opening that it was a lucky find, but what I really mean is it wasn't luck. It was the hard work of the investigators in this case. The defense has conceded that Henry Tenen is the shooter. Henry Tenen that night was a man unconnected to Jared Bridegan in a car in an area with no license plate readers, with DNA on a tire that they could only match with a one-to-one comparison. It was almost the perfect crime. He almost got away with it. And Jack's Beach and ATF, all the investigation they did, all the, the cross-exam and the criticism of what they did or didn't do, they got it right. They solved the unsolvable crime. They did it by boots on the ground, by going door to door, by getting hours and hours and hundreds of houses of surveillance and locating that truck on camera. They did it by going and talking to people associated with the only people who had motive against Jared Bridegan. They didn't leave stones unturned. They didn't just not talk to people. It was a pain, and it's annoying, and it's tiresome to drive all the way from Jacksonville Beach to all these random places and hope someone has some information. And it's not luck, it was good detective work and a little bit of luck that led them to solving this. If not for that tire, this defendant wouldn't be here today, and you all wouldn't be sitting in that box. There it is. And there's the house, and you can look at the roof yourselves. We get to August 18th. Jacksonville Beach Police has taken their time with this investigation. They don't arrest Henry Tenen for murder just based on a tire. They arrest him for unrelated charges to further their investigation. They take a DNA swab from him. They recover a phone from him. They start sending out these search warrants to get his cell site data. And that is when they see the geolocation in Jack's Beach the night of the 16th. They keep investigating. That's when they see the cell site and geolocation going to St. Johns County on January 29th. So when Mr. Dreiser was asking Detective Johns about not getting surveillance in Nocatee in January of 2022, it's because they didn't even know who Henry Tenen was. They didn't have his phone number or his phone or his location data or his download until August of 2022. You're not getting surveillance 6 months later from businesses and homes in Nocatee. You're just not. They're lucky that they got what they got. They're lucky they found that tire. They're lucky they worked hard. They put their boots on the ground. They knocked on doors. They were able to identify that person, Henry Tenen. And guess what? How did they find Henry Tenen? They found him through the defendant. They found him through his call records, through his rental property. They found the killer through Mario Fernandez, not independently. And when they found Henry Tenen and began investigating him, Henry Tenen led them right back to Mario Fernandez. He's the connecting thread in all of this. This was a point that I wanted to connect for you because it came out through several different witnesses. August 22nd, 2022, Detective Johns went and spoke to John Biggerstaff. You will see in John Biggerstaff's texts that that day, he and Mario Fernandez met up in person. John said, the police came to talk to me. I was working at a school. You'll see in John Biggerstaff's text, August 22nd, Mario Fernandez and him texting the address of the school, where to park, where to go, how to meet up. And that the police came back later that night and they took John Biggerstaff's phone after he had gone and spoken to this defendant, after the arrest of Henry Tenen. And John Biggerstaff told you that Mario Fernandez had given him a heads up. They've talked to me. They might talk to you, and they might talk to my tenant. And when we got the download of John Biggerstaff's phone, even though he testified that there were years, decades of friendship with this defendant, and even though you can see in Mario Fernandez's phone, after the wipe, of course, and in Biggerstaff's phone, that there are hundreds, 70 text messages on the defendant's phone between him and Biggerstaff in the span of a week in August. there are no text messages between John Biggerstaff and Mario Fernandez left on John Biggerstaff's phone before May of 2022. And then, of course, August 26, 2022, Mario Fernandez factory resets, wipes his phone. Listen, I keep saying this. Wiping your phone in a vacuum doesn't mean you murdered somebody. Could mean that you want to sell it to T-Mobile, like the transaction they showed. Wiping your phone a week after your tenant is arrested, who owns a truck that looks like the one used in the murder, and you are told by police they're looking at him for murder, and then wiping that phone and keeping it, you have to consider that in its totality of what the significance of that is. September 5th through September 21st, the defendant, you'll see in his emails, he contacts a home buying company, Atlas Homes, and he makes these Zoom appointments on September 5th and September 7th to talk to them. And then by September 21st, about a month after Henry Tenen is arrested, the defendant signs a purchasing agreement for 5239 Potomac to quick sale it to Atlas Home Buying for $90,000 and asks to close remotely by mid-October. Mr. Dreiser put into evidence the defendant's post-nuptial agreement. In the post-nuptial agreement, the downtown house was valued at $70,000. August 2019. So he bought that house. It's worth $70,000. We know in March of 2022, he put $14,000 of work in it for that new AC unit. We know he's been doing work on it. So he turns around after years of holding this investment rental property and sells it. Its value is $70,000, at least that we know of $14,000 in work to it, $84,000, and he quick sells it for $90,000. After signing a year-long service agreement and a lease with another tenant. That's what you call distancing. After Henry Tenen is arrested, this defendant wipes his phone, sells his house, and tries to put as much space on paper and on land between himself and Henry Tenen as he can. That is consciousness of guilt. Hiding evidence, deleting evidence, distancing yourself from evidence is evidence of guilt itself. October 6, 2022, before the remote closing on the 12th, there is a search warrant executed at 5239 Potomac by the ATF and Jack's Beach Police. The house, here you can see the garage, the roof, the landscaping, the old pallets junked in the back, appears to be in a state of disrepair. Despite the poll cam footage showing bringing in buckets and brooms and bags of unknown items, there is no tile in the majority of this house. It's been ripped up, the sink is off. And then it states 205, this is what Potomac, 5239 Potomac looks like. This is a Google Map photo of March 2025, after the Atlas home buyers bought it, looks like renovated it. So this is, using your common sense, you can decide how much money you think that roof costs and that landscaping costs to make this house look like that. October 14th, the truck is recovered. The truck that matches the truck from these still shots in the surveillance states 91. And Mario Fernandez at this point is living in Orlando, and we know from the teacher, Ms. Meredith, that Mr. Dreiser called this morning, that Ms. Gardner is living in Washington State with her children. She was able to, after Jared died, to have no further legal entanglements with him. She filed that death notice in their family law case, the one that Kirsten Bridegan testified that she asked Kirsten for Jared's death certificate less than 2 weeks after his death. She got full decision-making authority. She got more custody. She got her children and her freedom, and she packed her belongings and moved to Washington. And the defendant, according to Ms. Meredith, never saw those stepkids again. And in January of 2023, Jacks Beach Police has concluded their investigation. They have Henry Tennant's cell site. They have the videos. They found him on scene. They've collected items from the house, a pair of boots, a jacket. They found his truck with those check stubs. They found this boot box. And you get to decide, by the way. Detective Johns doesn't get to tell you. I don't get to tell you. Defense doesn't get to tell you. You get to watch those videos and you decide if those boots look like the boots Henry Tennant was wearing. The size, the appearance, the trim. You get to decide if that's the jacket he was wearing. You get to decide if this boot box belongs to these boots or some other boots in a photo, even though those boots don't have that black trim on them. You get to decide it. You're the finders of fact. And in the end, it doesn't matter because nobody here is disputing that that man on foot with the gun that shot Jared Bridegan is Henry Tennant. It just is a bad fact for them that Henry Tennant's clothing that he wore the night of the homicide is still at 5239 Potomac, even after he's been arrested and is in custody. At that point, the house that Mario Fernandez still owns and is doing work in and is trying to sell. And these clothing and shoes, they're collected months and months and months and months after the homicide. And if you watch that video, you see the shooting and you see Henry Tennant walking and then running away. So there is not much evidentiary value in these items because they've been in a dirty garage or in a closet months later. There's no evidence that Henry Tennant would have had any of Jared Bridegan's blood on him. He shot him from some distance away. You heard that from the ME by the lack of soot or stippling. So they collected everything at the time. They collected everything and they went and we put into evidence and you get to decide what value to assign it. But regardless of what you think, it doesn't change the fact that Henry Tennant shot and killed Jared Bridegan. And it doesn't change the fact that this whole timeline is replete with evidence as to this defendant's involvement. So January 25th, 2023, Jacks Beach has done an extensive investigation, including finding Henry Tennant's DNA on the tire from the crime scene, the steering wheel of the truck, and the keys that unlock and turn that truck on. And there is a media announcement planned to get people talking on this wire. The people on the wire are going to be the defendant and his wife, Shanna Gardner, and these other people. And we heard some calls between this defendant and his friend, Carlos Fong. And on January 25th, the media announces there's a break in the case and there's going to be a press conference. And the defendant's statements to his friend.
How many times I've had a discussion with like, I've just had random discussions with strangers on top of that, with strangers. Yeah. And then like, I've had people that knew him when he was like younger, you know, when he was in like high school or something like that, because he grew up here in Jacks or whatever. And they were just like, I get it. And I was like, get the fuck out of here. Like, now you're coming out and saying some shit, but this.
He's talking with his friend, and he's saying that Jared was a jerk, and he knows people from Jared's high school and Jared's church, and they are talking bad about him. And he's saying that people are coming up to him saying, I get it. Get what? That's a weird thing to say when you're talking about to your friend after the media just said, hey, we have a big break in this case. But again, a statement on its own doesn't mean anything. It's the totality of all these statements on the wire call. It's what he said and what he didn't say on these calls. What he says is that he denies, go back and listen, he denies really having that much contact with Tennant. He tells his friend, I'm trying to remember conversations I had with him, any conversation that I had with him. He was a tenant. I kicked him out. He did some work for me. He doesn't mention we had phone contacts 70-something times during the 2 months the homicide occurred and right after. He doesn't mention that he continued to let him squat in the apartment even after he was evicted. He doesn't mention that he would go to the house and be there when Henry Tennant was there. That is the next day after they announced the arrest of Henry Tennant. He also talks about the work that Henry Tennant did for him. He doesn't tell Carlos Fong that he paid Henry Tenen $5,000 for landscaping, clearing, and keeping up with the roof. What he tells him is he gave him money to do some clearing and to mow that bee down. But listen to how Mario Fernandez talks to his friend about how much he's willing to pay for yard work.
Just to do, like, somebody gave me an estimate for a single tree, and it was like $3 grand. And I was like, yeah, no, go fuck off, dude. No fucking way. You know what I mean? So I was like, hey, you want to fucking knock off some branches and fucking plow this bitch to the ground? And that's what he fucking did.
What he didn't say is I paid this late day laborer, homeless man who's squatting at my residence $2,000 to take down a tree, but I wouldn't pay a reputable tree service's invoice for $3,000. And look, I get $1,000. It's a third difference, but it's not like he's paying Henry Tenen a couple $100. This is a significant amount of money, especially given what you know about Henry Tenen's income.
And however they're going to want to.
One of the things he says on the wiretap is he's talking about how the media has been portraying it. But what he's saying is that from the outside looking in, how people see this situation makes sense. Even the defendant is acknowledging like the reasonableness of this motive and the reasonableness of this story. From the outside looking in, that he understands. He says in the first wiretap call, they were looking at us for obvious reasons. Even to him, his attorneys can argue all day they have no motive and it doesn't make sense. Even he acknowledges it makes sense that the media is looking at us. It makes sense the police is talking to us. The police are talking to us.
And however they're going to want to paint it, and then obviously it comes down to whatever the fuck, you know, is said afterwards. So it's a 50-50 swing looking at it that way. But the other part is it's actually not even. It's more like a three-way split, because then it was there's this guy, then there's me, then there's Shanna.
He's acknowledging that he, from the outside looking in, is the link between Shanna Gardner and Henry Tenen, this person they just arrested for killing her ex-husband. Carlos Fong does something interesting on these calls, which is that he gives this defendant these like softball explanations to seize on. Like, listen to it. He says, hey man, maybe this guy, Tenen, thought he was killing you, not Jared. Maybe he's got beef with you. And this defendant says, nah, that's not it. No way.
I guess something broke out today about that whole situation we talked about.
Mm-hmm.
So they arrested some guy that used to rent the Northside house.
I know.
I was like, what the? So I guess he thought it was you. Because I think the motive was after you, not her husband. Her ex-husband.
Yeah.
I'm like,
Or,
yeah.
oh, dude, no way. You think so?
But he rented your house, so he must have had some he probably didn't pay you, kicked him out or something like that.
I mean,
remember this, you know, there's a possibility of that area.
Right.
Yeah.
There's no way though. Like.
So his friend is telling him, you know, maybe he had a motive that we don't know about. And the defendant's telling Carlos on that recorded wire call, no, there's no link between Jared and Henry Tenen. Carlos asked him, did he ever see a picture of him, meaning Jared, as an explanation of why Henry Tenen would know who to kill. And Mario Fernandez says, no, I didn't talk to Henry Tenen about Jared. I didn't leave a picture of him around. That's what their conversation is. I know it's hard to hear. When you go back there, you'll be able to listen to it better, but he's giving him these explanations of innocence, and the defendant's saying, nope, that's not it, bro. It doesn't make sense. No way.
I'm on.
That's the, you wouldn't have had any pictures of him, meaning Jared. He says, yeah, no, F no. The other thing that's interesting about these wire calls is that what the defendant doesn't say to his friend. He says, I gave him some money for tree work and roofing. He never tells his friend, I also made an investment in this guy's company. I gave him a charitable donation. I gave him some Kickstarter startup money. He doesn't say that to his friend because it doesn't make any sense. His friend's giving me all these theories that don't make sense. He doesn't say that. That is important. He doesn't say it because that check does not make sense given what you know about Henry Tenen and given what you know about this defendant. What he doesn't do, he is talking to Carlos Fong that first jail call about him and Shanna separating, but it was amicable, it's fine. The media announces, we are about to make a big break in this case. And then they announce the killer of Jared Bridegan is Henry Tenen, the tenant of First Choice Home Rentals, an LLC owned by this defendant 60% and Shanna Gardner 40%. What is the first thing in your mind you think someone in that position with that relationship would do when they hear, they caught the person, there's a big break, there's an arrest, this nightmare's over? He never calls Shanna Gardner, and she never calls him. Why? They've arrested someone that knows them, that killed the father of her children, the father of his stepchildren, when the media has been blaming them, and they don't call each other because it's not surprising to them. It's not new information, and they don't want to be in contact with each other. Mario Fernandez and Shanna Gardner want that distance between them. February 6, 2023, we seize the defendant's phone, we see it's been wiped. And then March 16th, he's arrested. June 4th, 2023, we had that very, very strange testimony from Juan Biggerstaff about a burglary of what he called the worst pool car in the entire Irving Police Department. Was stolen out of his driveway in a suburb of Dallas and abandoned a quarter mile down the street. And he made a report that the only things taken were his service weapon from his time as a police officer and a firearm with a serial number that happened to match the serial number of his father's unaccounted for Glock 10mm firearm. Between Fred Barton, John Biggerstaff, and Juan Biggerstaff, there's truth somewhere, and you have to ask yourselves, who's telling the truth, who has an interest in lying, who has an interest in protecting themselves, their friends, or their family? Who ended up with those 10mm firearms? Fred Barton said it wasn't him. Does Fred Barton have a reason to lie to you about that? Does Juan Biggerstaff have a reason to alibi his father's gun for him? Does John Biggerstaff have a reason to lie about where that firearm is? Because it is a Glock 10mm that's used in this homicide. And a few words about a Glock 10mm. It is not a one and only gun in the world. I'm sure a lot of you are gun owners. Everyone understands that. We live in a capitalist society, and guns are products. So they make them, they sell them. But it's not that common. It's not a 9, it's not a 40. And if it had been a 9mm or 40 used in this, we may not have had all this evidence, we may not have solved this. But when Mr. Mizrahi asked John Biggerstaff, a self-proclaimed gun enthusiast, do you know anyone else that owns a 10mm? John Biggerstaff chuckled. He laughed and said, no. I don't know anyone other than myself that owns a Glock 10mm. Other than the shooter, of course. A convicted felon shooter with no money in his bank account and nowhere to lay his head is somehow going to procure a firearm that has value, that is not that common, not like a 9mm that's passed around the streets easily. The murder weapon has still never been recovered, but Juan Biggerstaff accidentally writes the serial number down wrong on a police report, a police officer. And he testified that he did so because he used that record to make his police report. Juan Biggerstaff, a police officer, doesn't keep a log of his own firearms, including his service weapon and other weapons he owns, like a list of them in his gun safe with his ammo in his gun, like most firearms owners. Instead, he wants all of you to believe that he kept a barely legible handwritten copy of his dad's 2016 federal firearms affidavit as the reference point for him, that he kept it all those years to remember what serial number he has for the 4 guns his dad gave him. It is clear that if John Biggerstaff gave that firearm to Mario Fernandez to give to Henry Tenon, wherever it ended up, nobody can find it. And if we had it, we could compare it to these shell casings and we could exonerate John Biggerstaff. But we can't. People don't get rid of evidence that's helpful to them. People don't get rid of evidence that's helpful to them. Guns don't just disappear. They're valuable. They're dangerous. Police officers aren't so uncareful with their weapons. And plenty of convicted felons possess firearms and don't get caught. Plenty of people don't take a magistrate's order seriously. That's clear because John Biggerstaff didn't really take it very seriously on pretrial release, said he shouldn't do drugs. Because he ended up going back into custody and serving time. So just because a magistrate or a law or a judge tells you not to do something doesn't mean people do it. Otherwise, I wouldn't have a job. I wouldn't be standing in this courtroom talking to juries like all of you. Agent Mick Stengel, a firearms instructor from the Bureau of Alcohol, Tobacco, and Firearms, also testified that in 18 years of experience, he's never seen another 10 millimeter in a case. Knowing someone who owns a 10 millimeter by itself doesn't make you guilty. In the totality of it, you decide what significance to assign to all of this. The evidence together proves that this defendant was involved. He wanted Jared dead. He solicited Henry Tenon to do it. He asked for help from John Biggerstaff, whether planning or provision of the firearm. He incited it. He encouraged it. He assisted it. He is guilty as a principle of murder, and he is guilty of solicitation for the ask, for the act. Later this afternoon, after your lunch break, you will hear argument from defense counsel, and then Mr. Mizrahi will have the opportunity to speak to you again. I anticipate that the argument will be that there is no DNA that connects Mario Fernandez to that crime scene. There is no witness that puts Mario Fernandez at that crime scene. There's no surveillance that puts Mario Fernandez at that crime scene. There is no photos or DNA or evidence or ballistics testing that put a 10 millimeter firearm in the hand of Mario Fernandez, handing it to Henry Tenon. And that is because of the nature of this crime. The almost perfect crime, designed so that there would be no link to this defendant, designed so he would never get caught. How can I show you a text between Mario Fernandez and Henry Tenon about murdering Jared Bridegan when they have deleted all of their texts? How can I show you the geographic location of Mario Fernandez the night of the homicide if he has turned his phone off?
Do you want to be heard?
No, Your Honor.
Okay. I'll sustain it.
Henry Tenon is not available as a witness in this case. Henry Tenon and Mario Fernandez committed this crime together, and Henry Tenon can't be here to tell you about their conversations. There would be no way in the world this defendant would write murder on the subject line of a check. Of course, he would launder the money. Of course, he would make it look legitimate. Of course, he would hope and pray and expect that the Jacksonville Beach Police Department would just never, ever, ever figure out it was Henry Tenon and never figure out the connection to him. If you outsource your murder, you are doing it so that your DNA and your footprints and your fingerprints are nowhere near the crime. When I spoke about the defendant and Ms. Gardner being the architects of Jared Bridegan's murder, that's exactly what I mean. If you are an architect, if you design a house and pay someone to do the painting, of course, there is not going to be the architect's DNA on the paintbrush. There's not going to be surveillance of the architect buying the supplies. There's not going to be a witness saying, I saw the architect painting this house. That's what solicitation in principle means. That doesn't mean that the architect didn't plan it, want it, finance it. It doesn't mean the architect wasn't satisfied with the outcome. Individually, you can explain anything away. But a reasonable doubt is not a possible, speculative, imaginary, forced doubt, a guess, conjecture, or proof beyond all doubt. There is always some possible, hypothetical, made-up explanation for something. But you cannot go down that path. You have to look to the evidence and the testimony and your common sense. All of the evidence. This is the last portion, and then I'm wrapping up, I promise. The Getty Museum in New York City did this exhibit on textiles. What they did was they showed microscopic views. So what you see here is a fabric, and when you look at it under a microscope, ancient fabrics, you can see the minor defects, the imperfections in the threads, the weaving, the wear and tear over time. And then in the exhibit, when you pull back, you see how the threads are woven, how they connect, and what the tapestry shows. The law does not require a microscopic view of the evidence. It does not require proof beyond all doubt. It does not require perfection. No matter what you look at individually, how close you look at it, when you step back and see how it all relates together, the witnesses, the testimony, the motive, it is clear that it makes sense. No matter how much you look at these individually, you are going to keep coming back to this conclusion. You can test it, you can argue it, you can play devil's advocate, but there is no other conclusion that makes sense other than this defendant had Henry Tennant killed Jared Bridegan. It is unexplainable in any other way for all of these to add up together. And if you think that there is no reasonable doubt that he aided, encouraged, incited, solicited, or was there that night, then you have a duty to find him guilty. And that brings us to your verdict, which is the truth. For those of us that do work in homicide, we have an expression. To the living, we owe respect. To the dead, we owe the truth. Your verdict will forever define the death of Jared Bridegan and the responsibility overruled. It will forever define the death of Jared Bridegan and the responsibility and culpability under the law of those that planned it, of those that wanted it, and of those that made it happen. The shooter was a stranger. The murder was personal. This defendant is that thread that runs through that whole tapestry, and no matter where you yank it will not come unraveled. It all comes together, and it all connects through him. Find him guilty as charged.
Thank you, Ms. Stifler. Members of the jury, we're going to take our lunch recess and return back for the remainder of the closing arguments. I'm going to remind you that at this point in time, since closings, I'm going to restrict the phones. Mr. Holman, I'm going to restrict the phones, okay? You can have your lunch recess, but because the evidence is being summed up, I'm going to restrict your phone use while we're in session today, okay? Leave your notepads on your chair. Follow the communication rules over the recess, and I hope that you all enjoy your lunch. All right, please let the record reflect that the jury has left the courtroom due to the extended nature. Normally, everyone may be seated. So generally speaking, when we close cases down, I wouldn't have given them access to their phones, so I'm not going to give it to them over the lunch recess. Was there any objection to that? No. All right. So after the lunch recess, we'll call this, it's 12:22, we'll call it 12:30. We'll return back at 1:30. The defense will be set up for a closing argument. Okay. If there's something that comes up, let me know. You all enjoy your lunch. Court's in recess.
should be audio right now.
So it's not supposed to take, you say 18 piece, you're not supposed to take the whole game. Leave the little piece on the,
Is your computer audio? It's not on your computer, it's on here. Yeah. Oh, we did hear
my son just said, this girl. So now my little one says that now. Or he'll be like, Daddy, can you give me some juice? And I'm like, yeah, baby, I can some juice. She goes, good boy. Oh my God. And then Chase is dying on the couch. I said, you taught her that shit? Yep. Where you got it from? So now I do it back. And she's like, no, I'm not a girl. I'm a sister. Yeah. She can lie. I mean, she's telling the truth.
In her head, she is absolutely correct.
Yes.
She's not wrong.
an audio issue.
She is not wrong.
Do you just want me to do it?
Oh, that part.
Yes, that part, then leave.
What about them?
Yeah, nobody said her name.
So the volume's on the way.
Thanks, sir. Was that Mike Smith? He's on his way.
Thank you. Check the other one too.
What else was there? Sure.
Question. Do the TVs need to be out? But no, because they're still playing even on the screen. Okay.
Who's playing? Anybody? Anybody? Right?
Off the screen, no source. No source. Okay. To get it back on, public shut. Something happens, you know, I gotta get this off. No source. And to get this shit back on.
My clipboard right there back. You put it over there back there and all.
This is such a friendly little guy.
Oh, you already here?
Thank you. Good afternoon. Is the defense ready to proceed?
Yes, Your Honor.
Anything we need to take up?
No, Your Honor.
Okay, thank you. Let's bring in the jury. Thank you. Welcome back, members of the jury. Everyone may be seated. All right, members of the jury, the defense will now present their closing argument. Mr. Dreiser?
May it please the court,
Yes.
counsel, members of the jury. Jared Bridegan was murdered. Henry Tenon murdered Jared Bridegan. Mario Fernandez had no motive. He had no desire. He had no reason, and he certainly gained no benefit from the death of Jared Bridegan. In the first 15 seconds of Mr. Hill's opening statement to all of you, that's exactly what he said. And it rings as true at the beginning of my closing statement to you all as it did when Mr. Hill told you that. Because what he told you was that the evidence that you had not seen yet would show that Jared Bridegan had been murdered, that Henry Tenon had murdered Jared Bridegan, and that there would be no reason for Mr. Fernandez to do this. And after you've seen all of the evidence in this case, and you've been presented even with the first closing argument, Mario Fernandez had no motive to do this. He had no reason to do it, and he got no benefit. So I'd like to walk you through what we expect the judge is going to read you, the law in this case. And then I'm going to walk you through all the facts we heard so we can determine whether or not the government met their burden, whether they told you just a series of half-truths every single day and didn't tell you the whole story until we would get up and ask the witness questions, get the whole story out, the whole picture. So let's walk through what I expect the law to be. The law is so important in this case because you have to take all of the information that you heard and with no doubt in your mind, in order to convict Mr. Fernandez, each and every one of the elements we're about to go over must be met. And I found it so important that we don't ever hide the law from you, that during my entire closing statement, the law will be right here, right behind me. So at any given moment, if you want to ask yourself, was there actually any evidence that Jared Bridegan is dead? Of course there is. That is not in dispute. There is no reasonable doubt that Jared Bridegan is dead. The death was caused by the criminal act of Mario Fernandez. There's all the reasonable doubt in the world that this criminal act wasn't caused by Mr. Fernandez. The state has told you that Mr. Fernandez did not do any act that caused Jared Bridegan to die. And there was a premeditated killing of Jared Bridegan. While we're walking through, you have to determine whether there was a premeditated killing that Mr. Fernandez, prior to the murder, wanted Jared Bridegan dead. So we know that Mario Fernandez did not kill Jared Bridegan. That is not in dispute. So then the state attorney relies on what is a principal instruction. And the principal instruction says, if Mario Fernandez helped Henry Tenon commit a crime, then he's a principal, and he must be treated as if he had done it. So I'll concede that they're going only on the principal instruction because clearly Mr. Fernandez did not kill Jared Bridegan. So how do they do that? What do they have to prove to you with no doubt? What must you be convinced of at the highest level of our justice system that you will leave this courtroom with no doubt in your mind, that you are convinced beyond all doubt? You have to know that Mario Fernandez intended for this crime to occur. So when we're walking through the facts this afternoon, ask yourselves, what single fact before February 16th of 2022 did you hear one witness say that Mario Fernandez wanted this crime to occur? What witness took the witness stand and said, or heard, or a wire call, anything, any piece of evidence where you heard Mr. Fernandez say, I want that son of a bitch dead. I'll do anything to kill Jared Bridegan. I hate him. He deserves to die. Any number of disgusting, foul statements that we always hear in murder cases. Ask yourselves, what one singular statement did you hear so that you could know beyond all doubt that Mr. Fernandez intended this crime to occur prior to February 16th?
Your Honor, I'm objecting to misstatement of the law for the third time.
You want to be heard?
No, I'll reread the instruction, Your Honor.
So I'll sustain the objection.
The defendant intended the crime to occur. And then second, the defendant did not act, did some act, or said something that was intended to, and that did incite, cause, encourage, assist, advise the other person to actually commit the crime. That's what the judge is going to read you. That's what you have to know beyond all reasonable doubt. And while we're walking through this, please ask yourselves over and over again, what fact did we hear that Mr. Fernandez did some act that encouraged or caused or assisted this crime to occur? That you heard on a wire call, that you heard a witness say that he did, that he incited, that he did any of these things. And then the second charge is criminal solicitation. And in the criminal solicitation count, the government has alleged that on between November 1st and February 16th of 2022, right off the rip, what evidence did you hear in this case about anything that happened in November of 2021? What one piece of evidence did you hear of anything that happened in November? And I'm going to submit to you there was none. What one piece of evidence did you hear in this case that anything happened in December of 2021? Why has the government alleged that there's some period of solicitation when they didn't show you one single piece of evidence for 2 months? And then I'll concede the first piece of evidence that they showed you during this time period is somewhere around January 5th, and we'll talk about that. But you have to ask yourself while we're walking through these facts, and most importantly, while you're deliberating, what one piece of evidence did you hear? Go back, please. That Mario Fernandez solicited Henry Tenon to commit this offense. What call? What text? What meeting? What witness? What did you ever hear that Mario Fernandez solicited Henry Tenon to do anything? I'm going to submit to you, you didn't. It did not happen. There was no evidence. And when they say the checks are post the homicide. Checks There is no check, and I very carefully went through, and we'll talk more about the checks, but just to give you some.
Mr. Dreiser, pause for a moment.
Flash for a second. Take your time now. It's all the way down. The floor. It's just a loose connection.
There you go. There you go. There you go. There you go.
I won't touch it. I'll touch it. No, leave it. I gotta be able to see it. Thank you.
May proceed.
Thank you. So first, they have to prove to you that Mario Fernandez solicited him in some way. Before the homicide, he went to him and said, hey, I want you to commit this particular crime. And there is no evidence whatsoever of a conversation, a solicit, a meeting where a solicitation took place. None. And then, on top of that, they have to prove to you, convince you, so that there is no doubt in your mind that during that meeting, that solicitation, that time period, that event that they've never been able to prove to you happened, that Mario Fernandez commanded, encouraged, or hired, or requested Henry Tenen to engage in this specific conduct, which would constitute first-degree murder. They first have to prove to you that there's some meeting that took place that you've seen no evidence of. And then they have to tell you exactly what happened at that meeting or during that call.
Objection, Your Honor. It's a misstatement of the law.
This is my argument as to the
Hold
element.
on. Let me see your sidebar really quick. Right, I overrule the state's objection. You may proceed.
Thank you, Your Honor. The law that's been in front of you this entire time says is that they have to prove so that there is no doubt in your mind that Mr. Fernandez solicited Mr. Tenen to commit this crime, and then the specifics of what happened during that solicitation. They have to prove to you that Mr. Fernandez in some way commanded, encouraged, hired, requested to engage in this specific conduct. And that's what the law is. It will be behind me the entire time I give my closing argument, and I ask you to think to yourselves, what evidence did I hear at all that I could know without any doubt in my mind that these crimes were committed and that every element has been satisfied by the government? There is no question that the facts of this case are sad. There is no question that there was a child in the car. There is no question that an innocent man was gunned down in a dark street on a night in which he least expected it. We concede that fact. We don't dispute that fact. And what the judge is going to read you is that although those things may be true, and we're not asking you to ignore them, when you go back to deliberate, you can only decide this case upon the evidence that you have heard, the testimony of the witnesses, and that you've seen in the form of exhibits and testimony and evidence. But this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on evidence and the law contained in those instructions. So although we concede how sad this case is, the judge is going to instruct you that you cannot take those feelings and use them in any way to be biased or prejudiced against Mr. Fernandez or the evidence that is or is not applicable to him. So real briefly, we started this case with this family law motive that Shanna and the history of their family law case. So very briefly, Shanna and Jared Bridegan got married in 2010. That's the history. 2 twins were born of this marriage, AB and LB, in 2012, and Shanna filed for a petition to dissolve her marriage with Jared in 2015. The court entered a consent final judgment ordering equal time sharing. And although that doesn't seem like an important fact of this case, it may be the most important fact, because as the state has told you, the motive for Mr. Fernandez to commit this murder is because they weren't happy with the child custody arrangement. But the fact is, the evidence in this case is nothing consistent with that fact. Because when Shanna and Mario get married, that's in 2018. So all of what we just went over before, Mr. Fernandez didn't even know about. It wasn't facts that he was aware of. But he does get married, and over the years, there are modifications and changes. And we went through those together, and every single one of them is in this binder. The entire docket sheet is in the binder, and all the applicable pleadings that we talked about and the state was free to put into evidence, any that they talked about, not one time does Shanna Gardner or Mario Fernandez attempt in any way to change the custody agreement between Shanna Gardner and Jared Bridegan. They're right. They did argue once over who should pay for an oxygen machine. Ms. Stifler said they litigated that issue. No, they did not. I showed you that pleading, and then I quickly showed you that they came to an agreement, meaning they asked the court for litigation, and then the 2 parties on their own decided who to pay for it, and they agreed. No question that not one single time did Ms. Gardner ever say, I think it would be better to take away time sharing from Jared Bridegan. Never. Not one time. And in fact, I showed you that in the pleadings in which they did talk about time sharing, she repeatedly asked the court to keep a 50-50 time sharing. And in one pleading I showed you, she went out of her way to say, it's working really well. We just want to switch the days. So when you hear the rhetoric that this is about a child custody battle, What you should be hearing is that when Ms. Gardner or Jared Bridegan had any issues that they wanted changed, they went to court. They filed pleadings, and they either agreed on their own, which is what happened in every single situation, or their intended purpose was to ask the court to rule. You didn't hear one time that there was any self-help where Mario Fernandez threatened Jared Bridegan, said, if you don't agree to this, I'm going to do this to you. And in fact, this family law case had been closed for over 4 months, completely closed, with no filings prior to the homicide of Jared Bridegan. There wasn't a single family law dispute going on at the time of the homicide. I thought it would be helpful when we go through all the witnesses. I would show a picture so it would help us do a visualization of who we're talking about and what they said. First witness, if you may recall, was Miss Cruz. She was a scene witness. She got there. She placed a 911 call. It's obvious she didn't know what had happened. She took great care of BB. She did not see anyone leaving, and we asked her no questions. Because as we promised you in the beginning, if we didn't think it aided you in determining the law with the facts of this case, we did not want to waste your time. Then Mr. Borgia took the stand. He was also a scene witness. He didn't see anyone leaving, and we didn't ask him any questions. The next witness was Sergeant Smith. He was a responding officer, and what I noted from his testimony is he just said how dark that road was and how dark that road was. And you have to ask yourself, why was it so important that they kept talking about how dark that road was? It's because the government cannot prove to you who the people who are involved in this crime were. They don't know who was driving that truck. So they want it to be known how dark it was. But then when I got up, I said, it's not dark all over Jack's Beach, is it? And he's like, no, there's street lights all over Jack's Beach, isn't that correct? Yeah. There's surveillance at the police station. You can see just fine. That's correct. Because there's plenty of light in Jack's Beach to determine, if they could, who was involved in this crime. And what the evidence in this case is it's not Mario Fernandez. It's Henry Tenen and an unknown person who was driving that truck. We'll talk more about that. Then you heard from Ms. Bridegan. Ms. Bridegan told you that there were thousands of text messages in a group family chat, meaning that they communicated regularly. Shanna Gardner, Kirsten Bridegan, Mario Fernandez, and Jared Bridegan. Not one single threat of violence. She couldn't articulate one time where there was an act of violence, that Mr. Fernandez did something that made her nervous or made her afraid or said something threatening, like, if you don't drop the kids off at this time. Because I asked her, what were they mostly scheduling? And she said, yeah, medical appointment stuff, yeah. In thousands, there wasn't one time where this alleged murderer he just kept his cool all the time. He never one time made a threat. One time did an act of violence that she could articulate. No physical confrontations between Mr. Fernandez and Jared Bridegan. I said, did he ever report to you that he threatened him or confronted him? No. She showed that the family law case was closed 4 months before. There was no arguments about this upcoming baptism. She said Mr. Fernandez and Ms. Gardner were calm about it. Ms. Gardner took AB dress shopping. And this is an important fact. I said, did you go over to the Fernandez residence the day after this homicide? She's like, I did. I asked if I could go over there so we could all deliver the news to the children together. And I said, did they agree? And she said, yes, they did. They invited Miss Bridegan into their home at her request, meaning she wasn't afraid of Shanna Gardner. She wasn't afraid of Mario Fernandez. She asked, can I come into your home? Can we do this together? And they said yes. They included her in that. But what you later learned in the interview of Mr. Fernandez where I'll admit he is a little angry. He is a little uncomfortable about what happened, because with the grace that they showed Miss Bridegan, she did not in return. She would not allow Miss Gardner to attend the funeral of Jared Bridegan with her daughter. And there is no question that after the grace Mr. Fernandez and Miss Gardner showed Miss Bridegan, she did not return that grace, and he was frustrated about that. And then they made a big deal that there was a suggestion of death filed in this case. Per the rules of Florida court, when there's a child in the family law system and there are pleadings regarding those child, you file what's called a suggestion of death, letting the court know that one of the parties had passed. That is all it means. It doesn't mean anything else. You heard from Dr. Gillespie. He was the medical examiner in this case. He confirmed what we've all been talking about, that in fact Jared Bridegan was murdered, and we asked him no questions. Then you heard from Detective Jarman. He was an evidence technician who went to the scene. He talked about what the scene looked like, what he had did. He had done a walkthrough. He said a picture is worth 1,000 words, and that's why it was important for him to videotape in case it had any evidentiary value. And he participated in carefully collecting DNA from the scene. Next, we heard from Corporal Wallace. This is the witness who compiled all of the surveillance in this case. He headed up the task force of people that went from business to business, from residence to residence, to collect every piece of possible surveillance that they could find in this case so that they could attempt to connect Mario Fernandez to the homicide of Jared Bridegan. And he told you just how carefully he had done that. And they had, on direct examination, they had asked him, well, what do you convert times to make sure everything lines up? Yes, I took great care to do that. I added up times. I subtracted UTC to format it so everyone could get a good idea what's happening. And of course, the video was wrong. First question I asked him, sir, you said that you took great care and precision to do this. Do you think precision is important? Yes, I do. You think accuracy is important? Yes, I do. You agree with me that this video is incorrect? Yes, it's wrong. Well, what's wrong? Is it not the truck that's pulling out, or is it the time? Oh, it's the time. On the video, if you recall, before I got up on cross-examination, it looked like the truck pulls out, and then they show a map, and then they showed it on fairway. But it wasn't until we got up. There's 36 minutes that we had to tell you, you have no idea where that blue truck is prior to the homicide. When that truck pulls out of Pablo Hamlet for 36 minutes, you don't know where it is. And then I went out of my way to say, okay, well, the state's alleging that there's no surveillance at a gravel parking lot. Were there any reports that a vehicle was in that gravel parking lot? No, sir. You had mentioned that there's a long street along the golf course where there's no surveillance. You had mentioned that that's a busy road at 7 o'clock, 8 o'clock at night on a Wednesday night. That's 15th. That's right. Did you get one report, one Crime Stopper tip, any information that a Ford F-150 that's been blasted on the internet and the news was just randomly parked along that way? No, no information. So this whole time, the government gets up here and they're like, Mr. Fernandez didn't report the F-150. Mr. Fernandez didn't report the F-150. Nobody reported the F-150. Jimmy Jones, where the truck was found, didn't report an F-150. It's because there are thousands of F-150s, and the surveillance really wasn't all that clear that was released to the media. But there is no evidence that in this case, a truck, an F-150, two-toned in color, on the night of the homicide was anywhere near the Fernandez residence, anywhere parked on the roadway, and certainly not at the Cradle Creek Preserve. They just throw these things out there, and they expect you to say, well, it could have been. Now, it's interesting, when they want to do could-have-beens, they say you can't do that. The jury instruction is going to tell you it's not a forced doubt, it's not a speculative doubt, it's not an imaginary doubt, until they want you to fill in the gaps of the evidence and say there's a blue truck parked at a gravel parking lot. No evidence of that whatsoever. They just want you to believe that without ever giving you a single piece of evidence that that's true. Today, in the beginning of Ms. Stifler's opening statement, she said, you can believe that, and you can believe that. She was like Oprah Winfrey handing out vehicles. You get a car, you get a car. It's not how it works. It's not you get to believe this, you get to believe that. We have evidence. That's what all of this is. They spent 6 days trying to establish that Mr. Fernandez participated in this crime, and that's what you have to know. You have to know, or at least be presented with something so that you could believe that during that 36-minute period of time, Mr. Fernandez had something to do with this crime. But the answer is they just don't know. They have no idea where that truck was. They have no idea who was in that truck. And they just want you to guess or fill in the gaps in your mind. Ms. Stifler told you very on in her opening statement this morning, you can use reasonable inferences. I'm going to tell you that I'm going to read a lot of law to you, and when I'm done and Mr. Mizrahi's done, the judge is going to read you a bunch of jury instructions. You listen. See if you ever hear the word, you can take and use reasonable inferences. See if you ever hear that this afternoon, because I submit to you, you will not. You will never hear the judge say, yeah, you can just do reasonable inferences and jump from fact to fact. That is not something that you're going to hear. That's just something that they told you because they want you to do that, because they didn't meet their burden in this case. The next, and I wasn't trying to be a stickler about all the little mistakes in this case, but my client is charged with first-degree murder, which is the highest crime that you can be charged with in this country. So when they make all the mistakes about the times that we have to point out, and it's in evidence, and when you look at the CD, it says, State of Florida, State Lieutenant Gardner Hernandez. They don't even get his name right. And is that the biggest deal in the world? No, but it's one mistake after the next mistake that we have to keep pointing out to you because the government was careless. They're not taking the time to make sure that in this case, all the T's are crossed, the I's are dotted, and that they have their evidence in order. It's just one mistake after the next. And then it shows, after we corrected it, that it's 8 o'clock when the truck pulls off. And we're going to talk about that a little bit more. Pablo Hamlet is on surveillance. It runs all the time. And they want you to believe that that's the area of interest. But yet, you never see Mr. Fernandez at Pablo Hamlet. You never see a person running from his residence to the Ford F-150, from the Ford F-150 back to the residence. No evidence of that. So what does the government do when they have absolutely no evidence that Mr. Fernandez ever gets to that truck or ever gets back to his home or goes back from his home back to the truck? I mean, let's just talk about it. What they're telling you is, and we'll get to his phone, trust me, but his phone goes off, then his phone goes back on, then she wants you to believe that there's a second gap, his phone goes off, his phone goes back on. He's home. But if you want to believe what the government's trying to convince you to believe, he has to be running all around Jack's Beach. Detective Johns told you that when the phones finally connect, one phone pings over by Mojo's. The other phone is over by the police station where Henry Tennant is. They want you to believe it's Mario Fernandez who's over there by Mojo's, and somehow, like a ghost in the night, he never is seen. So think about what they keep asking you to do. In that video, when the truck pulls off, all of a sudden Detective Johns is like, it pulled into a gravel lot. And I said, you can't even see in that video the vehicle stop. And he's like, no, you can't. So what makes you think it stopped? He just told you. I think it stopped, even though I asked him right on the stand, you acknowledge that you can't see that video stop. That's correct. You have any evidence that it ever stopped there? No. He just wants you to believe it because that's something you'd have to imagine because he wants it to be true because it's nowhere else. Go back. I asked them what no criminal defense attorney ever does. You ask questions you know the answers to. And I looked at him and I said, tell me, after that truck pulls off, you believe it doesn't leave for hours. Where does the truck go? What did he tell you? I don't know. I think it pulled into a lot. There is no evidence of Mr. Fernandez out and about, the blue truck, for approximately 3 hours after you last see that truck pull out of Pablo Hamlet when it just backs up, turns around, and pulls forward. So like we said, there's no surveillance. I showed a video, if you recall, of the truck passing a sidewalk by the police station. And I said, count how many people are on the sidewalk. And it was 7. 7 people in that one clip were right next to that truck, and not a single person reports seeing Mr. Fernandez, a person who's been blasted all over the news and the media, saying, I saw him that night. He was in that truck. Not a single person. This is 7 o'clock at Jack's Beach. This isn't a time period where it's in the middle of the night and no one would see him. And then I showed you all what area they had pulled into. Mr. Fernandez is going to be running from his home, across Discovery School, back to a truck at the area of interest, and it's not caught on surveillance. It's not seen. He's not seen by any one of the people in the 40 or 50 windows that are in just that building, in the smokers pavilion. Do you remember when I asked the detective about, Corporal Wallace, about that smoking pavilion? And I said, it was 7 o'clock at night. Not a single person in an area where people congregate and smoke, which is, what, 30 feet from where the car was parked? And he said, oh, I don't think people smoke at night. Have you ever met a smoker? Do they stop smoking at 6 o'clock? That's what they're trying to do. When they cannot give you evidence or an answer in this case, they just say whatever they want, including smokers stop smoking at around 7 o'clock on a Wednesday night. And you have to ask yourself, how credible is that if someone's willing to tell me something we know just isn't true? Am I to rely on this kind of evidence to convict Mr. Fernandez of first-degree murder? That's for you to decide. And then he collected so much, if you go back, so much surveillance that they caught, in this video it's really small, but it's all there, back there in evidence, and every witness agreed. When Mrs. Bridegan pulls into the police station, you can see Henry Tenen in the same frame of Mrs. Bridegan pulling into the police station. If you stop it, you can see Henry Tenen on the sidewalk, and you can see Miss Bridegan's vehicle. And I'm not suggesting to you that that's some fact that you should believe that Miss Bridegan is involved. I'm not. But ask yourselves this. If they had Henry Tenen and Mario Fernandez in the same frame on the night of the homicide, how many times would they play that for you? They would say that is all the evidence that you need. And they collected so much surveillance that they actually got the killer and the widow in the same frame on the night of the homicide, and they can't show you one piece of evidence that connects Mario Fernandez on the night of the homicide to the crime scene, to the truck, to the route, to a gravel lot, to the Cradle Creek Preserve. Nothing, except for that Mario Fernandez is at his house. That's how much surveillance the government collected in this case. And then they want you just to believe it's just chance luck that he's a ghost in the night. And that's not reasonable. Then we heard from Detective Burrell. He said that he collected the tire at the Potomac House. He told you that who was there when he collected it, and that he went to the home, knocked on the door, And who was at the house when he got there? Mario Fernandez and Miss Gardner. So when they say, we have no idea where Mr. Fernandez was the night of the homicide, yes, you do. You know exactly where he was. They have him traveling at 5:45, and we'll get there on Beach Boulevard, going back to his house. He never leaves. His phone never leaves. And when law enforcement, who they told you, they don't call and say, hey, we're on our way over. They don't know when they're going to pop in. When they popped in, who was there? Mr. Fernandez. So when you hear over and over again, we don't know, they told you in the opening statement, we don't know where Mr. Fernandez is. They told you in the first close, we don't know where he is. You do know. He's at home because witnesses saw him at home. And I don't want to jump too far ahead, but while we're talking about it, Mr. Fernandez's interview said that he was home. And then you say, well, maybe he would lie. How do we know he's not lying? We know he's not lying because he said, when the children came in, I talked with them. And they told me that Jared Bridegan took a 20-minute or so phone call during the date night. And then I asked Detective Johns, did you confirm whether that was true? And he said, yeah, he had to take a work call during the date night. How in the world could Mr. Fernandez know that there was a call during date night unless the daughter told him when he got home that there was a call during date night? So now you know he's home because he said he was home. The facts confirm that he was home. His phone is at the location, and Detective Burrell, sure enough, knocks on the door, and Mario Fernandez is there. He's not acting nervous. He's not sweating. He's not doing anything evasive. He's not fumbling with his phone. Not one single detail could they offer you that suggested their favorite phrase, that Mr. Fernandez had consciousness of guilt. None. He answered the door, he spoke with detectives, and there was nothing unusual whatsoever about the encounter. And they looked at the evidentiary Ring doorbell, they shared it with him, and he said he just didn't see anything of evidentiary value. Then we got to meet Detective Chris Johns. There is going to be a jury instruction that the judge is going to read you that I want to point out now, because this is the point in the trial where you have to ask yourself, was the witness honest and straightforward in answering the attorney's questions? That's your job to determine that. But I suggest to you that when the government had a question for Detective Johns, he had no problem answering it. Can you tell me about these FBI cast slides? Sure, I'd be glad to. Then I ask him, can you tell me just, some basic information? Oh, we should leave that for Agent Blythe. If they wanted it, he had no problem answering their questions. If I just wanted a simple answer to a simple question, he just wouldn't give it to me. I had to walk through 30 minutes of a bank account, an irrevocable trust yesterday that had no $50,000 transfer out of it. Didn't occur. He could have just said, there's no $50,000 transfer. But he wouldn't. He was not straightforward in answering my questions. And that is one of the factors in weighing the evidence in this case that I will ask you to consider when you go back and deliberate. He has no homicide experience. This was his first case. He's now a part-time employee. He works as a financial planner or a tax person. He acknowledges this was the biggest case of his career, and he had no experience handling a case like this. He acknowledged that there were thousands of Crime Stopper tips. He said sometimes people would just call and be like, I saw a Ford F-150 at the Home Depot, and there's nothing we could do with it. But that's how many tips they got. People in the area were willing to give any information they had, and yet not a single shred of evidence on the night of the homicide that anyone came into this courtroom and reported connecting Mr. Fernandez to the blue truck, to the scene, to the route, to the school, to the gravel parking lot, or any other place they want you to imagine that Mr. Fernandez may have been at. January 5th, This is the first date that I sort of had to go through because the government suggests this date has some importance. And remember, in the opening and this morning, Ms. Stifler will say to you, these are just snapshots in time. These are just snapshots of evidence. It's that way because the government made it that way. They're just showing you snapshots and then asking you to string together why our client is guilty. We are the ones that tried to show you the whole story. We're the ones who tried to show you poll camera footage from other days. We're the ones who tried to show you reasons why he would be doing X or Y or Z at other times. They want to show you certain dates that have certain reasons and certain values for whatever their prerogative is. So let's start at January 5th. Mr. Tenen, or his device, goes to the area of the Fernandez residence and Pablo Hamlet. Government told you that there would be no reason for him to do that other than his landlord lives there. And then they said, well, there was a phone call on January 4th. So if there's a phone call on January 4th, that means that this had something to do with the homicide. Or did it have to do with Mr. Fernandez calling and saying, dude, you haven't paid me in 3 months. Like, I'm meeting up with you, I'm getting my rent payment, or you're out of here. Government will get up and Mr. Mizrahi will say, there is no evidence of that. There's not. There's also no evidence that he went there for any nefarious purpose. There is evidence that he didn't go to the crime scene. So they want you to believe this was some practicing for the ambush. I don't know why Mr. Tenen was there, but he didn't see Mr. Fernandez. There's no cellular data suggesting Mr. Fernandez was home. There's no GPS showing that Mr. Fernandez was there. There's no evidence connecting Mr. Fernandez to January 5th whatsoever. And suspiciously, when Agent Blythe shows the GPS of January 5th, there's no confidence levels. It's the one slide, they're just all blank. But it's the one slide, he's like, I think that Mr. Tenen was on their street. Their street is 300 feet long. And yet that day, he's like, I think he went on a street. And I was like, okay, if you're right, and he did go on their street, was he on there for more than 30 seconds? No. That's what you learned on January 5th, is that some tenant of Mr. Fernandez went to the area after knowing that he's owed him money, he's behind on his rent, and may have been on his street for 30 seconds. No evidence of where Mr. Fernandez is, no evidence of their communications on that day. And then Ms. Stifler says, we have communications on the 4th, we have none on the 5th, blame Mr. Fernandez. This is their investigation. This is their burden. They have to come up with communications. They have to come up with the evidence. They have subpoena power. They have warrant power. And they did it over and over again. But when they don't have evidence, they look to blame Mr. Fernandez. Then the next date is January 25th. Mr. Fernandez goes to John Biggerstaff's house. And they're like, well, it's only one reason could be to talk about a 10-millimeter firearm. He has known this man for 17, 18 years. They work out together. They have a cigarette every once in a while. They have a beer together. Mr. Fernandez helped with his son's upcoming wedding. Let's ignore that legitimate reason. They have known each other. They do things together. They do tile work together. They have done handyman work together, or at least Mr. Fernandez has hired Mr. Biggerstaff to do it when he was healthy and he owned a company, 904 Handyman. One reason after the next, we were able to show you why he may have been over to that house. Has to be a 10-millimeter. That's what the government has to tell you. And of course, not to jump the gun, but we know why he went there one day, because it's on video. But when it's on video, they tell you, can't be for that reason. So whenever you show them the real reason, they tell you you shouldn't believe that, and you should make up something in your mind that's nefarious or criminal, when they cannot show you that they have any connection to nefarious or criminal activity between Mr. Fernandez and Mr. Biggerstaff. January 29th. On January 29th, Mr. Fernandez goes to the Potomac address. There's no dispute with that. Now, in this case, Agent Blythe will tell you that I don't track people, I track devices. And studies show that people are within arm's reach of their device. Sometimes they corrected me, because I would say, Mr. Tenen went to this place, or Mr. Tenen went to that place,
or Mr. Fernandez was at this place or that place. And he would say, I don't know. I just know his device. But on the 29th, all of a sudden now, they throw out the studies, they throw out their own testimony, and they say, because he went there on a day that Mr. Tenen was doing something that obviously had something to do with the homicide. I don't dispute that. When we said it was a dry run and we're the ones who told you that. We were the first people to give you that information in this trial, to show you those slides. No dispute. But the detail is, number one, in a vacuum or a silo, looking at it independently, that would be a really bad fact if there was no evidence that Mr. Fernandez ever went to Potomac. But that's not the case. So I painstakingly, and I acknowledge it was boring, and it was slow, and it was painful. I showed you the poll camera footage that showed you how often Mr. Fernandez would go to that location. Because it's not in a silo, and it's not in a vacuum, and it's not one day like January 29th. He was there regularly. So I showed him, and we didn't put up the poll camera. They did. There was no camera on January 29th. But if there was, it would show you exactly what I was able to show you, is that Mr. Fernandez goes there, he drops things off, he does work, he meets vendors. We showed the Bueller air conditioning guy show up. They've shown you that he bought a new air conditioner. Today, for the first time, they're making this big argument that who would get a contract for a one-year service agreement when you know or you end up selling the home. The contract and the service agreement is in evidence. And if you decide to look at the evidence list and look it up, another half-truth that they didn't share with you is when he paid $15,000 for his air conditioning unit, and you look at the service contract, it says 1 year maintenance included. But somehow, in the state's first close, that was some big point. Who pays for a 1 year service contract when you later sell the home? It came with it. That's what the continued theme of what they keep doing. They just tell you one little piece of evidence, and then when you look at the whole truth of the whole story, it doesn't add up. It's not what they're telling you. They didn't tell you that he goes there regularly. I mean, think about where they're tracking Mr. Fernandez in this case. They're either tracking him at the place he lives in Jax Beach or a place he owns. They don't ever show you any information or evidence that he went somewhere where Mr. Fernandez shouldn't have been. They don't show you evidence that he met up in some murky pool hall in a part of town that he doesn't go to meet up with some character that he doesn't know. That does not exist in this case. He goes to a place that he owns, and he goes to a place that he lives. Those are the two places they have tracked Mr. Fernandez in this case, and that is it. They keep telling you, even as much as this morning, Ms. Stifler's like, and his phone was stationary. I don't know why they keep saying that. I asked Detective Johns and Agent Blythe, when a phone is in a band, in the pink bands, can you tell where the phone is? No. The technology isn't that good. If he's sweeping, I don't know if you guys remember, I was standing right here, and I said, if he's sweeping in his driveway, can you tell if the phone's moving? No, we can't tell. We just know that it's in the band. If he's moving boxes, if he's tiling, can you tell? But for whatever reason, they repeatedly just keep telling you that that phone was stationary at Potomac on the 29th because they want you to believe it so badly because there's no evidence that that phone left Potomac while Henry Tenen was doing whatever Henry Tenen was doing. And then, yes, I agree. A person could leave their phone at the Potomac place and leave it on and go with Henry Tenen. Is that possible? Sure. But you have to have evidence of that. And she's like, there's no way to get surveillance in retrospect a year later in St. Johns County. I don't know if that's true or not. You didn't hear any evidence that that's true. They didn't get any, so they want you to believe that. But there could be financial transactions. There can be people reporting, I saw a black man in an F-150 with a person that matches the description of Henry Tenen. There is no evidence. There's license plate readers that show the truck was there. They have the ability to match two pieces of evidence to a location. I went through that. They just don't have anything that lets Mr. Fernandez's device or himself leave that property, so they use words like it was stationary the whole time, when you were told that's not possible to tell. And then ask yourself, that he's some big mastermind who turned off his phone on the night of the homicide because that somehow would protect him. He doesn't turn off his phone this particular time. What is it? Does he think that turning off your phone is helpful, or leaving your phone on is not? It doesn't make any sense. They don't have a consistent theory. And I'll talk more about that in a moment. On February 15th, Mr. Fernandez goes to the Potomac address. He goes twice, and they wanted to make a big deal out of that. Number one, the first time he goes, on the 15th, Henry Tennant's not there. If you recall, he's at Modison Pallets, the place that he works, and he's not even there. Well, that's unusual. The day before the homicide, why would Mr. Fernandez go to the residence that he owns, where Henry Tennant is staying with his best friend, Jeremy Ordway? We'll talk about that in a second. Why would he go there twice on that day? So I painstakingly showed you evidence that it is not uncommon for Mr. Fernandez to go twice to the residence when he's doing work. I was able to show you on 8/9 that he pulls in the morning at 7:46. He stays there for a period of time. And then on 8/9 at 2:05, several hours later, Mr. Fernandez comes back. This is showing you that it has nothing to do with the fact that it's the day before the homicide. It has nothing to do with that it's suspicious that Mr. Fernandez went there twice in one day. That's what Mr. Fernandez would do if it required him to do that for whatever reason he was doing it. And then they suggest to you today, well, there's just no reason he would ever go there. Look at the state of disrepair. He wasn't really doing any work there. That's not the evidence. The evidence on a poll camera that you saw that he didn't know was put up is that he pulls in, there's supplies get unloaded, they get taken in. You see Mr. Fernandez with this orange bucket, and he takes it, he's doing tile work, he dumps water out, you see him sweeping. There's another footage at the end when I just said to Detective John, would you agree he continues to do work? It's in evidence if you'd like to look at it. He has gloves on, he's literally carrying lumber from outside the house over the driveway and through. He's obviously doing work there. There is no dispute. But they don't like that fact, so they tell you, look at the state of disrepair. He wasn't doing a good job. He wasn't really doing work. Your own eyes will show you the work that he's doing with a camera that, thank God, they put up. On February 15th, this is the night that he goes over to Mr. Biggerstaff's house. They want you to believe that it had to be to pick up a 10 millimeter until when we went through all the evidence and we went through John Biggerstaff's phone, who somehow this morning, everything was wiped. There is no evidence. We could gain nothing from these people. No, they just didn't gain evidence that connects Mr. Fernandez to homicide. What they did gain is plenty of evidence. And in this evidence, there is a video of Mr. Fernandez. He's there that night, and he's doing whatever he's doing, and that's not the point. I'm not hiding it. If you recall, I'm the one who asked Detective Johns about it. But he's on video. You know exactly what he's doing there, and he's not picking up a 10 millimeter. And when I asked John Biggerstaff, did he owe you anything? Was he doing this because you were going to give him a gun? No, no, no. Detective Johns, did you have other evidence that Maria Biggerstaff was caught on video doing these things? Yes. This was the lifestyle that they chose to live. But when you actually know for an undisputed fact why Mr. Fernandez was there on the 15th, ignore that. It has to be because he picked up a 10 millimeter firearm that's not connected to this homicide. And we'll talk more about that. On the night of the homicide, Mr. Fernandez returns to his house at 5:45. He is there the entire night. There is no evidence that he left his home. Think about all of the different detectives that told you that they collected detailed evidence from the crime scene. Where people touch the little, the caps that are on the tire, we collected those. Not one person can connect you, Mr. Fernandez, to any piece of evidence that was left at the homicide scene, or most importantly, the blue truck. They used special vacuums, if you recall me asking the detective, with special filters so they could collect hair. They did fingerprint dusting. They did DNA testing of the steering wheel, the seats, the headrests. Not one piece of evidence connects Mr. Fernandez to ever being inside of that Ford F-150. And then I went one step further. I'm like, well, it's been a little while. Was there evidence that the vehicle was cleaned out, wiped, cleaned, vacuumed? No. It was the side of a pigsty. No evidence that it was cleaned out. And yet they couldn't find one piece of evidence connecting Mr. Fernandez. And remember, when Mr. Fernandez goes in for his interview, it's voluntary, and they say, will you give us a DNA swab? And he says, no problem, and he gives us DNA. And according to the government, what they told you is he never thought he would ever get caught. So of course he would give a DNA swab. Well, if he was so willing to do that, knowing that he was inside of the blue truck, that doesn't make sense. And that's in conflict with what the government wants you to believe. Not a single eyewitness, not a single Crime Stopper, no DNA, no fingerprints, and he tells law enforcement he's home, and he gives details about date night. Detective Johns, went on to say that they don't know where the F-150 went post-homicide, that an unknown driver pulled out of Pablo Hamlet, an unknown driver passes Ocean Cay, and they do not know where the truck went post the homicide. It's never to be seen again. If there's an unknown driver, okay, and unknown locations, 36-minute gaps, and then a vehicle that just disappears, if they don't know who the players in this case are, then they don't know what happened. And I mean the government doesn't know what happened. And when they say there's only one person that could connect Mr. Fernandez to these little details, it's impossible to say that when you don't know who the other person in the truck was. The other person in the truck could be connected to Shanna Gardner. The other person in the truck could be connected to Shanna Gardner's family. The other person in the truck could be connected directly to Jared Bridegan. And we would never know because we don't have their bank records. We don't have their DNA swab. We don't have their phone records. It's an unknown player that's not Mr. Fernandez. So when you go back there and you say, well, geez, I mean, out of all the gin joints in all the world, it's Mario Fernandez's, it's Henry Tenon is Mario Fernandez's tenant. So all this makes sense, and we should just go along and make sure that we don't unstring the yarn or whatever it is that Ms. Stifler showed you at the end of the tapestry. The bottom line is, for the government to tell you that there's only one connection, they have to know who's involved, and they don't. Keep going. So the 10mm firearm. How many times have you heard the government tell you it's an unaccounted for 10mm firearm? Let me be very clear about this. The first thing they would have to do for this to have any evidentiary value is they have to tell you that John Biggerstaff's 10mm firearm is connected to the homicide of Jared Bridegan. They have not done that. There are tens of thousands of 10mm firearms in Glocks that have been produced since 1991, and they don't know which of any one of those it is that was involved in this homicide. So let's just start with that premise. Then the second thing the government would have to do is then connect Mr. Fernandez to John Biggerstaff's firearm. So what did we show you? We showed you that John Biggerstaff, in fact, did purchase a 10mm firearm in 2016. Then he became, he was arrested. So this is the purchase of the Glock. This is the Glock that was put on the firearms affidavit, which of course is a big deal that it matches, because it would be a big deal if the government could show that John Biggerstaff bought a 10mm then filled out a firearms affidavit, and that firearm wasn't on it. That would be good evidence to suggest that he kept one of his guns. But that's not what the facts are. The facts are is that he bought one, he filled out a firearms affidavit, and the exact one that he bought was put on it. And the magistrate said you can no longer have guns, and he got rid of them. And I think Ms. Stifler said during her close, well, I mean, you know, just because a judge tells you to do it doesn't mean that you have to do it. Sure it does. He got rid of all of them with Juan Biggerstaff, his son present, and someone from federal probation. And when you don't follow the rules, that's exactly what happens. You go to jail. And when he tested positive for drugs, because the government does a little thing called following up, they make sure you don't have your firearms when you're on federal pretrial release. You think they just take your word for it? No, they send someone to your home. They make you fill out an affidavit. They check to make sure you don't have them. They tell you you're not supposed to do drugs. When he tested positive for drugs, what did they do? They arrested him, and he went straight to jail. So this idea that they just don't follow up or it's not a big deal, it's in conflict to their own evidence. So then he fills out the firearms affidavit, that firearm is put on there, and it's not seen again for all of these years. But they made such a big deal about it. How rare it was, how this could be the only 10 millimeter that could be involved. They went to one pawn shop. Detective John sent his investigators to one pawn shop in all of Jacksonville, and they found 6 10 millimeters that were sold in the recent time, 3 of which were Glock Gen 40 Gen 4s, the exact make and model of John Biggerstaff's. Like, he laughed when he's like, you know anyone that owns a 10 millimeter? He hasn't been allowed to be around guns or people that are in possession of guns since 2016. He probably doesn't know someone who has one. We don't have to guess that people own them. 6 of them were purchased in and around the time of the homicide in Jax Beach, 3 of which match the exact description. And when I asked Detective Johns, well, once you learned that, what did you do? Nothing. You didn't follow up? No. You didn't go interview anyone? No. Nothing. 0. When they learned that Henry Tennant had gone to a particular pawn shop and actually pawned something, did you go there and investigate to see if he got a 10 millimeter? No. Did you go to any other pawn shops anywhere across town ever? No. But they want, what's more reasonable? That maybe someone who actually got a firearm during that period of time may have been involved, or that Mario Fernandez, who not one witness, and we'll talk about John Biggerstaff, Juan Biggerstaff, and Fred Barton, not one of them said anything about Mario Fernandez, other than John Biggerstaff said, I did not give him a firearm. On March 1st, Mr. Fernandez came in and he gave a voluntary interview. You know, because of his bank accounts, that on March 1st, he had in excess of $200,000 available to him. Hiring a lawyer is not something that he could not have done. He didn't show up with counsel. He didn't invoke his right to remain silent. He sat down voluntarily. He gave an interview. And then I asked on cross-examination to figure out, well, let's see if the guy was telling the truth. He talked a lot. You heard the interview. Detective, he told you that Jared Bridegan got into a big confrontation with Bishop Curry about the purple hair. Did you ever go and interview Bishop Curry to see if that was true? We did. And in fact, there was a big confrontation, wasn't there? Well, I don't know if it was a confrontation, wouldn't answer my question, but yes, they got into it, and Bishop Curry was not happy about their interaction. That's what Detective Johns told you. But the point that I'm making is, he went, he interviewed him, and it did, in fact, happen. It was true. He wasn't lying. AB phone call, true. The children's therapist that he talked about, Mercedes McGowan, this is a guy who's some absentee stepdad. He knows who the children's therapist is. He knows all the medications they're on. Did you find out if that was true? That was the children's therapist? We did. He admitted that it was a high conflict co-parenting situation. He didn't deny that. If he's thinking I'm the suspect in this murder or I'm involved in this, maybe I should make it seem like things weren't that bad. No, He said it was a high conflict. That's exactly what the evidence showed. As Ms. Stifler said, most people said he admitted there was some high conflict, and that's exactly what he told the police. He didn't undersell it or try to underreport. He told it exactly like it was. And he was upset that Miss Gardner and the children were not invited to Jared Bridegan's funeral after inviting Kirsten Bridegan into their home. And all of that was true. They were not invited, and they did invite Kirsten Bridegan into their home. The government, of course, talks about the motive. We talked about the family law case as to why there's no motive, and they just keep focusing on this one sentence. But I ask you to please remember that what the evidence was is that they asked him questions about Jared Bridegan. So they keep saying, and well, he just kept bad talking Jared Bridegan. They were only asking questions about Jared Bridegan, and that he would give the answers. And he was saying that the children needed to be in therapy, and therapy was good for the children. And if Jared Bridegan attempted to take the children out of therapy, which they believed Mercedes McGowan was helpful, that the family law lawyers suggested that then they would file for a social investigation, and then they would move to modify the time sharing to 60-40 or something that worked better for the children. That's what the interview that's in evidence says. Don't take my word for it. That's why I took the transcript out and I read it line by line with Detective Johns. It's not just that we want decision making. And most importantly, the children were never taken out of therapy, and they never moved ever to modify the time sharing agreement. So the predicate of what this was based on never happened, and then they never took this action. So to suggest that now they would just kill Jared Bridegan because that's an easier solution, there is no evidence they had any motive to take one single day away from Jared Bridegan unless he did something that would negatively impact the children, which he decided not to do.
Mr. Dreiser, can I pause you for a break?
Yes.
Okay. Members of the jury will take 15 minutes, okay? We'll come back. All right, thank you. Thank you. Ready to bring in the jury? Mr. Dreiser?
Yes.
Okay, thanks. Thank you. Welcome back, members of the jury. Everyone may be seated. Mr. Dreiser.
Thank you, Your Honor.
Thank you.
One of the things that I'd like to also talk to you about, this jacket has no evidentiary value to whether Mr. Fernandez is connected to the homicide of Jared Bridegan. I think we can all acknowledge that. This big box of boots that you've seen us sort of manhandle around the courtroom trying to get it on, and it was brought over there, has no evidentiary value to whether Mr. Fernandez was involved in the homicide of Jared Bridegan. So why was it important? Why did I take the time to show that to you? Because all of the surveillance is in evidence. And I want you to take the time, if you so choose, to look at any one piece of surveillance that shows Henry Tennant. And I picked out for you right here, can you go back and play one more time? What I believe is the clearest, where you can see Henry Tennant the most clear. And she just stopped it. And you tell me, after watching that video, which I submit to you is the clearest, but if there are others that you think are more clear, that you believe that you can tell that this is the jacket that he has over his shoulder, whether it's a jacket at all or a blanket, whether he's wearing white sneakers, not these boots, the purpose is they don't know. But they keep telling you these half-truths. They keep trying to get your imagination to connect the dots. So they frame a jacket that was found at Potomac and tell you, this is the jacket. They put a pair of old boots in a big box so it looks like they have a lot of evidence to connect Mr. Fernandez to this crime, to make it look like they've done their job and met their burden, when they haven't. When you look at that slide and you say to yourself, there's no way you can tell. It could be that jacket, but there's no way that we know it's that jacket. We know, there's no way we know it's the boots. Then ask yourselves, why are they doing that? Why not just say, like they did in their first close, we're not really sure, that's your job. Why not put all the jackets that they found in the garage and say, it's your job to determine if it matters what jacket he's wearing? Why not put in all of the boots that they found at Potomac and say, it's your job, you determine what boots he's wearing? They're not doing that repeatedly. They're trying to force evidence on you to get you to connect dots that simply do not exist. Detective Johns arrested Henry Tennant on August 18th, and they told Jeremy Ordway that he was arrested in connection with the murder of Jared Bridegan. And why that's such an important fact is there's a flutter of phone calls amongst Mr. Fernandez and Shanna Gardner. If he just got arrested for a driving while license suspended or revoked, there'd be no reason for a flutter of phone calls. But when they tell the current tenant that the person who is his best friend and a family friend of his father's for 20 years, which is another thing they keep telling you, like he never moved out, he just continued to stay there. His best friend moved in, a family friend of Jeremy Ordway's. That's the connection of why Henry Tennant appears at Potomac. It has nothing to do with Mario Fernandez. It has to do with Jeremy Ordway. But because they told Jeremy Ordway that, and they asked Jeremy Ordway to conduct a controlled phone call, of course there's a flutter, because they told them that they were investigating the homicide of Jared Bridegan, and it would be weird if Jeremy Ordway didn't call Mr. Fernandez and say, did you know that this has something to do with your wife's ex-husband? That makes sense. Again, this is all the jackets. This is all the shoes that they could have shown you, and they chose not to. February 8th, Mr. Fernandez's phone is seized. He was cooperative. And when they pull him over, I asked, he didn't know you were going to pull him over? No. Did you find any evidence connected to the crime? And the answer is repeatedly, no. We didn't find any evidence. And I will talk to you about the Pennsylvania trip, but they continue to show you something, and then when asked, did it connect? No. Was Mr. Fernandez cooperative? Yes. Did you get what you were looking for? Yes. And then when they arrest Mr. Fernandez, he's arrested without incident, no running, no fleeing, no violence, no gun found, nothing. Nothing that connected him to the crime of the murder of Jared Bridegan. Ms. Kudus, I don't know why the government chose not to tell you my first question. You used to have a fling with him. Yeah, that's right. But why didn't they tell you that? That's an important detail when you're judging someone's credibility. That makes more sense why he would share information with her about their high conflict. She would call him to ask his advice about her high conflict advice. And then lastly, she said, toward the end, I felt like he was sort of feeling me out to see if I was interested in a relationship again. Doesn't that make more sense when they used to be in a relationship? And then when it turns out that she really wasn't interested, they didn't have that much more contact anymore. But she doesn't report him to law enforcement. She doesn't call and say, hey, he said some weird things about his marriage. No, law enforcement shows up at her house and they ask her questions about the homicide. And then she's like, yeah, I did know Mario Fernandez. And she says, which are from conversations that were years prior that she never wrote down and admitted they were not verbatim. She commented about some contract in the marriage, and I said, did you know that they had, I probably said prenup by accident, a postnuptial agreement? That's a contract. No. Did you know that he was the trustee of the family trust? No. She said there was some issue between the Gardner family, yes, the very wealthy people, and him being the trustee. That makes perfect sense with the limited information that she had, is that he was the trustee of the family trust. Then you heard from Mr. Quiroz. Someone will have to explain this to me one day. They tell you that one day Mr. Fernandez goes, he Googles a place that he's heading, which I think is pretty consistent with what people do. Then he goes up to North Carolina. Mr. Quiroz tells you, he texted me a few days before. He said, hey, I'm coming up that way. Do you want to get together? They go to Ruby Tuesdays. He uses his credit card. They go to dinner. He uses his phone. He doesn't turn his phone off. He doesn't have a bat phone or a secondary phone. He says, I'm going up to visit friends up north. He ends up going up north. He stops and he buys some shampoo and toiletries at Walmart. This is somehow evidence that they took time to show you that Mr. Fernandez is connected to the murder of Jared Bridegan. This is the part of the trial, folks, where you were waiting for that shoe to drop. You had to have been thinking, all right, we've heard from this guy, we've heard from this guy. Nothing really connects Mr. Fernandez. It's got to be coming. Here's the receipt where we got the rope, the duct tape, the silencer, the gun, something that connects Mr. Fernandez to a crime. That's the part in murder trials where they're like, gotcha. You went to a random Walmart that no one thought you would be at, and you bought a bunch of supplies that are consistent with killing someone. Something that could make you think that Mr. Fernandez is connected. He was on a road trip that he had planned, that he told people about, that he used his credit card and bought his phones, and he went to Walmart and bought some shampoo. That's what they told you. And then he went to Pennsylvania, and he left, and somehow it was some big deal that he booked a hotel for 2 nights but only stayed 1 until Mr. Hill got up there and said, what time is checkout? 11. What time does the cellular data show that he left the area? I don't know, like 7 or 8 o'clock at night. Every single one of us knows that when you go to a hotel, if you stay past, 11, 12, maybe you get an extended checkout, 1, 2 o'clock. But after you stay after that, you have to pay for the second night. So if he was in the area visiting friends and had his things in that room until a certain period of time, or whatever the case may be, decided that he likes to drive through the night because there's less traffic, so I'll sleep in, I'll stay until 7 or 8, and then he came back to Jacksonville in March. And then they just sprinkle in. That's when the twins were being interviewed. You guys have heard that. He went up there, and that's when the twins were being interviewed. Folks, what have you heard that is some negative inference that the twins said anything that would make Mr. Fernandez think that he was in trouble and would have to flee? And I don't know who flees to Pittsburgh. He didn't go to Tijuana. He didn't go to the border of Canada and camp out. He's in Pittsburgh. And then they just sprinkle in, that's when the twins were interviewed. What piece of negative information have you heard that the twins said anything that would incriminate Mario Fernandez? And the answer is none, not a peep, 0 evidence. So somehow they took time to tell you about a trip where he went to Pennsylvania and met up with a friend. And I just suspect you were wondering, why did we hear this? What was the purpose? Because as Mr. Fernandez's criminal defense lawyer, who's been on this case since day 1, I have no idea what evidentiary value him going up to Pittsburgh and coming home in March of 2022 has anything to do with this case, except for the fact that we know he bought toiletries on a road trip. Then you heard from an analyst that they flew in from Maryland to go step by step through every little piece of evidence, who just told you there's no DNA that connects Mr. Fernandez to the crime or the murder of Jared Bridegan. Bottom, end, period, stop, nothing. Not one piece. Then you heard from Mr. Stengel. Do you remember when the government, I keep telling you about these half-truths and not whole stories that you heard. Do you remember when the government said, and Agent Stengel, did you find a gun accessory when you went to John Biggerstaff's house? Yes, I did. Here it is. We're about to find, the shoe's about to drop, folks. We're going to get that piece of evidence. I found a gun cabinet. All right, this is the point in a murder trial where they show you that they found the gun or evidence of a gun. Nope. I have to get up on cross-examination and stand there and look at him and say, you found a gun accessory? Do I understand that you found an old, rusted out gun cabinet on a back porch? Yes. That thing didn't even shut, did it? No. You found garden tools in it. That's correct. That was the gun accessory? That's the kind of evidence that they're showing you to try to connect Mr. Fernandez to a firearm that's phantom in this case. That John Biggerstaff had a garden tool in an old rusted out cabinet on his back porch. And then he told you that he was one of the agents that was responsible for finding the F-150 at Jimmy Jones's house. This has got to be the most inept part of the entire investigation. They want you to believe that Mr. Fernandez is somehow connected to a gun that legally had to be disposed of in 2016. But they find the #1 most important piece of evidence that they had been looking for, that had been blasted out on the news. Which, remember, they keep saying, well, Mr. Fernandez never reported the F-150. Well, either did the person who was in possession of it. So we had no reason to believe that he was a suspect. He was nice to us. I talked to him for like 8 minutes. He was a good guy. He's in possession of the most important piece of evidence that they found in this case. He said, you can search my house. And they don't search the house? What's more reasonable where you would find the homicide weapon located in this case? Maybe it's there, maybe it's not. But we all agree that if the truck was hidden there, the murder weapon could be hidden there. The motive could be hidden there. The reasons could be hidden there. Jimmy Jones could be involved. They have no idea. They didn't investigate him. You didn't hear from him. You have no idea the connection of Jimmy Jones to this case, other than they just want you to believe, oh, Henry Tennant asked me to keep the vehicle here, and I had no problem doing it. Case closed. It's all cool. Mr. Hill had to get up and be like, how many people have told you, you can search my car because they don't want you to think they have anything to hide, and then you find a kilo of Coke in the trunk? That happens. It does happen. No investigation whatsoever. Don't go to the pawn shops where the 10 millimeters are and ask follow-up questions. Don't go inside the home where you actually find evidence in this case. And number one most important fact of this entire scenario is that that truck at that location, Jimmy Jones's house, isn't connected to Mario Fernandez at all. Stop, period, no evidence. None. He is not connected to the place where that truck was found, and they did nothing to determine the relevance of where that truck was found. Never heard from Jimmy Jones, never searched his house. He never called it in. Then you heard from Carlos Sonny Fong. Mr. Fong calls Mr. Fernandez. That call is in evidence. Please listen to it as many times as you want, because it never says anything that they told you it says. You heard today Ms. Stifler tell you that Mr. Fernandez was willing to pay $3,000 to remove one tree. That's what she said. So how it would be unreasonable that he would pay Mr. Tennant $2,500 for tree work? Excuse my language. This is what the call says. During COVID, they wanted $3,000 to remove a tree. Fuck that. That's what he says. He does not want to pay $3,000. And then he goes on to talk about the checks. When he calls Mr. Fernandez doesn't deny. That would be great evidence. If we know there's a connection between Mario Fernandez and Henry Tennant, and then his friend calls and says, hey, man, do you have any connection to this guy? No, never heard of him, no reason. He's like, yeah, man, the guy did work for me. He was a workhorse. He did lots of work. First check, keeping up with the roof, $3,000. Not a shred of evidence in this case that Mr. Tennant didn't do roof work for Mr. Fernandez, okay? The call between Sonny Fong that they did not know was recorded was 11 months after the homicide. 11 months. Second, $2,000, landscaping clearing. Now let's hear what happened on the call.
Like, he was working for me for a bit, like, after it.
Really? For real?
Yeah, yeah. Like, he helped me, like, that's a fucking quarter-acre lot. And like, he did a lot of fucking work, dude. Like, he fucking took down trees and shit and fucking mowed that bitch, and then he did roofing. Like, I don't fucking get it.
I don't know anyone that's that good. On a call that he didn't know was being recorded, either party, 11 months later, he says, did you know him? And then he says, yeah, he did a lot of work for me. A quarter-acre lot. I don't even know if they're talking about Potomac, because Mr. Fernandez also owned Whitehorse and other properties at the time. He did a lot of work for me. Not one piece, not one tree. He mowed that bitch. He took down trees. He did roof work for me. Mr. Fernandez is so good that he had the opportunity to, on an unrecorded call, recall the exact or close to it memo lines of the work that Henry Tennant did for him after the homicide. There's not one part of that call that's inconsistent with those checks. It is the most consistent piece of evidence in this case that Henry Tennant did legitimate work for him, and they get recorded on a call talking about it. And then call where he's like, yeah, I don't remember everything. It would be really weird if he talked every single specific detail. The government's like, well, he didn't say the Kickstarter. I mean, we'll get to the Kickstarter checks in a minute, but I'm going to suggest to you that no one is that good. And the reasonable inference is that he actually did legitimate work for him after the homicide because Mario Fernandez knew he needed money and Henry Tenon was willing to do the work, and he did it. In opening statement, Ms. Stifler said, "You will not hear any evidence from the downloads of Henry Tenon's phones or Google accounts that have ever had anything to do with the Kickstarter. You will see very quickly these are not legitimate payments." Again, who is this good? Scouring tens of thousands of records, we were able to show you that the week prior to Mr. Tenon receiving this Kickstarter money, he's Googling business plans for pallet companies. He then writes out a business plan. I'm sorry. He then, while at the time period that Mr. Tenon is at the house, he gets arrested. He can't control when he's going to get arrested. A pallet truck, while Mr. Fernandez is there, pulls up in front of the house. I don't know who can plan this. I mean, this is insane. There's a Google search history of starting a company a week before he gets a Kickstarter money. Pallet trucks show up at the house and stop after he's arrested. And inside, these are the Google searches, okay, showing the business plan that he was obviously trying to impress Mr. Fernandez with by getting a little bit of money that meant nothing to Mr. Fernandez in the grand scheme of how much money he had access to. And then they've not decided to go in and show you what the business plan and the numbers were. Is this real or fake? Look at the dates, folks. Right around the time of the checks, 3/31, 4/1, 2022. At the time, no one could have assumed that they would ever find this. And look at Mr. Tenon's. It has the number of pallets. It has the unit price. It has the totals. It has the dates. It has the numbers. All consistent with what you would need, which is about $5,000 or $6,000. All listed out, all with the dates from before he got the checks to getting the checks to after he received the money. No one is this good, folks. It suggests to you that it's real, that that's what the money was for. Mr. Tenon was helping him. He was doing a lot of work for him. I'm sure if Mr. Tenon wanted to start a pallet company and Mr. Fernandez gave him some money, it was an advance for him to continue to do work for him. That's what's happening here. It's $5,000 to a guy who has access to hundreds of thousands of dollars from the trust in his own personal accounts. This is not a great deal of money to Mr. Fernandez. It was a great deal of money to Mr. Tenon, and Mr. Tenon clearly tried and did the work for the pallets in which he needed the money for. Next. Then you heard from Mr. Blythe, or Agent Blythe. It wasn't until I got up and I said, "Are these things peer-reviewed?" "Yeah." "How many drafts did you do?" 5. 2 finals? "Yeah." And there were still mistakes on it. First-degree murder case. They're trying to put my client in prison for the rest of his life.
Your Honor, object.
Sustained.
This is a first-degree murder case. It's the most serious case that you can be indicted for in the state of Florida. There is no more serious of a crime. And they want you to believe that Mr. Fernandez's phone was off because there's one gap in data during the time of the homicide. But it's the defense that has to show you that the same records that they were relying on to come up with that information comes with a warning. The warning says, even if call records are found, which some were, there may be times when no timing advance records are available. Please use caution in using these records for investigative or prosecutorial purposes. It's exactly what they're doing in this case. They're taking one missing record, which T-Mobile tells you you shouldn't do because there are missing records. And then when I ask him about it, this is what he says. Well, on direct examination, when Ms. Stifler asked, any rhyme or reason as to why no timing advance measurements? Answer, could be engineering product, can't map it, no location, no TA recs recording, can't say with certainty. We need certainty. The jury instruction says you have to have certainty. And yet, in this case, he cannot give you certainty as to why there's one missing TA record at that time. And then it took the defense on cross. I said there can be blocks of time where the network engineers just don't record TA for a particular market area. That's correct. And that's what they're asking you to rely on, to know that his phone was off. And then when I asked, do you know if his phone was off? No, I can't say. Circumstantially, it may have been an airplane made, or the engineers at the company, for whatever reason, just didn't receive timing records. And then when I showed all of the timing records for the whole night, I showed there's another 52-minute gap. They didn't tell you that. And I said, if you took that 52-minute gap and you put it on a slide, wouldn't it look identical, that there's no information? Yes. So what does the government do? They get up in their first close and they say, I wish they would have mapped that, because there could be another reason why at that time period it connects Mr. Fernandez to the crime. No, it doesn't. T-Mobile doesn't get records timing advance all the time. There are gaps for engineering reasons. Exactly what Agent Blythe told you. Blocks of time where the network engineers just don't record TA records. T-Mobile tells you that with a warning, and then all the records show. But they didn't show you other nights. Mr. Hill got up and he asked a witness later, did you look to see if there were identical times where there were no records for that time period? Yeah, I found 4 other ones with the exact time period. Now, there were some calls and texts during that time, but the phone had no TA records 4 times, 30 days prior, 30 days post, of the exact time. And they want you to look at the jury instruction that says a forced doubt, an imaginary doubt. They're asking you to create evidence in your mind that doesn't exist. The evidence is you can't use it because it's not reliable and it's not used for prosecutorial purposes. That's why T-Mobile didn't come into this courtroom and tell you anything. He can't say whether Mr. Fernandez and Henry Tenen were even together on January 29th when they arrive at Potomac. Henry Tenen is there. Mr. Fernandez arrives, and when I said, do you even know if they're there at the same time? I can't say for certain. They could have been. I asked Detective Johns, you don't know that they were there at the same time. Could have been. And I'm like, what's the opposite of could have been, Detective Johns? That they could not have been. I mean, how hard was it for me to get that out of him? They don't know. The technology isn't that good, but if they were there together, it's like a minute or 30 seconds max. Otherwise, they're just 2 ships passing in the night. And why would there be 2 ships passing in the night on January 29th? Because it's 2 days after Mr. Fernandez signs the lease with Jeremy Ordway, and all of the things were being moved to the garage. It's not at all unusual that a landlord would go at the end of the month when there's a new tenant coming in and an old tenant leaving and moving all of his stuff to the garage to make sure the house is in whatever order the new tenant expected it to be in, or for the other 20 times in one singular month that we know Mr. Fernandez went there to do work. And we know that he was there when tenants were there and when they weren't there, because we pointed out every time a tenant would leave or come. And we also know that on the next date that we're going to talk about, Agent Blythe agreed that there were times when on the 15th, when Mr. Fernandez was at the house, Mr. Tenen left 29 minutes before Mr. Fernandez did. So there's plenty of facts to suggest that Mr. Fernandez would be there when Mr. Tenen was not. And Mr. Agent Blythe, again, found no evidence that Mr. Fernandez or his device was ever with Henry Tenen when Henry Tenen was doing whatever it is that he was doing on that day connected with the homicide. This is the night of the homicide, and what Agent Blythe talked about is that there's no evidence that his device ever left his residence, and we talked about whether his phone was off or not and the certainty in which he could say that. Now, this is the part of the trial, if you recall, where I brought to your attention that Henry Tennant had 2 phones. And then I talked about where those phones connected and that they were separated. And that common sense would be that if at some point in time they were calling each other, they weren't together. So whoever was involved in this homicide that night with Henry Tennant had the other phone. If they want you to believe that Mario Fernandez was that other person, although there is no evidence to believe that, why would Mr. Fernandez turn off his phone? He had no history of turning off his phone, and Henry Tennant would have given him the other phone. It doesn't make any sense. They're just asking you to fill in gaps because they can't do it. The other person had Mr. Tennant's other phone. That phone connects over by Mojos, and there's not a suggestion in the world that Mario Fernandez was ever anywhere out of his home on that night. You heard from Mrs. Butler. She's the one who said that Mr. Fernandez deleted a bunch of stuff from his phone right before his police interview. We know that Mr. Fernandez was involved in a sex tape and had lots of personal things on his phone. He cooperated. He gave his DNA. No reason to believe a person would not expect that they would ask for the phone. Why they didn't ask for his phone, that's your decision to make as to what kind of thorough investigation they did. They don't know what he deleted. They don't know if it was porn websites, which you saw Ms. Butler. She said, look at all these things he deleted. I saw you guys leaning in and looking. You saw the contents of the websites that he deleted. All reasonable things that if law enforcement was to take your phone, you may not want really the world to know what you're looking at in the privacy of your own home. But not a shred of evidence with all of her detail, with how good she was, with the precision that she was able to go through these records, that anything that was deleted had anything to do with the homicide of Jared Bridegan. Next. Oh, she talked about the search of John Biggerstaff, the thumbnail that she says that she doesn't know whether he clicked on or not. And it wasn't even the right firearm. It was the 9mm as well, and all the other searches that John Biggerstaff either looked at or had thumbnails of. Then you heard from Mr. Ostertag. He's a JSO detective. He was in the digital forensic, and the big theme that they had with him was Mr. Fernandez, he wiped his phone. So all those months later, where they never collected his phone, and when they did, he was cooperative, he turned it over, they wanted you to believe there was some evidentiary value that he wiped his phone until we got up on cross-examination. You saw scrambling over there. I went over to Miss Day. I said, get me the date that they say his phone was wiped. I bet you there's a T-Mobile purchase. Sure enough, T-Mobile, he got a new phone. That's what happened. Everyone wipes their phone when they get a new phone. They keep saying different things like, he wiped it, he got a new phone and device, and they showed you that on T-Mobile, but he kept it. That's weird. There is no evidence whatsoever that anything was unusual other than 8 months or so after the homicide, or 6 months or so after the homicide, he got a new phone and he wiped his old phone. That's what happened. The IME numbers are totally different, and that was the evidence in this case. This is the gentleman from ATF who said that he believed it was a Glock. I'm sure it was. He believed it was a 10mm. I'm sure it was. He seemed to know what he was doing. Can't connect it to this case at all. Doesn't even know if it was a Generation 44. They make 3 different models. Can't say what model it was. Tens of thousands of 10mm Glocks in circulation since 1991. That's what he was able to tell you. Next. Then you heard from Mr. Barton. And even the government said, there's got to be truth in there somewhere. Who cares what the truth is with these 3 guys? The truth is, Fred Barton says the guns were dropped off and it was in a gun cabinet. Juan Biggerstaff says the guns were all dropped off in gun cases and appropriate gun boxes. John Biggerstaff says, I was a convicted felon, couldn't be anywhere near him, had to get rid of him. Who told you anything that any of those stories had anything to do with Mr. Fernandez. This is the part of the trial, folks, where you're waiting for the shoe to drop and you're like, all right, someone's going to take the stand. They're going to be offered immunity, which means they can't be prosecuted. They can tell you the truth. And they're going to put their chin to their chest and they're going to say, I didn't know it was going to be used for that purpose. I regret what I did, but I did give somebody a firearm, or whatever the case may be in every murder trial where they attempt or they can establish a connection between whatever evidence they put on for days at a time and the defendant. They didn't do that in this case. John Biggerstaff, first question I asked him, you heard Mr. Mizrahi ask you all these questions about your guns. Where are they? But he didn't ask him the one question, did you give Mr. Fernandez a 10 Miller firearm? No, I didn't. I haven't seen those guns since 2016. I asked him every which way. I even tried to trip him up. I'd ask him fast, I'd ask him slow. I'd ask him one time, then I'd ask him another time, and I'd ask him a different way. I'll let your memories reflect how many times I asked John Biggerstaff and how many different ways I asked him whether he helped Mr. Fernandez participate in this murder. His answer was no, 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 every single time. I didn't call John Biggerstaff as a witness. The government did. They're acting like we called an incredible person and you should hold that against us. They called him, and then in first closing, they got up and said, as a liar. Well, I didn't call him. He doesn't connect my client to that firearm. Maybe he is a liar. Maybe he did keep his gun. Maybe he doesn't want to be arrested for being a convicted felon and go back to federal prison. I have no idea. But the one thing I'm certain of is that John Biggerstaff, Juan Biggerstaff, or Fred Barton never mentioned Mario Fernandez in connection to that 10 millimeter firearm. So why did they put all these people up there for one gun that's not connected to this homicide to have you learn that there is no connection to Mr. Fernandez? Ask yourself what the point of all of this was. This is a first-degree murder case. The consequences are real. There has to be evidence. There has to be connections. There isn't a single one related to John Biggerstaff's 10 millimeter firearm or any other 10 millimeter firearm other than one was used in this homicide, and there's not a shred of evidence that Mr. Fernandez ever owned a 10 millimeter firearm, was in possession of a 10 millimeter firearm, was seen in a photo with a 10 millimeter firearm, was seen at a gun range with a 10 millimeter firearm. Nothing. Zero. Zilch. Is he a law enforcement officer and he's credible? Is he not credible? I don't know. I didn't call him as a witness. The government did. You have to ask yourself what the purpose was and why. I don't care. He doesn't connect, other than he acknowledges that Mr. Fernandez helped him set up for his wedding. So when they say, God, it's so weird that on the 15th he would be with wrongdoers, he's not with wrongdoers. He's with a guy whose son came into town to get married, and Mr. Fernandez helped him bring tables and chairs to his wedding, confirmed by Juan Biggerstaff. That's what you learned from Juan Biggerstaff as to why Mr. Fernandez may have seen these people, Juan and John Biggerstaff, around the time of the homicide, because he got married at the time of the homicide. And you don't have to take these guys' word for it, because they think they're liars. I asked Detective Johns, did you find receipts from the tables and chair place? He's like, yes, they picked up tables and chairs. The cellular data confirmed that Mr. Fernandez was with John Biggerstaff at the tables and chairs storage place, and a delivery was made. This isn't like some made-up story. That's what the evidence is. But they don't tell you that. They tell you, well, it's suspicious the night before the homicide he was with John Biggerstaff. When they know the evidence is he was helping him set up for a wedding. It's not suspicious they'd have communications. And the school teacher didn't provide a ton of evidentiary value, with the exception of, she said, there was some theme that this was some kind of fake marriage, that from 2018 until 2022, Mr. Fernandez was some kind of contract marriage with Shanna Gardner. But he knows all the kids' medications. He does pickups and drop-offs. He goes to all the school projects and school performances. The school knows him. He was the first person with Miss Shanna Gardner to introduce themselves to the head of school. That's the purpose. That's ludicrous, that they somehow hired Mr. Fernandez and then 4 years later to do a contract killing and he just integrates himself into the family and the schools and the communities, and that's why we called the teachers. That's why we called Ms. Orpitsberger, who also, by the way, said 7 o'clock on a Wednesday, the community would report suspicious activity. And they want you to believe there was all this suspicious activity with a truck and Mr. Fernandez running back and forth, if you want to believe that theory. Next. Then you heard from Detective Chris Johns, who went through the financials, and you heard Mrs. Stifler in her opening statement, and this could not be more important, and she looked at all of you. I saw many of you write it down. It will be in your notes because I watched you, because when I heard the words come out of her mouth, I can tell you I know this case pretty good. I know the evidence in this case. I know the records. And when I heard the words come out of her mouth, I almost fell out of my chair. You heard what she said. There is... Wait.
A week after Jared Bridegan's death, the
No, I-
document
Okay, hold on, pause. Let me, pause it. Let me see. Mr. Dreiser, the jury needs a break. Okay, right? Y'all need a break? We'll take the break. Leave your notepads. All right, court's in recess until the jury buzzes. When you're ready, Mr. Dreisen. Oh, wait. Okay. Whenever you're ready.
Let's not let this fact get lost. I know this case. I almost fell out of my chair. It would have been a horrific fact if it were true. Use your collective memories to recall what the government told you in their opening statement. To make it seem as though Mr. Fernandez gained $50,000 the week after the homicide for his heroic act of helping the Gardner Trust commit a homicide, Ms. Stifler told you, quote, a week after Jared Bridegan's death, the defendant transferred $50,000 from Shanna Gardner's trust into his own personal account. And we all know that's not true. It's not even close to true. It did not happen. It was such a big statement. I watched you all. Your notes will reflect, and it's not true. And I spent the time going through with Detective Johns, statement by statement, to show you there was no $50,000 transfer. There wasn't a $10,000 transfer, a 20, a 30, a 40. There was nothing but two transfers, one of $1,500, one of $1,800, and maybe another $1,000. And when I asked him, do you know if those went to Mr. Fernandez? He would say, no, I don't know. He has all of Mr. Fernandez's financial records. If those did go to Mr. Fernandez, he would know it. The evidence is that that did not happen. Mr. Fernandez, think about if they had told you this. No one would have wrote it down because it wouldn't have been important. Mr. Fernandez took $50,000 of his own money and transferred it to a joint account of First Choice Home Rentals so that he could pay for a $15,000 air conditioning unit and the checks that he wrote to Henry Tennant. There wasn't enough in the account. All Mr. Fernandez did was transfer money that he had in his account, hundreds, I think it was $212,000 or $160,000, and he moved $50,000 to the business account. It covered all the expenses, and then he moved the remaining balance back to himself. What benefit did Mr. Fernandez get from the transfer of that $50,000? And the answer is zero. It was his money, and he covered expenses to his premarital rental property. That's what happened. And you have to ask yourselves when you go back and deliberate, why did they tell me that? This case is like 3.5 years old. They have to know what money was moved. Why did they tell me that in opening statement? And then gauge the rest of the evidence that you heard to determine if that was credible. How many times did they tell you, we don't know where Mario Fernandez was during the homicide? And then there's no evidence of who was driving the blue F1 Ford 50 the night of the homicide. And then in her closing statement, she told you two things. She said, go to the next slide. I think maybe on there. Well, I'll get to that. And I've been jumping the gun on the slides, but I'll skip, I promise, when I get there. She told you in opening statement that two people can keep a secret if one person's dead, which means that two people who are alive can't keep the secret, right? That's what the saying is. Then today, she told you it had to be Mario Fernandez because it was mutual destruction between Henry Tennant and Mario Fernandez. Those are two completely different concepts. Two people can keep a secret if one is dead, and it's mutual destruction. And then we don't know where he is, but he's in the blue truck. Two totally different concepts. And then Ms. Stifler gave you this whole example about how it had to be Mr. Fernandez in the blue truck because it was mutual destruction. There's only one person Henry Tenen would trust, and it's got to be Mr. Fernandez. Has to be because no one else would get involved. No one else could take the chance to get caught. Has to be Mario Fernandez. And then about 30 minutes, and right before she closed, do you remember what Ms. Stifler said to you? Well, of course there's no DNA. Of course his hair's not in the truck. Of course there's no surveillance, because he's an architect of the crime. And architects hire the painters. Of course you don't have paint on your hands if you're not a painter. Of course people that hire people to commit crimes, cowards, they hire people to commit crimes so their DNA is not at the scene, so their hairs are not in the Ford F-150, so they're not caught on surveillance. Well, which one is it, folks? Is it that Mr. Fernandez has to be in the truck because he's the only one that Henry Tenen would trust? Well, that's not good. That doesn't fit the evidence because there is no DNA. He's not caught at the scene. He's not seen on surveillance. Not a shred of evidence connects Mr. Fernandez. So let's pivot real quick. He's the architect. He's not in the truck. He probably is at home. We don't know where he is because he paid for it. They told you two completely separate theories. Why? And the answer is because they don't know who is involved. And when you don't know who is involved, you don't know what happened. You don't know who's connected to Jared Bridegan. You don't know who's connected to Shanna Gardner. You don't know who's connected to Shanna Gardner's family. You don't know. So they just say, well, it has to be him. He's the only connection. That would only make sense if they knew who was involved, and they don't. Henry Tenen is not dead. They told you he's dead to you. Two people can keep a secret if one is dead. He's not dead. He's alive and well. You just didn't hear any evidence from him. He just didn't come in here and tell you that Mario Fernandez paid you. You just didn't hear that. But it's not because he's dead. He's alive and well. The government just didn't put that evidence on. Ms. Gardner was mentioned 26 times in the opening statement, and you didn't hear anything about Ms. Gardner in this case. You think maybe there's another part of the story that you don't know? And if you don't know all the facts, how are you supposed to determine if Mr. Fernandez is the only link to Jared Bridegan? They're desperately clinging to that fact. That's how they want to win. All this stuff, the totality of the evidence, makes only sense that it's Mario Fernandez. Except for if you go back there and go, we don't know who's in the truck. We don't know how Ms. Gardner's involved. I didn't bring up Ms. Gardner. The state did 26 times in their opening statement, and you didn't hear anything about her during this trial. How are you supposed to convict Mr. Fernandez of first-degree murder and solicitation to commit first-degree murder when you don't know who is involved? The answer is you cannot. We can't present that evidence. Talked about the date of crime and what evidence you heard. I'm not going to go over that again. We talked about weighing the instructions and whether the witnesses were straightforward, and I'll ask you to consider that when the judge reads it to you. There's another jury instruction that says the number of witnesses and the number of exhibits is not what counts. This whole stack of evidence that's been in front of you for the last 6 days, these framed jackets and these framed shell casings and the keys to the truck, just because there's a lot of it, and just because they called more witnesses than we did, the judge is going to instruct you that you have to weigh the evidence, not the number of witnesses and not the number of exhibits. Mr. Fernandez elected not to testify in this case, and I spent a great deal of time in jury selection speaking to each and every one of you about many different reasons why a person would not testify in their own defense other than the fact that they are not guilty. The judge is going to read you that the Constitution requires the state to prove its accusations against the defendant. Mr. Fernandez has a constitutional right not to take the stand in his own defense, and you cannot consider that in your deliberations. I asked you in jury selection that if anyone were to go back there and do that, and you all agreed that would be unfair, that you would follow the law, that you would not allow your other fellow jurors to consider that or talk about it if the judge in fact instructed you on it, and she is going to. And I hope that you will hear that objection, you will understand why a person who is not guilty, in fact, a person who is innocent and did not participate in this crime, still may have elected his constitutional right to not take the stand. And that's why I spent so much time in jury selection talking about why a person may not do that and getting you all to agree and understand that it's not because he's hiding anything, it's because he has a constitutional right that he's exercising. These have been behind you the entire time. I asked you at any given point to look and say, with the totality of all of the evidence that you heard during the course of the 6 days and the evidence that I reviewed with you this afternoon, what evidence was there that Mr. Fernandez wanted Jared Bridegan to die? The answer, none. What act did he do? What did he say that was intended to aid or to incite, cause, encourage, assist? The answer is none. I showed you every witness. I showed you a picture of every witness. We went through and talked about it. I know I didn't talk about everything they said, but I'm telling you that your collective memories will reflect that there was no evidence that Mr. Fernandez wanted him to die. There was no evidence that he said anything to Henry Tennant to cause him, encourage him, or assist him. And then for the criminal solicitation, next, that he solicited Henry Tennant prior to February 16th. What witness? What evidence? The checks were for legitimate work. They were post the homicide. They're going to keep harping on these checks. There's no check in November. There's no check in December. There's no check in January. There's no check in February. 2 checks in March, 1 check in April. That's it. That's what they're going to tell you is the circumstantial evidence that he solicited someone. Henry Tennant committed this crime on credit. Murder for credit. It just doesn't happen, folks. There's no financial transactions to support circumstantially, and there's no evidence or testimony to suggest that Mr. Fernandez did something or said something to Henry Tennant. None. Doesn't exist in this case. And lastly, we get to the reasonable doubt instruction. And a reasonable doubt as to the guilt of the defendant may arise from the evidence, meaning that what you heard is not consistent with a crime. The evidence in this case is that Mr. Fernandez wrote Mr. Tennant some checks for legitimate work that he did. Mr. Fernandez owned Potomac, and that's why he was there. The evidence that we saw was that he would go there regularly. He had a legitimate reason to be there. He would go there twice in a day. He had no contact with a 10mm firearm. All of the reasons that the evidence that you heard would give you doubt that he was involved in a first-degree murder or solicitation to commit murder. That's what that instruction is telling you to look at. Or it's telling you, don't look at the evidence, or look at the evidence, and look at the lack of evidence. What connection is there to a 10mm firearm? None. What evidence is there that Mr. Fernandez asked, did something, said something to Mr. Tennant? There is none. What evidence is there that Mr. Fernandez intended or wanted Jared Bridegan to die? There is none. That's a lack of evidence. And if you go back then, you're like, they just didn't prove it. I was just waiting to hear one piece of evidence that would make me know. That's what that jury instruction says, is that the 3 things that you use are the evidence itself, which in this case should give you reasonable doubt. The lack of evidence, which in this case certainly should give you lots of reasonable doubt. And then there's a conflict in the evidence, when the evidence just doesn't line up. When one witness says the guns came in a lockbox, and another witness says they came in gun cases, no witnesses say that Mr. Fernandez had anything to do with the firearm. That's a conflict in the evidence that doesn't make sense. Conflicts in this case, there's no DNA in the blue truck, but the government wants me to believe that he's in the blue truck. There's no fingerprints in the blue truck, but they want me to believe he's in the blue truck. There is no physical evidence that ties him to the scene. No surveillance, no eyewitnesses, nobody that puts him outside of his house on that night. But they want you to believe that he's running from his house to the truck, to turn back off his phone, to run back later in the night, to hand back keys. I mean, you heard that today. There's just, like, what evidence is there that Henry Tennant needed to get keys from anybody else other than the driver of the blue truck? So they just throw it out there. That in and of itself is a conflict because the evidence doesn't support that he ever left his house. And if that gives you any doubt, just one singular doubt, that you aren't convinced that every single one of you knows with every fiber in your body. You heard Mr. Mizrahi say in jury selection, it's been referred to as an abiding conviction of guilt. This is the highest standard. Being convinced. And I spoke to you about probable cause. It's the lowest level of proof in this country. To arrest somebody, to pull them over, it is literally, by law, the lowest standard of proof we have in this country. And how many times has the government told you in this trial that they believe other people are involved, like John Biggerstaff, that he's lying to you, that he gave him a firearm? They haven't arrested John Biggerstaff. How unfair is it what they're asking you to do? They're asking you to go back in this room with the highest level of burden of proof, the toughest burden of proof that we have in this country, beyond to the exclusion of a reasonable doubt. And they want you to believe that John Biggerstaff gave Mario Fernandez a 10-millimeter weapon, and they have never even arrested him. They've threatened him. They've offered him immunity, but they can't even arrest him with the lowest level. They're asking you to find that it's reasonable that he gave it to him using the highest standard. That is simply unfair. And it tells you that they cannot prove that John Biggerstaff provided a firearm. Otherwise, he would not have been in here on his own volition, walking in. He'd be a principal to first-degree murder of Jared Bridegan, and he is not. Before we move on, the word that they use is convinced. Abiding conviction of guilt is what Mr. Mizrahi referred to, and lawyers refer to that as. You have to know, and if you don't, the judge is going to tell you that if you have a reasonable doubt, you must acquit the defendant. That's what the law is. If you go back there and you're like, they just didn't connect all the dots, the judge will tell you in her words, you must acquit the defendant, meaning you have to find him not guilty if you have one reasonable doubt. Elements we have gone over and over every time we've spoken to you. I want to point out number 4. The judge is going to tell you that the lawyers are not on trial. Your feelings about them should not influence your decision in this case. If I acted a certain way, if I was too aggressive with a witness, if you thought I was pushing Detective Johns' buttons, or I could have been nicer or more polite, I will take the criticism. I'm not the best lawyer in the world. I make mistakes. I get caught up in it. I get emotional. If you go back there and you think that something I did or Mr. Hill did, I'll concede it was probably me. In this case, was unprofessional or whatever the case is, don't hold that against Mr. Fernandez. Hold that against me. And that's what the judge will instruct you. Music to your ears. This is the last time that I get an opportunity to speak with you in this entire case. So first I want to tell you that the government gets to get up now and they get to tell you all the reasons I was wrong. And they get to tell you everything about what I said and why Mr. Fernandez is guilty, and they're entitled to do that, and I assure you Mr. Mizrahi is going to. But what Mr. Mizrahi is not allowed to do, he's not allowed to reopen the evidence. He's not allowed to give you evidence that you didn't hear. He's just allowed to argue that with what evidence they've already submitted, it's enough to convict Mr. Fernandez. That's it. That's all he can do. And before I ask you to return a not guilty verdict on all of the counts of the information, I want to thank you. I want to thank you for your attention, your candor in jury selection, your time, paying attention. It has been a long, dense few days or week, and I am grateful, but most importantly, Mr. Fernandez is grateful, because this is the most important week of his life. And on behalf of Mr. Fernandez, I want to thank you for your time and your attention. As to the verdict of solicitation, we're going to ask you to return a verdict of not guilty. As to verdict murder in the first degree, we are going to ask you to return a verdict of not guilty, because we believe the evidence in this case shows the government wholly and woefully failed in their obligation and their burden to prove to you that a crime was committed. And most importantly, it's because we believe that Mr. Fernandez is innocent, and he got wrapped up in something that he never should have been wrapped up in, that he knew nothing about. We'll ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Dreiser. Does, Mr. Mizrahi, do you need a moment to set up?
I just need a brief moment, Your Honor. We can do that while the jury is in the courtroom. It should not take me long, and I'll give the defense a chance to move all their stuff.
Jurors, do you want a brief recess? Are you all good? Good? Okay.
Your Honor,
Okay. Let's take 5 minutes, okay?
I'm sorry. I'd like the principal up if you could leave it up. Yeah, put them all up. I'm standing up. What's the problem?
No. The bigger memory. Got it good. He just finished and said he got wrapped up in something. He got wrapped up in something.
Is this plugged into the thing? Directly into here? Is this plugged into here?
Yes.
Started. Well, it's not working. It should work from this. Oh, because I didn't have it on. There's going to be pictures. Okay? You don't have to. Make sure everyone knows. I don't see Kirsten. Go ready, you are.
All right. Mr. Holman, ready. Where's Mr. Help? Mr. Dreiser. Where's Mr. Hill?
Close your eyes. Ready to go. I'm not saying anything. It doesn't work from here. I understand the mic's still on. It doesn't work from here. On the screens. Got publish all. That's America.
All right, welcome back, members of the jury. Everyone may be seated.
Hey, please the court.
Yes.
Counsel. Ladies and gentlemen, grace is defined in our culture as polite, fair, a forgiving attitude towards others. We live in an amazing country, and the beauty of our country is we get to have trials like this. Trials where we get to hear very competent, very well-trained defense attorneys get up here and argue to a jury of his peers that Kirsten Bridegan did not show the grace that the murderer of her husband showed her. That was an argument that you heard from that mouth. That somehow Kirsten Bridegan's desire to hold those accountable and not have the murderers of her husband, the murderers of the father of her children at her funeral for him, isn't grace. She wanted the kids there. But the fact that a man is angry 2 weeks after a widow has buried her husband because she's just being a bitch. The insight of the personality of that man is striking. The only grace is that Kirsten Bridegan wanted someone that loved Jared to be present when his children were notified about his murder, not his untimely death, his murder. And by the way, she went there with her dad, not by herself. She went with her father to stand next to her and be with her during this process. The defense has the, and let me say this before I get, I'm going to say a lot of what the defense says, and Mr. Dreiser and Mr. Hill have done a wonderful job representing their clients within the bounds of the law, and I am not attacking them personally. Maybe a little bit different from what you heard from the other side, but I'm not attacking them personally. They're supposed to do what they're supposed to do. But when they say things like, nothing nefarious, what they're trying to get you to ignore is the starting point. The murder is the starting point. The grace that Kirsten Bridegan showed is the starting point. Nothing nefarious that implicates this defendant. This defendant took this man and turned him in to a medical examiner number on a slab. That's the reality of this case. We don't do it to inflame you, but we do it to inform you. This is what happened. And this is the nefarious thing that occurred. The nefarious thing is not threats within a divorce pleading. The nefarious thing is he ended up with 2 bullets and bled out not knowing whether his daughter, was okay or not. That's the nefarious thing. So the analysis has to be what evidence is there that this defendant, is a principal to that act. Your decision is not whether there exists a text message saying, please kill this person for me. Your decision is not whether or not the pickup truck was in a gravel lot near the crime scene. These are not your issues. And we spent hours and hours in closing argument listening to those kind of arguments. That's not the question. The question is whether or not this defendant is a principal to the first-degree murder of his wife's ex-husband. We heard lots about the shoe drop. The shoe drop. You know what the shoe drop was in this case? The shoe drop was after weeks and weeks and months of investigation where Kirsten Bridegan is posting justice for Jared, trying to find out who is responsible when she knows in her heart who it is. But we need evidence. We have to be able to prove it. The police saying, listen, we can't just arrest people because you think they did it. You can't arrest people because you have a bad divorce or bad child custody and you'll always fight. That's not evidence. Motive is not evidence. We have to have evidence. The shoe drop began with the happenstance finding of the tire propped up against the Potomac Avenue address and discovering that, holy cow, the DNA on the murder weapon, the tire in the middle of the road that caused Jerry Bridegan to get out of his car, that was essentially the impetus to his murder, whether it be a firearm or a stabbing, whatever it ended up being, that helped cause the murder. The DNA on that tire is Henry Tennant. And that Henry Tennant, his ex-tenant, who's so poor he can't afford the rent and had to be kicked out, and he was tired of having him live there without paying rent, killed the victim, and he gave him $10,000 in the weeks after it. That's the ultimate shoe drop. There is zero other explanation from this case. He keeps saying they can't prove what happened. That's what happened. There is zero link between Henry Tennant and the victim. This defendant is the only link, the only hub. The shoe drop is his tenant that he had tremendous contact with over and over and over again, that he paid $2,000, $3,000, $5,000, and lots of other cash payments that we don't really know about, that person killed Jared Bridegan. They don't get any benefit for coming into this court. We didn't know it was going to happen. Stifler and I try to keep our poker faces. We did not know that in their opening statement, he was going to stand up here and say, Henry Tennant did this. No idea that was going to happen. And we 100% agree with defense counsel that a lot of this stuff proves Henry Tennant did it. We didn't know that was going to happen. A tremendous amount of our proof, as in any murder for hire case, is that the person that was hired has a link to the person that hired them. All that is, they don't get any credit, any benefit, any points for standing up and saying, admit what you can't deny and deny what you can't admit. They don't get any points for that. They have to say Henry Tennant's involved because the evidence is overwhelming it's involved. But they have to deny everything else or the defendant is guilty. Now, a few points about Mr. Tennant. We heard so much of the he brings up the jacket and the shoes, and we can't tell you what happened. They stipulated it was Henry Tennant. They keep saying, why did they do all that? The defense counsel says, why did the state do all these things? Why did he argue that? He's saying that Henry Tennant did the crime. Do I know beyond and to the exclusion of every reasonable doubt that that's the jacket? No, and the detective just said it was consistent with. He believed it to be the jacket, but we don't know that for sure. It's not relevant. He did it. That's not what's relevant. You know, Henry Tennant may be a lot of things, and one of them is a murderer. But you know what? The only two people that knew that little Bexley was in that car were this defendant and Shanna Gardner. And this man is uneducated, alcoholic, spends his money all at liquor stores. You'll have the records. That this man, a desperate, over 60-year-old laborer, handyman, making a few $100s a week. He sees Lexus driving, Toyota Tacoma driving, brand new cars, big spender landlord. And Mario Fernandez turns Henry Tennant from a desperate handyman into a hired hitman. Here's a newsflash. Nobody saw Henry Tennant do this crime either. All this incessant arguing about no one saw the pickup truck. No one saw Mario Fernandez. Over and over. No one saw Henry Tennant. We have some grainy video that later we piece together and go, yeah, that sure looks like Henry Tennant. That was after weeks and months. We didn't know who Henry Tennant was. And if you look at the vehicles, you can never see anyone in any of those vehicles beyond it to the exclusion of a reasonable doubt. And you know how you know that? There's arguments you heard over and over and over again. You don't know that that's Kirsten Bridegan and her mother in that car. You know it because they tell you that. If you look at that video when they come in, you can't identify anybody. And that's a clear shot from the police station into their front windshield. There is no video that's going to be able to look into a car and tell you who is inside that vehicle. But this is a still shot from the video that we introduced in evidence. And let me be clear. This isn't proof beyond a reasonable doubt. Okay? But the figure in that vehicle, in that grainy still shot, this is after the homicide, is clearly not a 6'6" black man whose head would be at the top. It is certainly consistent with a man of the defendant's stature. Well, is that him driving beyond the reasonable doubt? I don't want y'all to get confused. No, I can't say that. No one can say that. It is a shadowy figure of what appears to be a moderately sized individual driving, maybe even short. The defense argues the defendant is at his house. There's no evidence of that. His phone pinged there earlier and pinged there later, but we don't know what he's doing during the time frame. Right? He says in his non-custodial interview, he says he's passed out high on gabapentin because he has a migraine and never talked to the kids. We'll get to that in a minute. The entire defense was this defendant wasn't seen murdering the person or positively identified in the truck, which is why you hire someone else to go shoot a person. that this defendant didn't leave behind any forensic evidence at the scene, which is why you hire somebody else to kill the victim. That we presented no letter, email, or text from this defendant saying, will you pretty please, with sugar on top, kill Jared Bridegan for me? If you set aside the checks, if you set aside all of the circumstantial evidence of the dry run and everything else. That's also why you and your co-defendants delete messages. It's why you give Mr. Biggerstaff a heads up that he might be questioned. It's why you factory reset a phone. By the way, there's no evidence he purchased another phone. He purchased something at a phone store for $70. Okay? That's what the evidence is. And it might have been a phone. There's no evidence of that it is a phone. Just could have been. But more importantly, the evidence is he kept his phone. And anyone that has lost anything on their phone or even gotten a new phone, I guess back in the old days, you had to re-input everything. It just so happens to be a few days after his tenant is arrested on unrelated charges. The entire defense is what you would expect to find in a murder for hire case. So then it goes, and you heard this argument, well, Henry Tenen didn't come into this courtroom. Henry Tenen, then the next words out of his mouth are, Henry Tenen has the defendant, by the way, and Henry Tenen, have a Fifth Amendment right to remain silent. And that should not be held against anyone. So if Henry Tenen has a Fifth Amendment right, this defendant has a Fifth Amendment right, apparently if you can get away with murder if your co-defendant doesn't squeal on you. That's the defense in this case. That's really the defense in this case. Ignore the mountains of circumstantial evidence that points to the defendant and just realize Henry Tenen didn't testify and no one saw him in the truck. We don't have those pieces of evidence, but would you ever expect to have those pieces of evidence in a murder for hire case? By the defense logic, if the killer doesn't testify, it's impossible to prove a murder for hire case, absent a full written confession. Luckily for everyone, the law says that they're wrong. There is no particular piece of evidence that's required. The law requires a diverse group of citizens willing to give up their time and treasure to sit in this courtroom and listen to the evidence and evaluate it fairly. The defense challenged each and every one of you to listen whether or not there's a logical inference from the evidence instruction. Okay? Ms. Stifler, and God bless her, lawyers do it all the time. We like to use fancy language because I don't know if it makes us sound smarter. We exit the vehicle instead of getting out of the car. We say the aforementioned. I don't know why we do that, but we do it. They don't teach it in law school, but we just do it. It makes us feel lawyerly. But she says, logical inference from the evidence. You know what that is? And you know what will come out of Judge Kite's mouth? Is each and every one of you must use your common sense in deciding the evidence in this case. Logical inference from the evidence means common sense. And if you don't use your common sense, then the only cases that could ever be proven beyond a reasonable doubt are those with direct evidence like an eyewitness or confession. Just think about it like this. We talked about in jury selection. If, let's just speculate that Henry Tenen comes into this courtroom, he did not, there's no evidence of this, and says, I was paid by Mario Fernandez to kill the victim. What evidence would there be as to bias for Henry Tenen? That he's facing first-degree murder charges? That he has an interest in how the case is decided? That he may be looking for a deal in order to get him to testify against someone that the state wants him to testify to? That's crappy evidence. And if that's all we had, then we would have direct evidence, but we wouldn't have the beauty of the circumstantial evidence in this case. You know, Lady Justice wears a blindfold. And that concept is the concept of circumstantial evidence, that it doesn't have bias. It doesn't have vision problems. Circumstantial evidence speaks the truth. You have an abiding conviction of guilty in this case because it's a marriage of the logical evidence that we have and the gut feeling in your heart. That's what abiding conviction means. It is a marriage between your mind and your heart. Your heart screams to you this defendant is guilty. Jared Bridegan was barely cold in the ground, and this defendant spent 2 weeks after, and this defendant is bragging what a jerk he was, what an awful person his widow is. The only people in the world that knew about the timing, the location, that had a desire for Jared Bridegan to be heard, that are criticizing him just the weeks afterwards, that got everything that they wanted. They couldn't contain their glee at his untimely demise. You can be entirely convinced and have an abiding conviction of guilt and it be lawful. You're not filling in blanks. You're using your common sense that is given to you by our Maker. And your God-given common sense can be enough that, of course, the hub of the wheel with all these different spokes was this defendant, and he was married pursuant to a contract with the with the Gardners to kill the victim, hired a desperate handyman to become a hitman, and the circumstantial evidence screams that to you. And that's an abiding conviction of guilt. And that is one which does not waver and vacillate because circumstantial evidence doesn't change. Now, they did a wonderful job of arguing about things we can't prove, which we stipulate to. We don't have someone identifying him or a fingerprint or DNA, but what we have, what they didn't argue to you, is that you have an abiding conviction of guilt. But I want to spend a little bit of time going over what the evidence is that we have. It's been belabored at this point, but I feel necessary because I want to rebut some of the things that defense counsel says. So we talk about motive. By the way, the most smiling, best looking photograph at a funeral I've ever seen. That's what this is at. Where her children are remembering their father. That's what abiding conviction is. Defense counsel talks about the amicable child custody and divorce proceeding. They put out that little thing. Did you notice that when it was closed, it said line 318? That was the number of entries. There were 318 entries in that 8 to 9 years of divorce. This was not amicable. Kirsten Bridegan told you that it would be closed for a couple of months, then open for a couple months, then closed for a couple months, then open for a couple months. The child custody issue, let me be clear, it definitely applies more to Shanna Gardner than it does to Mario Fernandez. Not his kids. But this defendant had financial reasons, kind of glossed over by the defense. They didn't spend a lot of time with Taylor Crudis other than to, I guess, personally attack us about the questions and keeping her business private. But she was a really important witness in this case because she says two things that I think each and every one of you should find striking. Says it's a hit and run. Okay, that's just weird. Makes it seem like it's a traffic accident. It's not. Okay, whatever. He says he has a contract, not a prenup. She fought with the defense election. They never said prenup. I know what a prenup is. He never said that. And he said it wasn't with Shanna. He had an agreement, a contract with the Gardners, meaning the parents, the wealthy people. He had 75,000 motives to do this. This guy, you have the documents. He got VA benefits and a rent for some slum little houses. That's it. He was working as a maintenance man in a gym. He's driving around $50,000 cars. He gets to keep the money. They sold their marital home. He gets hundreds of thousands of dollars. He gets $75,000 checks at once. That's the motive.
Mr. Mizrahi, I think you knocked your microphone off. Okay.
Can y'all hear me?
All right. Thank you.
Thank you. $75,000 because he had a contract. His parents. That's a pretty good motive. Mario Fernandez is over us. I'm going to go through this very quickly. Hopefully I don't get yelled at too much. You have the video. This is why we put in an interview. That wasn't even an interview, by the way. The police asked like 4 or 5 questions the whole time. It was all the defendant going on and on and on and on and on. They said, tell me how things were. How'd you meet Miss Gardner? He saw how things were. This is what he said, which corroborates the whole contract idea. This is the marriage of it. He said, how did you and Shanna get together? He saw how things were with Jared. He sealed the deal with Shanna because otherwise he could not help with the kids. Say anything about love at first sight. He doesn't say we had to be together. He says, I saw how things were with Jared, and I sealed the deal so I could help with the kids. Apparently, Jared's a terrible father because he doesn't want to medicate his children without medical expert opinions, not Mario Fernandez's Googling. Doesn't want his child's beautiful hair turned purple after he told her, I think your hair is beautiful, you should leave it. I think that's about as common of an argument as you could ever have between a father and, by the way, not a teenager, but like a little 5, 6, 7-year-old. I mean, it's one thing fathers may lose control when they turn 16, right? What are you going to do? But she's like, we don't know the exact time of it, but it's some 6, 7, 8. Father does have some control. So wait a second, you're turning your hair purple? Bad dad. Is a man of faith and doesn't want people without his faith participating and influencing the baptism of his child. That's bad. Oh, and by the way, she's never been baptized. That evidence was presented before you. For as cooperative as they want to make it seem because she bought her a dress, Jared's death ended that little foray into Mormonism that the defendants did not want. I'm confrontational. We wanted more custody. I don't like him. And then he says weird things like, I just don't know why he got out of the car, which you can take with that what you will. Not a lot of the details had been released to the media at that point. Was raging. In fact, the details that the police thought was he was shot in the car. Remember, the blood's all in the car. So believing he got out of the car, even though he probably did to move that tire slightly because it was not in the middle of the street, it's interesting. He was raging the night right after Jerry Bridegan was murdered, that Kirsten shared that Jerry loved and cared about Mario and Shanna. He actually said that to you. He said it to the detectives, but you get to see it because it's recorded. He said, I just couldn't believe that. What a jerk. I can't remember when he used the B word. How could she say that Jared loved us when he treated us so poorly? He's dead. She's saying, listen, I know we had bad blood between you, but, I love my stepchildren. Can we get along? Kind of thing. He doesn't want that. more interesting things, we say around my table in my house.
Ground. Yes. Ready? You may proceed.
Thank you. And I want to be clear. I think I said it in the beginning. These are my notes. This isn't quote. You don't see the quotes here. All right, you decide what the stuff is. I don't decide it. But this is an argument, and certainly a reasonable inference from his video. I'm using my common sense. You use your own. That he said he was very upset that Kirsten shared that Jared loved and cared about her. He talked about that it was my house and my table, which is interesting since it's 100% financed by his in-laws. That Jared passed away, doesn't say murder. The widow of the murder victim was a bitch. He did say that. He did call her a bitch, or being a bitch. He said she was being a bitch, I think is what he said exactly. And the hardest thing after Jared passed was realizing that they didn't need permission anymore because there was no more split. Another way of phrasing that, this is my argument, not his words, is that they won. I'm going to talk about groups of pieces of evidence because I don't want anyone to get lost on the fact that this location was targeted specifically for murder. And in case it was lost on anyone, this location, when you go to the cart, where we can go back and forth between these two. This is a still from the video, and this is a still from the video at the scene when police were there. There is not, and many of you have been to Jacksonville Beach, and I think there was significant testimony presented on the witness stand. The Jacksonville Beach is a pretty populated place, and that you actually have a road where the only video camera is across a street and some woods. This video camera is not on Sanctuary Parkway. This is on Atlantic and stuff, or it's Atlantic, Huh? America, I knew it was an A. It's on America. So this is a street behind. And, you know, I won't ascribe any supernatural reason for it, but this car driving by, which is on a different road, triggered the video on another road. Who could predict that? That there would be a video from a road behind the woods that would capture the shooting and see the figure. And more importantly, from Mr. Fernandez's case, see the truck doing this little, because remember there's the earlier video where the person with the hand truck at this house triggers the video, and you can see the truck doing that little dry run earlier. Just when I talk about dry run, I'm talking about the dry run on the day in question, showing that the truck has something to do with it. And there's not a darker, more desolate, better location to do this. Only Jacksonville Beach people would know this. You have to scout this. You have to drive around and know this. Henry Tenen from Potomac, I submit to you, would not have figured this out without Mario Fernandez's help. That's full stop. The location, and this also is weaved in with the timing of the whole thing. If there is some motive that we don't know about, or some people with Jared Bridegan we don't know about, despite all efforts, what's the best place to shoot Jared Bridegan on a date night? Where do you know that he's going to be stopped and alone for a period of time? Where do you know it? At the home of the Gardners. He stops and drops off those kids. That's where he stopped. They don't kill him there. That's too close. They have to find another location to do the killing where he will be stopped and his stepkids will be safe. Only after the kids are dropped off does the shooting occur. The only definite stopping point during the drop-off is at their house. And he had to know it was a date night. How many people in the world know about this? We talk about reasonable doubts. Not all doubts. It has to be him. There is no other reasonable decision or reasonable explanation. Let's talk about his. So we have the timing. We have the location that are married, right? The location and timing. Those are the only facts that you had. It's pretty compelling that Mario Fernandez and Shannon Gardner are involved, just based on those things. But we have more because we have his guilty mind. Now, he did a good job in this murder, but he didn't do a perfect job. His phone was not connected. Now, in today's world, the fact that there is absolutely no activity, no phone calls, no TDOA, none of that stuff on a blank screen during the time of this murder, is this defendant is the unluckiest man on the face of the planet, that his tenant that he paid $10,000 for, the timing that only he could know about with date night and location, that his phone happens to be not connected in any way, shape, or form. He's either the unluckiest man on the face of the earth, or he's guilty. Unluckiest man on the face of the earth, the Stifler put on the usage rates. And the usage rate shows he should be using his phone during this time. Now, does he have to be? No. One piece of evidence, but that piece of evidence doesn't lie. It doesn't have motive. It is what it is. But that's not the only guilty mind. It's because he goes and deletes things. He deletes things right before he's going to meet the police. And do you really think it's because he has pornography on there, like he's going to get arrested for looking at pornography on his phone? The police don't have anything better to do? He knows what he's going down there for. He knows. He tells everybody, I know why they're looking at me. My wife's ex-husband was murdered. And then the defense stands up there and says there's no evidence that any of those deletions have anything to do with the crime because he deleted them. This is the catch-22, right? You're either, if you get in a plane, if y'all remember the wonderful book, Heller, that we all had to read in school, Catch-22, if you get in the plane and you're too scared to fly bombing missions over Europe, then you're sane enough to fly bombing missions over Europe. It's a catch-22. You either don't say anything and you fly bombing missions over Europe, or you say, you gotta be crazy to fly bombing missions over Europe, and then you're not crazy. They actually argue to you, we don't know what the deletions are, because he deleted it. I don't know how to respond to that. He says that we're doing half-truths. We're doing half-truths. They can't show you what the deletions are because they're deleted. The factory reset. We've talked about shortly after Tenen is arrested for unrelated charges. And then we talk a little bit about the unplanned trip, and this is not a major part of our case. But the witness admitted on Zoom, he wasn't on the witness stand, on Zoom, that he forgot to tell all of us that he had contacted him before. Remember, he's like, yeah, I just forgot that like a week before he contacted me. Originally, he didn't say that. He's like, yeah, I just kind of showed up that day. And usually people keep the toiletries from their house. They don't stop on the road unless they leave in a real big hurry. I'll just make those minor points. Oh, and by the way, he came back because he knew they hadn't implicated him in anything. That much he knew, and then he came back. Whatever. It's not, does that prove he did this? No, it's just interesting. Let's talk about the 10 millimeter. Lies speak the truth. You shall know them by their fruits. It's hard to envision a scenario that we can link the murder weapon to this defendant without the recovery of the murder weapon than what we presented to you. Mr. Dreiser said, why did we present that to you? Because this defendant's very good friend, who he is having sexual relations with his wife the night before the homicide, has a 10 millimeter firearm that no one can account for. It's unfair. We do have a transcript of Mr. Dreiser saying it's unfair that the state of Florida didn't arrest somebody. The criminal defense attorney says it's unfair that we didn't arrest Mr. Bickerstaff. We have no evidence that he's a principal to first-degree murder. We do have evidence that he provided a 10 millimeter firearm to his friend, but without the firearm, how can you prove it? Mr. Bickerstaff make a big deal about the immunity, and then we had to put his son on the witness stand to say, my dad thinks your immunity is bullshit, and he doesn't trust it. That was the testimony. Your common sense, your reasonable inference from the evidence screams to you that this is where he got his gun. Is it a unicorn? Is it one of a kind? No. Every expert we put on that witness stand, including the ATF firearms instructor, says, I hadn't seen one of those. Mr. Bickerstaff says, I don't know anyone that has them. And then the defense makes a big deal about the pawns, which was good argument on their part. But he actually doesn't say what Detective John says, which is, oh no, we had the names of those individuals. And we looked into their backgrounds, into their phone numbers, and compared it with all the known evidence that we had, compared it to Mr. Tennant's phones. There's no link between those people and Henry Tennant. The link between Henry Tennant is this defendant. The only one of those three people that told the truth fully was Fred Barton. Fred Barton, former law enforcement, never been in trouble, no reason to not have these guns, no connection to Henry Tennant, no connection to anyone involved in this case, says they brought over a gun cabinet full of guns, both of them, and a week later came and picked it up. The Juan Biggerstaff thing, he seems like a nice kid, but it is illogical that a sworn law enforcement officer would write down the wrong serial number to a firearm that he embarrassingly had stolen out of his driveway. That's a bad thing if your guns go on the streets and you're a police officer. It's not good. And then you write down the very serial number of the firearm that you know is potentially involved in a homicide. The only explanation for doing that is hoping that you'll cover for your dad, and then when you get caught on it, you just say it's a Scrivener's error. I just copied it down wrong. That's the only explanation for it. I feel bad that he wanted to cover for his dad. You heard how his dad lied to him, lied right to his son's face. Oh yeah, I got the gun right here. I'll make it reappear in January. While he's searching for cabinets to store it where it can't be found, when he's searching for 10mm firearms on the day that Mario Fernandez goes to his house. The other interesting thing about the pawns is it shows that people sell their firearms. Again, a screaming piece of circumstantial evidence to you, which is why this poor Mr. Biggerstaff, who doesn't have any money, son works in law enforcement, why on earth would he not sell? Maybe because he thought he wasn't going to get convicted, but certainly after he got convicted, why on earth does he not sell this firearm to get a few $1,000s for him? Because he had them the whole time, because that's what Fred Barton told you. Yeah, they came and picked him right back up. And then if he has the 10mm and he gives it to Mario so that Henry Tennant can murder the victim, can't imagine a better link to a firearm than that one. So some of the top investments where Mario Fernandez could have invested his money. Vertiv Holdings is a global leader in critical digital infrastructure, providing power management, thermal management, liquid and air cooling, and IT management system for data centers, right? AI, we got to build all these data centers so we can do AI. And their stock market price has skyrocketed in the last several years. Advanced Micro Devices is an American multinational semiconductor company.
Hold on.
I agree, it's not inevitable.
Oh, no, stop. Let me see you at sidebar. All right, members of the jury, I'm going to ask that you recall, it was been a while ago that I gave you that instruction about closing arguments. What the attorneys say is not evidence, and you're not to consider it as such. However, you are to rely on your own recollection of the facts and the evidence as presented during the course of the trial. You may continue.
So as I mentioned, Advanced Micro Devices is a semiconductor company based in Santa Clara, California. Chips. Eli Lilly has done very, very well with GLP-1s and weight loss drugs that help many of us lose weight. Henry Tate. Unemployed, but marginally employed. Officially homeless. Never operated a business, whose business plan, the Finch showed you, whose business plan, you make your own decisions on that, I'm making an argument. It looked like it was written on one day. Lots of different dates. This $10,000 was not a Kickstarter. This was done with criminal acts. This argues that on September 4th, after Ken was arrested, there happens to be a truck driving by the defendant's rental property that he was about to sell. And that's evidence of a pallet company? There's no evidence of that. There's evidence of a truck driving by with some pallets in this truck. These are the arguments. Carlos phone. Defendant is not accurate. Not. He was scared. Tell his friend that he had invested in Kickstarter for thousands of dollars. $5,000, I don't care if you're a millionaire or not. $5,000 is a lot of money. He just forgets. Talk about the $5,000 Kickstarter good luck that he gives the 63-year-old convicted felon who, if you look at his bank records or credit card receipts, he's going to a liquor store every other day. It makes $300, $400. Discouraging because he's a murderer. That's not the kind of person you invest money in. Looks like it was all the same day as the business plan. Never mentions the $5,000. All this work that he did. Oh, there is no evidence. There is a memo line. This is what the memo line should say. The memo line should say. Memo lines for the landscaping, for the roofing, were done after Henry Tate was evicted from the property. How does it make sense to you whatsoever? I didn't just stay there and live rent-free and do work around the place. Doesn't make any sense whatsoever. A couple other points that this makes.
each individually away. Others than others. The state hasn't proven this charge. You must look at this evidence. The payments are just going to keep changing. The motive of this case, whether it be child custody or 75 plus hundreds and hundreds of thousands of dollars that this defendant received during the course of this marriage, corroborates the timing. Motive corroborates his guilty mind of deletions and wiping of the phone. Corroborates the link to the missing technology. Timing corroborates the link between this defendant and Henry Taylor, who is the shooter. The guilty mind corroborates the location. You get the point. All corroborate each other. You know what this is? This is what you refer to as a rock-solid case. Combination of circumstantial and direct evidence. Is it beyond all doubt? Beyond close. How many times, before we get to that, I want to make a couple more points. This may have been glossed over, but I want to make this really clear about the January 29th, 2022 trial. Remember how I talked about he must be the unluckiest man in the world? When the time that this crime took place, his phone wasn't bad luck. There's no piece of bad luck. Is that when Henry Taylor leaves, just minutes before, after his phone gets to that home address, Henry Taylor leaves for hours. And directly home, the children, assets, where he was eventually murdered, active. Within seconds to minutes, Mario Fernandez-Saldana's phone. You are the unluckiest man.
Mr. Mizrahi, your microphone. Is it on? Okay. Having a hard time hearing you.
Sure, it's on. Thank you. How many times did we hear, you can't, it's beyond all doubt, it's beyond all doubt, it's beyond all doubt, it's beyond all doubt, you must have no doubt. That's not the real world, folks. And they have to be reasonable doubts, logical, well-founded, sound judgment, not possibilities, not conjecture, not potentially or feasible. The umbrella in Florida in August example is a pretty good one. It's reasonable to believe it's going to rain outside in Florida in the summer. It's unreasonable to think we're not going to have court tomorrow because of that. It's possible, but it's not reasonable. Was Jared Bridegan murdered? Did the defendant want or intend for him to be murdered? Did he incite, assist, or otherwise cause the murder to happen? That is your question. It's right here.
Okay. Members of the jury, the attorneys, what they say is not your instruction on the law. You may proceed.
You decide whether that's wrong. Right there, same thing. Your doubts, if any, that are reasonable, meaning logical, well-founded doubts, meaning you don't have an abiding conviction of guilt, must go to the elements of the crimes charged. They're up here. And then remember, the death caused by the criminal act of Mr. Fernandez goes to the principal instruction. He doesn't have to pull the trigger. The lieutenant pulled the trigger. But if he has a conscious intent that the act be done, did the defendant want or have a conscious intent that the act be done, and help in some way by paying him, by showing him what date night was, by picking out the spot, by driving the truck away, all of these things overwhelmingly show you that he's a principal to first-degree murder. The defense made lots of arguments about how there's no direct evidence, right? Yet we spent hours of this trial looking at Home Depot buckets and people carrying things into a house. Remember all that? No one saw what happened in that house. The defendant's argument the entire time, and Detective Johns didn't want to say what was going on in the house because he wasn't there. He was trying not to give his verdict. He was trying not to give his opinion about what was happening in that house. He's just like, well, yeah, it appears like it's work going on in that house. The defendant, for hours and hours and hours on the cross-examination of Detective John, shows you the power of circumstantial evidence. No one saw any tile work being done. No one had any eyewitness inside of that house. But what we saw were circumstantial pieces of evidence that work was being done in the house. And that is exactly what we have here, is an incredible amount of circumstantial evidence that proves that the defendant had a conscious intent that the act be done and paid for it and helped plan it. Defense says there's no evidence that Henry Tenen got the gun, except for the fact that Henry Tenen used a 10 millimeter to kill the victim, except for that minor little detail. It's a relatively rare gun, and the defendant's good friend that he had sex with his wife the night before the killing cannot account for his 10 millimeter, even though he should have to account for it. The combination of all of these pieces of evidence should leave you no doubt. Now, this is a very important case. And defense counsel said to you repeatedly that this defendant stands accused of first-degree murder. He 100%, because he's charged with first-degree murder, he is afforded all the protections and guarantees afforded to him by the laws of our state. And it's important for him. It's important for Kirsten Bridegan, whose grief has so scarred her heart that she wears the scar as a proud badge of the love that she shared with her husband. It's to the kids. It's really important. AB, LB, little Bexley. Little Bexley that said, I saw a boo. Well, the police just helped my daddy. These truths about this case, about how this defendant turned Jared Bridegan into a medical examiner number,
are all important. Do you have that marriage of your heart and your mind, an abiding conviction of the guilt that the defendant who received hundreds of thousands of dollars during the marriage and whose wife got the custody that she so desired, that this defendant who knew the timing, who knew the location, who is the only link to the murderer, who has a direct link to a missing 12 millimeter, and has a conscious intent that this happened and benefited from it, and then consciously deleted the evidence of it. Is he held to account? Or does he just get to walk away because Henry Tennant has a Fifth Amendment right? Does he get to go home because he paid somebody else to do it? And then deleted everything he could after the fact. It's important. I submit to you it's easy. Because Lady Justice and circumstantial evidence can't have bad eyesight, they can't have a motive to lie. And it speaks the truth about who's involved in this case. That's why we have so many of you to decide this case, is because each and every one of you gets to contribute your abiding conviction, your thoughts about how this case should be defined. It is important. It's not that hard. This defendant, person with the motive, person who paid for it, the person who knew everything, the link to the killer, not the unluckiest man on the face of the earth. He's just guilty. Confident that when you marry your emotion, your heart with your logic and the law as the court instructs, you will find that truth. You will hold this defendant accountable. Thank you.
Thank you, Mr. and Ms. Riley. Members of the jury, the hour is late, and we do all from both sides appreciate your time and your willingness to push through. It is so important that you all understand where we're at, which is you've heard all the evidence, both sides have rested their case, you've now heard all of the closing arguments, and we are trusting you that each and every one of you will abide by this court's order, that you won't research anything, you won't look up anything, because the last piece that you need is the law. And so I intend to give you that law in the morning, okay? First thing, 9 a.m. So you all cannot talk about this case with each other. It's not time to deliberate. Instead, since the hour is late, then it's time to rest. And so that's what we're asking you to do. Come back refreshed. Follow the court's orders. Will all of you all agree to do that if you could answer out loud? Yes. All right. See you in the morning. All right, please let the record reflect that the jury's left the courtroom. Anything we need to take up? I'm going to email the copy of the instructions. I'm going to do another read of them, if you all would do the same. So if you catch any typos that I didn't catch during the charge conference, if you will let me know at about 8:30ish, so I can make those changes and then get them out to you.
In doing some quick research, Your Honor, I think the court has to discharge the alternates, and they cannot sit at a later time.
Okay, thank you. I thought that. I think you can do it in death penalty cases because it's a different issue, but I appreciate the research. So the question to me right now is, let's say everyone can be seated. I'm sorry, I forgot, I got caught up. So the question right now to me is that, let's say that all 16 come. Do you want them all 16 to listen to the instructions, or I can bring out the 12, excuse the 4 alternates, just to make sure that we get them all down here?
Yeah, I mean, it's 6 for one, half dozen the other. I think they may want to listen to the instructions. You can sit the 12 in the back, start seeing the evidence back, and then do your long recitation about how thankful we are for the 4's time, as opposed to just sending them home before we do all that.
I'll just do it the normal way. It's fine. So they don't feel like they totally wasted their time. Well, no, they get us to finality. There was a lot of work and a lot of moving parts. So the other thing, I think, so like I said, I think the instructions are about 30, I don't know, about 30 some pages. If this is to the gallery, because of the reading, because it's technical, I don't allow in and out. So if you all don't want to come for the morning session, that's all that's going to happen. But once I start reading, I lock the doors. And so there is no ability to go in and out. So you have to make a choice, okay? So obviously it'll be live streamed, so you can watch it that way and you don't have to be trapped in the courtroom, but I can't have the jurors, and it also distracts me from the reading. So just to let you all know so you can make your choices overnight, okay? All right, and I want to thank each side for your time and your attentiveness to these proceedings. Your professionalism was appreciated by this court and the parties. The court's adjourned.